Showtime. Get your popcorn ready. Oh, you ready?
Well, no. I'm gonna.
Oh,
I can drop down. I was just gonna get him as he comes up, but I can drop straight down.
No, you ready? You were here first.
I'm gonna. No. I can squeeze out. I was gonna get like one frame.
Okay.
Okay, I'm pulling. I'm going straight down.
Okay.
My back won't allow me to just stay crouched like that. You know.
I feel your pain.
I can use that bag.
No, you good. You good. See, like, oh, this is just for to help the red folks, man. Here we go.
Sunglasses.
That's the problem.
Here we go.
Here we go. Stop rolling. Get this shit on my damn phone, too. No, we don't care about the weather. Like I said, that's it. Easy peasy. Remember the first weeks, everybody used to go like, how are you feeling today?
That was me.
That was me?
Yeah.
Murdaugh's police interview was played in that Walterboro courtroom yesterday, and at the end of it all, the defendant denied killing his wife and son on that June evening in 2021. Now, we know that Maggie and Paul were found shot to death on their family property, and the defendant and former South Carolina attorney was the one to call 911, but he denies being at the dog kennels where the duo was found at the time of their deaths. However, his timeline didn't always add up. His alibi might not have always added up. To give you an idea of that, let's watch some of his police interview from yesterday to see for ourselves.
Is your timeline. You said you probably went to the office 8:30, 9 o'clock, 10 o'clock. You left early around 5 or 5:30. And there's been some other timelines or times that we've talked about and you can't quite remember what the times are or what time of day it was. When the dispatcher asked you when was the last time you saw Maggie or talked to Maggie, you said an hour and a half, 2 hours ago. To me, that's, a set, without thinking about it, you rattled off that time. We're sitting here trying to figure out a timeline.
Your question was, you told the dispatcher hour, 2 hours ago?
Hour and a half to 2 hours.
Hour and a half, 2 hours. What time was the 911 call?
10:06 p.m.
Hour and a half, 2 hours prior to that.
Yes, sir.
Go ahead. Thank you.
And you're having trouble coming up with a specific time.
Oh, yeah, that's fair. Tell me again what I said to the dispatcher.
You said an hour and a half ago, probably 2 hours.
And what time was that?
And that was when you were on the phone, and the 911 call was made at 10:06. So given 2 hours back, that would have been 8.
I think that's probably about. I think that's probably about right. And so, what do you believe? I'm giving you an inconsistent answer?
No, I'm just trying to wrap my mind around it when I'm asking you what time you went to the office that day, what time you got home.
Can I ask you a question?
Yes.
At this point in the investigation, did you have the video back from Paul's phone showing the dog at the kennels?
No, sir, I had not.
You're saying 5 to 5:30. I've got the card readout from the law firm, and it shows you going in at 5:30.
Going in the door?
Yes, sir. And Randy says when he left about 6 o'clock, you were still there. So the times aren't matching up. And I'm just trying to get an understanding of why.
I believe I left, so because that's not the first time I was at my office that day.
There were several readings, but your card wouldn't work. Somebody actually had to let you in.
Okay.
But I've got your card opening the door at the law firm at 5:30. And then Randy saying when he left at 6, you were still there. I'm trying to understand.
I left the office earlier than I normally do.
What's your normal time to leave?
I mean, it's not unusual for me to be there till dark. I try to get home when Maggie's home, before dark.
She don't like staying out there by herself in the dark.
That's right. So, if it was 5:30 or 6, I don't think I was still there at 6 o'clock.
Okay.
But, if I was, it wasn't long after that.
Okay.
So, I believe that I went straight home. So, my car, have y'all been able to get Chevrolet to download my?
We're still working on that.
Okay.
It's a long process.
Well, I mean, I got home early enough for Paul and I to ride the property for a substantial length of time. More than an hour. I thought probably a couple of hours that we were together, but somewhere.
You took her down the river.
We rode down all the roads. I believe that we rode all over. We rode all over.
All right, I'm here with psychologist Dr. John Delatorre. Dr. John, it's great to see you. So this is a few months after the murders took place, and still, Murdaugh doesn't have a clear timeline. He would even say that he thought he was at his mom's house 45 minutes to an hour, which is completely in contrast to what Shelley Smith, the caretaker of Alex's mom, said, and what the car data seems to suggest about, his car going in park mode and out of park mode. Maybe it was only 21 minutes. Is that unusual that somebody in that state, even a few months after that, might get these details wrong? Or is it, somebody covering it up?
You know what? I don't know that it's unusual. First of all, when I'm watching this video, I don't see him wearing a watch. And in the other video that was taken the night of, when he's in the police car and he's in the white shirt and everything like that, I don't see him wearing a watch in that one either. So I'm not entirely convinced that Alex Murdaugh really keeps time all that well. So I wouldn't be surprised if he doesn't know how long an hour is, or he's not watching the clock, because I don't think time really matters to him the way that it would matter to someone who wears a watch regularly, that they can check the time. It's certainly possible that someone would absolutely, assume that he's attempting to cover up something like that, his involvement in the crime. But I don't know. I'm not entirely convinced, because it's also possible that someone in a level of distress, as someone like him would be, it's also possible that they still wouldn't remember time at all anyway.
That's an interesting observation. And I tell you what, I think the defense may jump on that in a closing argument and say, what have you heard about Alex Murdaugh? He's disorganized, he's all over the place, he needs assistance because, you know, his paralegal needs to set him straight, he doesn't know what's going on. So maybe that's a way that you can't really rely on the things that he said in terms of times and timeline. Maybe something they'll go with. Now, I'll tell you what, there was another key moment from the police interview that I want to discuss, which is when Murdaugh was asked if he was talking to anyone else during his 911 phone call on the night of the murders. Let's take a look.
When we were talking, he had asked me that, so, I mean, he had told me that he thought I was up there.
Did that surprise you?
Yes, sir.
So when you returned back to the kennels, when you returned home from your mom's, where were the dogs?
They were like they were when I didn't put dogs up.
Okay.
So
they weren't running loose?
However they were.
Okay. At one point in the 911 call, you say here, like you're talking to somebody else or something else.
I say here?
Here, yes, sir. So the dispatcher is asking you if they're breathing, and you said no. And she asked did you see anyone else in the area, and you said no. She asked about guns near them, and you said no. And then you kind of stutter and start moving around, and you said here.
I don't have any memory of saying that. I guess I'd have to listen to it you know, but I don't recall a dog being out. I'm just certain that there was not a dog out. You know, I mean, there's other things people have told me about that 911 call that I don't remember. I don't know here. Like I was calling a dog.
Calling a dog, talking to somebody else. I don't know. That's what I'm asking.
Yes, sir. And I mean, that obviously was nobody else out there.
Okay.
And I'm certain that there was not a dog loose. But I don't remember saying anything about Buster would know. Something about threats. I was asked about that later. If I had information about, or that Buster had information about threats that I had said he would know.
Okay, so that's an interesting point there, Doctor, right? I mean, maybe he was in a state where he doesn't remember what he was saying, right? He doesn't really, can't accept responsibility for the things that he was saying. But it is weird that, I will say he said that, but also, we've never heard anything about investigators really finding out who that person could have been. And isn't that a kind of a deficit in the investigation, which we've heard from the defense, is that they really missed opportunities to look for evidence or look for other suspects or look into this a little bit more. I'm curious what you may take away from that.
I think a little bit of that, because number one, when a wife and a child are dead, police are automatically going to assume that it's the husband. It's sort of a heuristic, right? Just a cognitive bias when it comes to investigation. So I'm not surprised that, Alex Murdaugh ended up being the focus. But the next thing is that 2 different guns were used, right? 2 different guns typically means 2 different shooters. And it's another one of those cognitive bias, heuristic type things that it's certainly possible that there should have been more emphasis played on the presence of another person rather than solely focused on Alex Murdaugh committing this crime.
And overall, when you look at his demeanor in that interview, he's accompanied by his lawyer, who I believe who is suspended for allegedly helping him with his financial crimes. But he's sitting there with his lawyer. He's answering these questions. What did you make overall about the way that he approached these questions? I mean, we started the show off by him responding to, did you kill your wife? Did you kill your son? Anything that you took away from it?
You know what? To me, it's actually about consistency. There's going to be a lot of online sleuths and a lot of body language and linguistic experts coming in saying that he's sitting in a defensive posture. But the truth is that he's consistently sitting with his arms crossed. He's consistently sitting in that way. He's consistently answering questions with another question. Typically some people think that that's a way of sort of providing distance and giving you time to answer questions. To me, he seems pretty consistent across time and across interactions with other people, that it's safe for me to assume that he's probably very emotionally labile, swings, vacillates from one motion to the next. He's not quite sure of himself. He's in distress. He's nervous. He's anxious. There's a lot of stuff going on that's not necessarily related to trying to cover up a crime, but it could be.
All right, well, I'll tell you, we'll talk more about it. We do have to take a quick break, but stay with us because we do have a very special guest who's coming on in our next segment to talk about the XXX Tentacion trial. Stay with us.
Drake, but that beef was, pretty one-sided, right? X felt that Drake had basically ripped him off in a song, had sort of taken his style for a song. Drake at the time responded and said, yeah, you know what? I hear how people could hear that, but that's not what happened. And X just went on a rampage, angry tweet after angry tweet. And at one point, his Twitter account said, look, if anybody kills me, it's Drake. And then he immediately apologized and said, look, I was hacked. That wasn't me. So, my best guess, obviously, I don't know, but my best guess is what that was, is he got emotional, he got angry, tweeted something, and then said, well, look, maybe this was ill-considered. Maybe I want to work with Drake at some point in the future. Let me try to, walk this back. They mentioned Migos also in that clip, and X had a beef with Migos as well that actually kind of grew out of the Drake thing. One of the members of Migos defended Drake and said, X, you shouldn't be so upset. This guy didn't steal from you, grow up. And that led to a whole bunch of back and forths about, related and tangential issues that culminated in X claimed that all three members of Migos jumped him back in 2017. The members of Migos never commented on that. We never got their side of the story. But, he was an emotional, volatile guy, and he had a lot of, short-lived and somewhat one-sided disagreements with people in the rap world. I don't see any of that having anything to do with this case.
Yeah.
One more thing, actually, Tekashi 6ix9ine, who I wrote the book on, he's actually on Dedrick Williams' witness list as well. Good luck finding him. He's somewhat reclusive and hard to find these days. But he and X were friends. I know this. I've talked to X's manager about their relationship while I was writing the book. But that's it. They were, they were friends. They talked frequently. They met in person rarely, if ever. Mostly it was over the phone. And, Tekashi was obviously very upset when X died, but again, nothing to do with this actual case and the actual circumstances of X's death. So I think when you say it's reaching, I agree. I don't see what Shaggy's son, who is also on the witness list, could have to do with any of this.
And let's just be clear. So from my opinion, I think the case against these three men is very strong. Okay, you want to even put aside Robert Allen, who is the cooperating witness that has testified against them. Some people would say he's a snitch. You can't believe him. He's not credible. That's what the defense has said. I don't know. It seems pretty legit what he's saying. But just the other testimony we just mentioned, that the ex-girlfriend of Dedrick Williams testified and told her that he was there when X was robbed and murdered. Tony Robinson, another one of Williams' friends, testified that she rented the Dodge Journey that was used during the crime. She said Williams apologized to her for getting her involved in the situation. You have surveillance tape. You have cell phone data. You have them allegedly flaunting the money on social media. Now, the question I have for you is, this I think is a good thing, because is it not important to put this to bed that this was a rap beef gone bad? Because, I think there's a danger out there that not every feud or beef is going to result in actual violence. And I think it's important to put this to bed because we don't want to see this happen in the future. So how important are convictions here against these men in terms of, the hip hop community moving forward? And maybe it's a good thing for Drake to testify and say, be deposed and say, I had nothing to do with this and I would never have anything to do with this.
Well, look, that's a good question. I don't want to say that, anyone being, convicted and serving time behind bars is a good thing. That's always a horrific circumstance, for them and their families. But I will say, I think it's important to establish as best as possible that this was not a conspiracy, right? This was not, it could be dangerous, I think, for established artists to have their names sort of caught up with this in a public way, right? For the people around them, when by all indications, that's not the case, right? Drake or the surviving members of Migos or Ski Mask the Slump God or any of the other people on this witness list, it doesn't appear that they had anything at all to do with this. And, you know, we definitely don't want the impression that this was some kind of, you know, rap beef turned violent, right? We want to try to move past that, if at all possible, and show that this was, you know, this was not the case here. We don't want fans on either side thinking that was the case, or people close to artists on either side of this and attempting to, like, at the worst case scenario, somehow take matters into their own hands. We definitely don't want that. So that the more we can get the message out there that, like, look, it really appears this was somewhat of a Hail Mary from, you know, Dedrick Williams' side, and the artist named had nothing to do with this, I would say the better.
Yeah. All right. Well, Sean Sotaro, thank you for coming on, breaking this down with me. We'll see where this case goes, and we'll see what Drake ends up saying in that deposition testimony as well. Thank you so much, sir. Appreciate it.
Thank you so much, Jesse. Take care.
Take care. All right, we're going to hit a quick break. When we come back, we're going to see if we can jump live into the Alex Murdaugh trial. That's going to be our main focus, as the prosecution will continue their case. And there's a lot more to get into about what that case might look like. Stay with us.
You may now be seated.
Good morning. Mr. Griffin?
Yes, thank you, Your Honor. Before we bring the jury in, I would like to put on the record the basis of my objection to the redirect of Agent Owens regarding the roadside shooting. Understanding the court's ruling was that I opened the door to that based on my cross-examination. This is the first case I've had the benefit of being able to go back to YouTube and see exactly what was asked on direct and what was asked on cross. I have typed it out. Your Honor, it's very brief. On direct examination, Mr. Meathers asked Agent Owens, question, at some point in 2021 in the fall, did a financial investigation begin at Alex Murdaugh? His answer was yes, sir. Question, would it be fair to say that the investigations overlap with each other? Answer, it did. Question, would it be fair to say that the two investigations fed off each other? The answer is yes, they did. From the information I was learning from the financial investigation, it gave me additional people to consider and to look at Mr. Murdaugh as a reason why or why not. The next question, were the individuals in the finance investigation that you also interviewed in this investigation? He said, yes, I did. And then the question, did you learn information from the grand jury testimony? He says, yes, I did. Then the question, did you follow up on that information? He said, yes, I did. That was elicited on direct examination. My cross-examination, I began on this topic. You also testified that in the fall of 2021, there started up a financial investigation. Yes. You said it fed off and overlapped with the murder investigation. Yes. You developed information that Alex was stealing money to support a drug addiction. Yes, that was reported. Question, you learned that Alex was paying up to $50,000 a week to buy drugs. Yes, that is what was reported. You learned that Alex was buying from Curtis Eddie Smith. Yes. You learned that Eddie was buying from the Sand Hill drug gang. Yes. You learned that Eddie owed the Sand Hill drug gang a lot of money. Yes, but they were not worried about getting their money because it was Murdaugh. Question, did you ever conduct a cell phone analysis of the Sand Hill drug dealer's cell phones to see if they were at Moselle on June the 8th? Answer, no, because in my experience, they use burner phones. Question, you never got DNA from them to cross-check against the unknown DNA on Maggie's fingernails. Answer, no. Question, you never put them in the investigative circle, did you? Answer, my understanding is that investigation is continuing and is being conducted by the DEA. And from that, Your Honor, there were no questions related to the roadside shooting, no questions related to whether Alex lied to the police in connection with the roadside shooting. It was all about him stealing money from clients to support his drug addiction, which is evidence that was already in the case. Your Honor, I sent the court via email earlier today the case of State v. Hayward, 426 SC 630, which is a 2019 case where the Supreme Court reversed Judge Young on an opening the door theory.
The same Supreme Court reversed the Court of Appeals.
Excuse me, the Supreme Court reversed the Court of... Sure.
Yes.
The defendant was convicted. It went... The Supreme Court, the Court of Appeals affirmed, and the Supreme Court reversed the Court of Appeals. That's right. Yes. And vacated the conviction based upon the introduction of propensity evidence, 404B, 404 evidence on the theory of opening the door. And in that opinion, Justice Hearn is very specific to state that the courts have to be very careful and very wary of thinly veiled attempts to show propensity by way of the open door doctrine, and that testimony and response must be proportional and confined to the topics to which counsel had opened the door. And again, I go back, we did not open the door to any roadside shooting, any insurance fraud, anything with regard to Alex lying to the police. And so that was the basis. I just objected, so I want to put that in the record. Today, they intend to present a full panoply of evidence on the roadside shooting. And, Your Honor, we would oppose that.
What do you mean a full panoply?
Well, they've asked to, that they're going to, my understanding is they're putting up Agent Kelly to talk about his investigation of the roadside shooting. We got a request this morning for them to play the hospital videotape of Alex in the Savannah Hospital, which is over an hour, where he's being interviewed by SLED agents, and he's meeting with a sketch artist to draw up a sketch of the roadside shooter, and that they plan to introduce that evidence. They plan to introduce, as we understand it, follow-up evidence of when Alec gets to detox in Atlanta, when he calls back with Mr. Harpootlian and I, and he gives a full statement about the roadside shooting and about how he had lied to them previously, how he was sorry.
Is that the same video or
Two separate. I mean, the second is just an audio tape. But Your Honor, I just go back to State v. Hayward, where the court says testimony in response must be proportional and confined to the topics which counsel has opened the door. And so they intend to spend 3 hours of testimony here today, and it's not proportional, and it's not related to the topic that for which the court, I believe, should find that. I don't think I opened any door because I think the evidence was already in the case.
All right.
And it was in response to direct. It wasn't something I brought up.
May it please court, Your Honor. To go back, obviously we had this issue and we addressed it yesterday morning.
This time we're dealing with the issue of the court's, the exception or statement for the record that Mr. Griffin wanted to make concerning the court's ruling yesterday. We're not dealing with any anticipated testimony today at this time. I'm not ruling based on what, well, I've already ruled, but I'm entertaining these comments for the record regarding yesterday's ruling. So go ahead.
I think, Your Honor, if you listen, obviously, to the excerpts that Mr. Griffin just read, and you put that in the context of everything that had developed, starting with Marion Proctor, that the door is more than opened, and the State's intent in that regard is to fully respond to and flesh out the very examination.
The State's intent in that regard, we're talking about yesterday's ruling, so we can close the door on that. Do you have anything else to say about the court's ruling yesterday?
No, other than the examination, the redirect examination clearly was in response to and appropriate opening the door after that examination, and that's I think that Your Honor's ruling was appropriate in that regard, and I think that again that has opened the door to exploration of those issues.
Concerning the court's ruling yesterday, and also State v. Hayward, Mr. Owens, in questioning Mr. Griffin and cross-examining investigator Owen, got into this circle of interest that Alex is in the circle, then cross-examined the witness regarding, did you consider Eddie Smith to be in the circle? Well, did you consider some unknown gang members, whoever they might be, to be in this circle? Did you know that Alex was spending $50,000 per week supporting a drug habit, presumably through Eddie Smith, and that he owed money or he was indebted? So Mr. Griffin introduced the relationship between the defendant and Eddie Smith. The court conducted a pretrial, a hearing outside the presence of the jury, addressed the issue, made it clear that the roadside shooting was a bridge too far. Then the defense decided to build a road over that bridge, decided to just go right there as if they could dance through fire without getting burned, scarred, or anything. The door was open. This is not the same as the situation in State v. Hayward, where a co-defendant's, a cooperating co-defendant is being questioned about unrelated matters, totally unrelated to the case, and the Supreme Court felt Judge presiding judge went too far in allowing evidence not proportional to what was open and which he already ruled should not be introduced. I find that what this court allowed on yesterday was proportional because it was in relation to evidence elicited not by the state but by the defendant, and the state is entitled to explore this relationship between the defendant and Eddie Smith. And then we'll have further discussions at some point regarding this limitation of just randomly throwing out names of people or suspicions and speculations regarding on the issue of third-party guilt. But to the extent that the defense sought to introduce the relationship between the defendant and Eddie Smith, and then to seek to infer that Eddie Smith might have been or should be a suspect in the murder, then to prohibit the state from saying, well, if Eddie Smith should be a suspect, and Mr. Murdaugh, who at the outset engaged in his form of problem solving by telling the state what this case was all about and the murder was all about, meaning the boat crash, then later engaging what appears to be a conspiracy along with the person that the defense seeks to insinuate to be or should have been a suspect. The state is entitled to explore that. The extent to which the state should be entitled to explore that, that's open for discussion today, but not based on the court's ruling yesterday. The court in the Hayward case did indicate that the court should be careful as the nature and extent to which these other matters should be allowed to go into, and I intend to do that. But the record is protected to the extent that Mr. Griffin went through YouTube and citing what his version of what he said yesterday, excluding the portion that's more relevant and important to the court's ruling. But the record speaks for itself on all of that, and the court's ruling stands as it was given on yesterday.
Your Honor, obviously we would accept your ruling, but
okay, now we have a ruling, we have for the record, now we have an exception to the ruling, and another comment. Go ahead.
So what I'd like to discuss now is what the state will be allowed to submit in support of this position. Now, clearly there is a taped statement by Mr. Murdaugh from a detox facility in Atlanta, which was initiated by Mr. Griffin and I. So certainly there's no objection to that. I mean, there could be, but no real objection to that. Secondly,
no objection to the statement.
Well, no objection to the statement pursuant to and conditioned by our previous objection.
Yes, sir.
To. I want to make the record clear. We're objecting to any of this.
No, I understand. You've objected to everything throughout the trial. I understand.
Well, there's a couple of things we missed. We'd like to rehear some of those, but Your Honor, but then, and again, Mr. Waters and I discussed last night after your ruling, a way perhaps, I know this is shocking, to expedite this process. For instance, there is a statement made to EMS, the statement they're wanting to get to, which is, drive-by shooting, all those sorts of things, which he later on admitted in the telephone statement that was taken, was not true. We get that. He didn't need to be Mirandized on the side of the road by EMS. However, there are 2 recorded statements taken at the Savannah Hospital by Agent Kelly after he is, and we've got the medical records here if you want to look at them, but clearly has suffered a wound to his head, a fractured skull.
Always suspect of that word clearly and clear. Everything is in controversy.
I don't think this is in controversy.
Tell me what's clear again.
Bullet wound to the head, fractured skull, brain bleed. That's not contested. The medical records indicate medication that he was under while he was at the hospital. We would think there'd have to be a Jackson v. Deno hearing on those interviews, just under the issue of, was he competent, a competency hearing. To do that, we would have to bring the physicians and the treating physicians from Savannah here to testify. And again, and I think Mr. Waters will concede, it was at 6, I emailed him and said, all good, what we talked about yesterday, and he came back a little while later and indicated that he'd like to put those in. Mr. Griffin and I, over a cup of coffee, said there's competency issues, and we informed him of that this morning. Nobody's playing gotcha here. So we don't believe those should come in without Your Honor being able to rule that he was competent, hear from the doctors, and I think we may have worked out a compromise on that. I just want to confirm that for the record. But what we have worked out is this. The statement that he would not have to bring the EMS people. There's a statement that they made. Agent Kelly can publish that statement without having them need to be here. There was a knife recovered at the scene. They don't have to Kelly can identify that. There was a, what else?
Your Honor, so what we talked about yesterday, just to kind of wrap this up, was again, my intent to do this in a very expedited and focused fashion, not get into every detail or litigate that entire matter. And I suggested to the defense, and they agreed yesterday, that I could have Agent Kelly, who's the lead investigator on the side of the road, come up and essentially, in a very abbreviated fashion, walk through the case without the need to call the 911 operator or the ambulance driver or the roadside deputy or the DNA analyst or the person who found the knife, and so forth and so on. And I plan to do that, again, in a very expedited fashion. I'm not talking about anything 3 hours or the like. We also discussed this morning that I do need to be able to relate to the jury, though, the defendant's claim, which I have argued to you is particularly relevant, that he was attacked by an unknown assailant on the side of the road, when in fact he knew exactly who it was. He had actually arranged for it. And so our discussion that I thought we had an agreement on, I think we still do, is that Agent Kelly, there was an interview in the hospital on 9/4 and one on 9/6, and that I would have Agent Kelly just summarize and reiterate the defendant's claim about what happened on the side of the road, as well as the fact that he worked with a sketch artist, and show that sketch picture, and then just move through it like that. And then we will play for the jury, which I think they just said they don't object to, or no additional objection, the telephone interview in which he ultimately admitted to law enforcement in the presence of his attorneys that it had been a lie.
Yes, sir.
That's the deal. But I feel a little more comfortable if we could just have, and I'm not trying to delay court, but this recording is 47 minutes long, 41, whatever, 40 plus. So many recordings, I'm confusing them, but 41 minutes long. Could we take, if you could just, and by the way, I've agreed to allow him to lead unless I see something reprehensible going on, which for me is difficult to restrain myself from objecting, which would expedite it even more. But at 6:30 this morning, we were not in a position to discuss what Agent Kelly's, the sort of acceptable what happened at the hospital thing. I'd just like 5 or 10 minutes just to review that with him, and then I think we're on go. Although, just for the record, we're objecting to any of this. I don't want this kumbaya moment to be viewed as any waiver of our objections.
The only thing I just want to put on the record, again, is that in discussions with the defense counsel, moving expeditiously with Agent Kelly and without raising hearsay and that sort of thing and making us go through our paces has been a strategic decision that the defense has made.
Pursuant to the, I just want to make it clear, I hate to sound like a broken record, but I don't want any appellate court ever to look at this and say, well, you agreed to it. We're agreeing to this process pursuant to Your Honor's ruling this morning.
I have not reviewed any of the evidence that you all are now referencing. So to the extent that you all have an agreement on moving forward with this evidence, considering the objections, I'm fine with taking 5-10 minutes if that will expedite things. I deal with what you all disagree on, not what you agree on.
Yes, sir, Your Honor.
We're going, if Your Honor, when you take this recess, we're going to take myself, Mr. Griffin, and maybe even Mr. Barber to, he seems busy, to a room where we can have some peace and quiet and have a discussion without being interrupted every 2 minutes.
All right. We'll be in recess then for hopefully about 10 minutes.
All right, remain in order.
Didn't expect it. I'm sure when they went into this, they didn't think that they were going to hear about financial crimes and now that about an alleged suicide and comments that were made by the defendant in a hospital. But that's what's going to happen. We'll take a quick break. We'll be right back after this. Welcome back to Law and Crime, everybody, and our coverage of Week 4 of South Carolina versus Alex Murdaugh. I'm Jesse Weber, and thanks for joining us. So we were just listening to arguments all outside the presence of the jury on the question of the roadside shooting issue again. Remember, the allegation being that Alex Murdaugh hired Eddie Smith to shoot him in a way for the insurance proceeds to go to his surviving son, Buster. Wild detour in this case, but, you know, listen, the prosecution was of the opinion this just shows his common scheme of showing what he was up to as a way to distract from his alleged financial crimes, make himself the victim. Defense initially won a win yesterday. The judge wasn't going to allow it in, but after more arguments, Judge Newman decided to stand by his ruling that the evidence will be admitted into the trial. Let's take a quick look at that.
But to the extent that the defense sought to introduce the relationship between the defendant and Eddie Smith, and then to seek to infer that Eddie Smith might have been or should be a suspect in the murder, then to prohibit the state from saying, well, if he's if Eddie Smith should be a suspect, and Mr. Murdaugh, who at the outset engaged in his form of problem solving by telling the state what this case was all about and the murder was all about, meaning the boat crash, then later engaging what appears to be a conspiracy along with the person that the defense seeks to insinuate to be or should have been a suspect, the state is entitled to explore that. The extent to which the state should be entitled to explore that, you know, that's open for discussion today, but not based on the court's ruling yesterday. The court in the Hayward case did indicate that the court should be careful as the nature and extent to which these other matters should be allowed to go into, and I intend to do that. But the record is protected to the extent that Mr. Griffin went through YouTube and citing what his version of what he said yesterday, excluding the portion that's more relevant and important to the court's ruling. But the record speaks for itself on all of that, and the court's ruling stands as it was given on yesterday.
Okay, time to break it down. Joined by my special guest, once again, psychologist Dr. John Delatorre, but also joining us, Deputy Public Defender from LA County, Philip Dubé, who's appearing in his personal capacity. Philip, welcome to the conversation. I think I know where you're going to stand on this, but hey, I've been shocked before. What do you think of the judge allowing this in?
I hate to say it, but I think he was correct.
Oh, wow. I was wrong.
I
I thought you were going to be totally opposite that.
No, listen, from a defense standpoint, I would hope that he would have, reversed himself yet again, but unfortunately, he did not, and I think it was legally correct. Defenses throughout a criminal trial are quite fluid, Jesse, meaning that you never know how things are going to flow, how the evidence is going to unfold, and sometimes defense counsel makes tactical moves mid-trial that don't quite align with what was promised to the jury or maybe what was discussed pre-trial. And now defense counsel changed courses. Well, in response to that, the prosecution is also allowed to sort of realign their route to undermine whatever those new fluid defenses are, and to shut them down when defense counsel initially moved to exclude it and then introduced a line of questioning to kind of backdoor in that excluded evidence. It would be fundamentally unfair to the prosecution not to allow it in. It's a very, very damaging piece of evidence because in the end, Cousin Eddie was arrested for conspiracy to kill Alex Murdaugh. And this could have a tremendous blowback effect on the defense. If I were defense counsel right now, I would urge the court to reverse itself yet again on the grounds that counsel was ineffective And you don't want a retrial, you don't want a reversal merely because defense counsel provided ineffective assistance of counsel, which is a constitutional right.
Wow, I can't say I see that happening. I get your argument. Doctor, I'll move to you. What do you think the jury's thinking? Because let me just take a step back. Let's put the jury to the side. What are you thinking about Alex Murdaugh, right? So we learned some new details. We learned about allegedly paying $50,000 to Eddie Smith, of this drug addiction. Now it adds up about why he might have been needing to steal money. I mean, again, these are all allegations at this point. But the idea here is, what do you think the jury is thinking about Alex Murdaugh when they hear all about this and they hear about this whole life that he was living, almost a double life? At the end of the testimony about all the roadside shooting, what do you think their impression of him is going to be?
It's one of those curious things because for me, it boils down to one word, which is reactionary. And I think that Alex Murdaugh is a very reactionary person. He doesn't seem to be this kind of sophisticated drug dealer, Walter White kind of individual. Like, it doesn't seem to be this way. He seems to move through life because of his last name, because of the power and the legacy of that last name, the influence that last name has had. It certainly seems like he's not really putting pieces together because he's the smartest guy in the room. He's simply responding to what's going on around him. And I think that this kind of evidence, while shows completion from beginning with the financial crimes to the end where, he's trying to leave this money on an alleged suicide, I think it fits a narrative and completes a narrative for the jury, but I think it just leads to more sort of misunderstanding. And I think the jury's going to be left with, who is Alex Murdaugh, and is he capable of doing all of these kinds of things all by himself?
But flipping it for a second here, Philip, I have to tell you, I think the defense yesterday did a tremendous job of cross-examining lead investigator David Owens. So they have this tape that's played of his interview with Alex Murdaugh. Alex Murdaugh says some questionable things. If you believe Alex Murdaugh did this, there were things in there that I think that could add to that. But where they really, I thought, did a terrific job was showing deficits in the investigation, how they didn't look further at certain things, how apparently Mr. Owen provided incorrect information to the grand jury about blood being on the white shirt. That, I feel, has to have a big impact on the jury, no?
Of course it does. But correct me if I'm wrong, Jesse. If I recall the evidence correctly, at the time of the grand jury proceeding, all they had at that point by way of the serological evidence was a presumptive positive test for hemoglobin, meaning it was not a confirmatory test. What they should have done before just sort of willy-nilly introducing that as definitive evidence to the jury is they should have done final testing on it. Otherwise, it leaves the record murky, A, as to whether or not it was a confirmatory finding, and B, whether or not the cop lied to the grand jury. So they should have cleaned that up a little bit on redirect.
Yeah, I'm trying to confirm that too, because I remember the information that he gave. I wouldn't say lie. I mean, I think it was just he didn't have the information. And why didn't he have the information? And that comes into a question here too, Doctor. Was there tunnel vision a little bit? Was there, looking at it, because I'm torn. There are parts of this investigation where I think Alex Murdaugh was given a little bit more leeway than another person in his position. I mean, again, I'm still stretched how his housekeeper was able to come into the house and tidy things up after a killing. Okay, put that to the side. But even so, do you think that police kind of narrowed it down too quickly to focus on Alex Murdaugh and maybe not alternative theories? Maybe because there is a bias. I mean, they say, look, you're the one who found the bodies. You're the one who called 911. This happened on your property. Of course they have to look at him. What do you think?
Yeah, absolutely. But I think we need to be careful when we say the word bias, because when I'm going to say it, what I think you're describing is what we call a cognitive bias, which is this idea that when things get too difficult, we rely on sort of our past experiences and our past knowledge to kind of help us sort of navigate the decision-making process. That it's not exactly that they were solely focused on Alex Murdaugh because they don't like Alex Murdaugh. They were focused on it because previous cases has demonstrated to investigators that when you find a wife and child dead in a place, it's usually the husband that did it.
That is true. That is 100% true. And Philip, I go back to you on this. I think we can get one more question before we have to hit our break. Tell me, do you think that this is distracting the jury at all? Like, for example, if this case was only about the shooting, if it was about the kennel video, if it was about the police interrogations, if it was about or interviews, if it was about the forensics, and you didn't have financial evidence, if you didn't have the drug issues, if you didn't have the roadside shooting, how strong would the prosecution's case be?
I think it would be very weak. Because again, even though motive is not an element of murder, juries need to have a darn good reason why they should convict somebody of murdering their spouse and child if there's no good reason for doing it. And clearly, you know, the age-old reason for homicide is typically money-related, rage-related, or vengeance-related. And here they have ample evidence of financial dire straits in the Murdaugh household. Remember, Maggie was leaving him. She moved into the Edisto Beach home. She got her own forensic accountant to try to locate all the assets. She was getting ready to wipe them out, or at least
that
get
hasn't
her
been,
fair
but
share.
that hasn't been, at least in this trial, from what the jury's hearing, that hasn't really been alleged. There's been, like, you know, about her wedding ring being on the floor. There might have been a few issues in the marriage. They haven't fully explored that. Look, I don't know what was going on behind the scenes. I'm just looking at what the jury's being presented with. I'll tell you what, we are going to hit a break. When we come back, we're going to see what's happening in court. We still have a lot more to get to, so stay with us here on Law and Crime. A lot more.
All right, good morning. Day number 19. State's case, cross-examination, Mr. Barber.
No questions, Chairman.
All right, thank you, sir.
Thank you.
We'll call your next witness.
Thank you, Your Honor. We call Dr. Kenny Kinsey.
Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
All right. If you would, please, sir, be seated in that witness chair over there. State your full name for the record, spell your last name, and try to talk in the mic as good as you can.
Dr. Kinsey, how you doing today?
Kenneth Lee Kinsey, Kinsey. I'm fine, sir.
Good. Dr. Kinsey, let's talk a little bit about your career and who you are. First of all, just kind of introduce yourself to the jury a little bit and tell them where you grew up and where you went to school, and then we'll start to talk about your law enforcement career and your expert qualifications.
Yes, sir, happily. I grew up a long way from here in a little county called Orangeburg. I was there about 54 years, my whole life. Went away for college a couple times and came back. And I'm currently the Chief Deputy of the Orangeburg County Sheriff's Office, and I'm also a professor of criminal justice at Claflin University, where I teach crime scene related classes.
All right, and pull that mic a little bit closer to you. Let's first of all, before we get to the professorship and what led to that, let's talk about your law enforcement career. So walk me back to the beginning, and if you could just kind of walk through the various stages of your career and the things that you did along the way that led you to become the Chief Deputy for Orangeburg.
Yes, sir. I began my law enforcement career approximately 30 years ago, and I've held many positions in those 30 years. But for the last 22 years, my concentration, other than administration, has been crime scene investigations and working violent crime scenes. I have ran the crime scene unit in Orangeburg for 6 or 7 years, and then I went on to SLED for approximately 4 years, and then I came back, and now I directly supervise the captain of investigations, and investigations includes the crime scene unit. So I'm still hands-on on crime scenes, either as a primary or a backup crime scene investigator. And as I mentioned earlier, I teach crime scene investigation and other criminal justice related courses. I received my bachelor's degree from Clemson University in 1991. My master's degree in science from Troy University in 2011. And my PhD from Walden University in 2019 with a concentration on use of force cases involving police officers. And my research is use of force and crime scene investigations.
So we could call you Dr. Kinsey, correct?
My grandmother told me it's what you answer to, but yes, sir, I'll answer to that, Kenny or Chief Kinsey.
And we could call you Professor Kinsey, correct?
Yes, sir, that is correct.
And then we could call you Chief Kinsey as well.
Yes, sir.
Okay. Well, let's talk a little bit more about the law enforcement, then I want to talk a little bit more about the education. Now, you mentioned that you've done a lot of administration, and tell the jury just a little bit about what it is to be the chief, and just what that entails, and then we'll talk a little bit more about sort of the crime scene stuff, if you would.
Yes, sir. I answer directly to an elected sheriff. I'm the number 2 man at the sheriff's office, and I supervise approximately, when we're full, when every slot is full, I supervise over 127 people. 105 are certified law enforcement men and women, and that encompasses about 9 different divisions at the sheriff's office, including narcotics, special operations, criminal investigations, civil, courtroom, school resource officers. There's several groups in there, and our civilian employees.
Now, as you already testified, you don't just do the administration stuff as the number 2 man, but over your career you've also extensively done actual law enforcement work, processing homicide and other major crime scenes. Is that correct?
Yes, sir, I have. I have boots on the ground, processed north of 800 death scenes. Not all of those are homicide. That also includes suicides, accidental deaths, and unexplained deaths. That is either as a primary investigator or as a secondary investigator in my career. And I still have a directive that I placed with my coworkers approximately 11 years ago. I still go to every death scene if possible.
And over that time, you said over 800 death scenes over the course of your career. Is that correct?
That is correct.
And then, you know, how many pieces of forensic evidence do you think you've processed over the years?
That would be hard to determine, multiple pieces for each scene, but part of my duties...
Homicides, then?
Yes, sir. Part of my duties when I was at SLED was to also process evidence that was submitted through the door. And what through the door means, these are items of evidence from other agencies that have worked their own crime scenes, and they send their items to SLED for an analysis. And that's in the thousands. I would have no way to give you a quantitative number.
In the thousands?
Yes, sir.
Is it also over the years, have you attended autopsies as part of your investigative work as it relates to death scenes?
That is correct. Every agency I have worked at had a mandate that you attend autopsies to collect evidence, do major case prints, GSR, and that kind of thing. And also to give the pathologist an idea of your interpretation of what happened.
And have you ever been asked to consult on death cases in jurisdictions throughout the state or even in other states?
Yes, sir, I have.
And describe that to the jury, please.
As a consultant, I work for, to be frank and honest, sometimes it's against law enforcement. Sometimes it's defending law enforcement, just depending on what I believe is wrong and right. And I have participated with private attorneys in the civil process doing both, and I've also been asked by colleagues and comrades across the country to review a piece of evidence if they may have needed a qualified examiner to technically or administratively review that piece of evidence or their findings.
All right. Before I come back to the specific crime scene training and experience that you have, I just want to go back again to your education. You went to Clemson, right?
Yes, sir.
All right, and started a law enforcement career not long after that?
That is correct.
And what year did you graduate Clemson?
I was on a 5-year plan. I graduated in 1991, and I started as a reserve deputy. The records are a little shaky because back then you worked until they had a certification class, but best I can guess was somewhere around 92, 93.
So 91 Clemson?
Yes, sir.
I was 92 Carolina. So. All right. Then you went on to Troy University at some point later in your career?
I did, yes, sir. I attended Troy's satellite campus, which is in Sumter, an actual brick and mortar school. And the purpose of Troy being placed in Sumter is because of Shaw Air Force Base. A lot of our men and women who protect our country use their GI Bills to further their education at such campuses. And I had to travel 3 nights, well, 1 night a week and 2 days a week for approximately a year and a half to complete that, pass proficiency.
All right. That competency exam, is that a pretty tough exam?
It's the second toughest thing I've ever done. Yes, sir.
Is the pass rate pretty low on that thing first time?
It is very low. We probably had 30 people in our class, and I only know of 4 that passed the competency the first time.
Were you one of them?
Yes, sir.
And then you went on and got your doctorate, is that right?
I did, yes, sir.
And that was at Walden University program there?
It was, yes, sir.
Did you have to do any residencies with that?
Mr. Waters, we'll stipulate to him as a qualified expert if we can just go ahead and move on. Thank you.
Your Honor, the state's entitled to explore the extent of his qualifications. That goes directly to the value of his opinion to the jury. I'll do it expeditiously, but I think we're entitled to do that.
Do you accept the stipulation or no?
I do accept the stipulation. I would like to very quickly finish up the qualification process so that the jury understands that.
Ladies and gentlemen, he is so qualified. You may proceed.
Thank you, Your Honor. All right. So real quick, you did some residencies in your doctorate, is that correct?
I did 4 residencies in Atlanta, yes, sir.
All right. And ultimately did dissertation and all that comes with getting your doctorate relevant to criminal justice and criminology, is that correct?
I defended my prospectus and my dissertation, yes, sir, successfully.
All right. Now, let's get to the last thing I want to cover as far as your qualifications, but what specific areas of crime scene investigation and reconstruction have you had training and experience and previous qualifications in?
Yes, sir. I have been certified internationally by the International Association for Identification as a crime scene technician. That's a 5-year deal, and then 5 years as a crime scene investigator, where you have to do practical and written examinations, and you have to have statistics in your background, a certain number of each item to even be able to take the test. And that encompasses all of the different aspects of crime scene investigation. My training also encompasses footwear and tire tread examination, bloodstain pattern analysis, crime scene reconstruction, fingerprint examination, and fabric impression, but I haven't done a lot of the fabric impression.
All right. Have you ever been qualified in courts of record as an expert in crime scene examination and reconstruction?
Yes, sir, I have.
How many times?
Approximately 35, 36 times.
Have you ever been qualified as an expert in fingerprint examination?
I have, yes, sir.
How many times?
Maybe 20, 25. Sometimes, and let me explain why. Sometimes it's not individually. Sometimes you'll qualify for 2 or 3 of the different disciplines, and I didn't keep track of which time, was singular or which time was multiple qualifications.
All right. And then have you ever been qualified as an expert in footwear examination?
I have, sir, approximately 8 times.
And tire tread as well?
Yes, sir.
All right. I believe that's what I wanted to go through with your qualifications, which I believe you stipulate in those areas. Is that correct? All right, let's move on. Did you have an opportunity to review, at the request of the state, the crime scene here as it relates to Maggie and Paul?
I did, yes, sir.
All right. And just very quickly, what are some of the types of things that you reviewed as part of your process?
When I do a reconstruction, I look at the available evidence as I feel it's pertinent to help me answer some questions. And the questions that or the things I wanted to accomplish from this reconstruction, you can determine sequence, you can determine movement. A lot of times you can determine the number of blows, or in the event of a hand-to-hand combat or a firearm was used, those kind of things. So I examined forensic reports that were issued by law enforcement laboratories. I also examined extensively photographs that were taken on the scene, measurements, that kind of thing, and I also responded to the scene. It was rather close, and I took my own measurements.
When you say responded to the scene, when did you first get involved in this case?
The end of 2022, and I'm not talking about when the scene was actually going on. I went after the fact and did my own measurements.
All right. And when you were retained by the state in this case, were you told any particular goal, or were you told to just take a fresh look at it and offer your opinions?
I was told to look at all of the evidence and determine what I may be helpful on, and to use my own judgment objectively, independently, and come up with my own conclusions.
All right, let's talk about, if we can, and again, we're going to have to deal with some of, maybe not the images as much, but deal with some of the injuries that Maggie and Paul suffered, correct?
Yes, sir.
Okay. Let's, if you could, just remind the jury, what were the injuries that Paul suffered, please?
They were very, very severe firearms injuries. One was a shotgun wound to just a little anatomical left of the midline of the body. One was to the shoulder, and it proceeded into the jaw and ultimately into the head.
And was that the first injury or the second?
The first injury was the shotgun wound to the middle of the chest, and it was non-fatal. All right. At least not fatal immediately.
And then what about the second injury?
The second injury was immediate death.
And were you able, in reviewing the crime scene evidence, to come to any conclusions as to the order in which Paul suffered those gunshot wounds from the shooter?
Yes, sir, I was.
All right, and please relate that to the jury.
My conclusion was that the first non-fatal wound to the midline of the body occurred as Paul was standing with his body canted in the middle of that dog food room, pointed slightly southwest, and the shot entered the midline of his chest, exited his underarm, entered his underarm on the actual arm, and exited the outside of his arm, and most of those 9 pellets proceeded through the back window of that dog food room.
Right. And then just real quick, you said 9 pellets. So explain that to the jury why you say 9 pellets.
That double-aught buckshot shot shell contains 9 pellets and I guess you describe it as a styrofoam packing to keep it tight so it doesn't shake. And when that cartridge is expelled out of the end of that barrel, the styrofoam packing dissipates or goes its own way, and those projectiles continue in the correct path.
And hold on for me real quick. I want to get a couple things marked. Show you, can I have the Elmo, please? I'm going to show you what's been marked as states 531, 532, and 533, and see if you recognize these particular images.
Yes, sir, I do.
All right, and tell the jury just generally what these are, please.
These are views of the floor of the feed room and a view from the entrance to the feed room and some digitally placed legs that I placed in there to show Paul's approximate position in that feed room at the time of the shooting.
Your Honor, at this time I'd offer for states 531, 532, and 533, I believe, without objection.
Yes, Your Honor.
They're admitted.
All right, I'm going to put 531 up on the screen here. Make sure we can see it all right. All right, Dr. Kinsey, you were talking a little bit about Paul's positioning and his location when that first shot happened. And if you could tell the jury your conclusion as to where he was located when that shot was fired. And then if you want to, step down, and if you could, maybe point out what was added to this image to kind of reflect your conclusion in that regard.
Thank you.
And there's a dowel stick right behind you if you want to use that.
Okay, as you see here, those are the digital legs that I placed there showing Paul's approximate position as he was standing when he had the first gunshot wound. Here along the floor, what you see are passive or 90-degree blood droplets. And when blood, you can tell a lot from the direction of blood by the way it strikes an object. Blood has a cohesive factor. It's viscous, and you probably heard that term before with the motor oil for your car. It's thicker than water. And the thing that causes that blood droplet to change shape is the friction and the direction and how much force was used. Well, a 90-degree drop just is exactly that. It's perpendicular to the ground. So these 90-degree drops right here tell me that Paul was standing there for a moment. Can't tell you how long, but those drops were running down from that wound on his arm, more than likely his arm, because his chest area had a shirt on it. It takes a little while for that blood to make it through the shirt, but it'll run down the outside of your arm and drip off your fingers. And you can see these 90-degree droplets here, here, and then they actually lead to the door. You can follow the path to the door. He's not moving very fast because most of them are almost perfectly circular or 90 degrees. Had he been moving real fast, you could see some directionality in them. tail, because the tail always tells you the direction with a blood drop. So I know he was moving slowly, and I know he was standing in the middle of this room for some time after the first shotgun wound.
All right, and approximately how far was Paul inside the feed room? Can you describe a little bit about the dimensions of the feed room and your conclusion as to how far within the room Paul was when he was struck by that first blast?
Yes, sir. Well, the feed room is 10 foot deep by my own calculations and by looking at the other sketches. And where you see his feet here is just on the other side of the halfway point. So I went, I'm guessing, because I have no way of running a tape measure, because when I went there, everything was moved. But this door is 36 inches, and it's approximately 1.5 feet, 2 foot past the door. So that's how I come up with that determination. And he's just on the other side of the midpoint of that 10-foot room.
Which is about how far from the doorway?
5 foot.
All right. And I'm going to show you what's been marked as 534, states 534, and see if you recognize that.
I do. Yes, sir.
All right. And tell the jury what that is real quick.
That is a general view from outside the feed room that was taken at the time the crime scene was originally processed. And I added a digital enhanced arrow showing the reader or the viewer the direction of the shot path.
Right. This time I offer states 534 and evidence.
Okay.
All right, I'm going to put 534 up on the screen, and if you would, just show that arrow that you're talking about that's been added to this image.
Yes, sir. Right here.
All right, and then as well, just show generally where those blood spots are. It's not the best image in the world, but where those blood spots are that led to your conclusion about Paul's location within the feed room when the first blast struck him.
The placard hasn't been moved, although it's hard to see the droplets, and of course I didn't add the legs to this. But just on the other side of that placard, and then you have here a quantity of 90-degree blood droplets with a partial footwear impression in it. And then you can follow the blood droplets to the door.
Going back to states 531, again, point out to the jury, if you would, the sort of the digitally added feet that you had added. All right. And if we would, if you could, just if that's the feed room doorway, can you just sort of position me, in your opinion, how Paul was standing when that first blast happened?
That's the doorway coming in?
Yes.
About right here.
All right. And let me ask you this. In your review of the evidence and the available crime scene evidence that you've reviewed, in your expert opinion, is there any way that Paul's arms were raised when he suffered that first blast to the chest?
I see no possible way his arms were up when he suffered that first shotgun wound.
And can you explain the basis for your conclusion to the jury in that regard?
Yes, sir, I can. The shot pellets were real close because they stayed together. They went in as one, as a unit, and then they did what a shot pellet does. They separated once they struck the skin and made entry. Run along inside his body cavity. Underarm. If his arms would have been up, he would have had no entry wounds on the bottom of his arm and then more exit wounds on the outside. He had over 20 entry and exit wounds, and he's only got 9 pellets. So the only way the math works out is if his arm was down. And additionally, the wad stopped and was under his arm. Had his arms been up, in my opinion, that wad would have went on and exited his body, because it's only plastic. It doesn't take as much resistance to stop that wad as it does a shot pellet. And the wad stopped. It was right. You could grab it with your fingers if you would have been medical personnel and needed to. If it was right there.
All right. And let me ask you this. Do you have a lot of general experience with firearms?
I do. I'm a firearms instructor for handguns, shotguns, patrol rifles, subguns, and fully automatic patrol rifles. Everything but precision rifle.
All right. And when you say an instructor, where is that?
I'm certified. I have credentials through the South Carolina Criminal Justice Academy. I've also been certified as an NRA law enforcement instructor, and I currently have a CWP endorsement to teach concealed weapon permits from the South Carolina Law Enforcement Division.
And you testified how many buckshot are typically in your average buckshot shell?
According to the literature and according to my experience, there are 9 in that particular buckshot.
Did you see any evidence, I think you've already mentioned this, but did you see any evidence from the crime scene as to what happened to some of those pellets as Paul was struck as they continued on?
Yes, sir, I did. They exited on through the back window.
All right, and I'm going to show what's already been admitted as 532 and put that up on the screen. And if you could describe to the jury what you're talking about in that regard, please.
This is that window at the back of the feed room, and you can see the shot shell pellet defects here as they went through the window and continued on their path.
And those are kind of big holes. Are those consistent, though, with buckshot pellets striking that?
Yes, sir, they are, and some are bigger than others because it's just the makeup of glass. I mean, sometimes you'll get one individual hole, and sometimes it'll take out, a large portion. So I have no way to know that.
All right. And just real quick, I've got 533. I'm going to put that up on the screen. And again, is that just a close-up of where Paul was standing about 5 feet or so inside that feed room?
It is, yes, sir.
Based on your review of the blood evidence that you saw?
Yes, sir. And here are the partial footwear impressions. And here you can see the 90-degree blood droplets and some other biological materials.
All right. And in your conclusion, what's the most likely explanation for those 90-degree blood drops? So how is that physically happening?
It's the arm wound. Even though it was non-fatal, there's less restriction from clothing or anything else on the arm. Here you've got the T-shirt that's got to completely saturate before it gets to the bottom and drops, but here on the arm you got nothing. So once those pellets exited, entered, and exited again, that blood's free running down his arm, and then they'll drip off the ends of your fingers.
One thing I want to ask you about is you've testified as to your conclusions as to the position of Paul when that first shot struck him. Is there anything about the entrance wound itself that supports your conclusion as to the shape of the entrance wound?
Yes, it's oblong instead of completely round. And had he been standing facing that door and took that double-aught buckshot to the middle of the chest, I've seen it dozens and dozens of times. Instead of coming out this side, a shot shell or a projectile doesn't make a 90-degree right. Generally, it's going to follow the same path unless it hits something hard enough to make it ricochet. It would have went on through his body. It still would have exited the window. It just wouldn't have done the damage to his arm and his underarm. So he had to be canted in this direction. And the wound is not perfectly circular. It's more oblong, which tells you that he was canted to some degree.
All right. In your review of the crime scene evidence, did you come to any conclusion about the location of the shooter when that first buckshot blast struck Paul in his chest?
It would be hard to say exact, but I can say to a bare minimum the breech of the shotgun, because I don't have the shotgun. I don't know the length of the barrel, that kind of thing, or I could run it from the door. But the breech of the shotgun, where it ejects the shot shell casing after it fires, was somewhere inside the door, because had it been on the other side of the door, the shot shell would have been located outside. So depending on the length of the shotgun, at least I can say the ejection port was inside the door of the shed.
All right. And then the shooter, I have this image up here, which I apologize, states 534. And can you kind of illustrate what you're talking about to the jury using that image?
Yes, sir. The breech, the ejection port, where you load and unload that shotgun, which is a little less than midpoint from the shooter, was inside this door frame, at least to some degree inside.
And where were the expended shot shells found on this crime scene?
According to the photographs and the original crime scene, behind this door.
And is that consistent with your review of the evidence? Does that support your review of the evidence that you just, that conclusion you just related to the jury?
Very easily. This is, if you look, this room is kind of cluttered. and I measured that door myself. It had been pressure washed, but the same door, found the same shot shell pellet defects in that door. 1.5 inches at the bottom of the door, that's plenty of room for a shot shell to bounce and roll under the door. So I have no reason to believe it didn't end up there because of the location of the shooting.
All right. All right, let me get a couple other things marked. You can kind of head back to your home base, and let me just get these marked real quick. Dr. Kinsey, I'm going to show you what's been marked as 535, 536, 537, and 538 state's exhibits, and see if you generally recognize those images.
Yes, sir, I do.
All right, and generally explain to the jury what these images are, and then we'll talk about them specifically.
Those are images at the door that I've added some visual enhancements to help the reader understand the flight path of the second shot and the different elements that I looked at in determining where the shooter was for the second or the fatal shot to Paul.
All right. Your Honor, this time I'd offer states 535, 536, 537, and 538 into evidence, I believe, without objection.
No objection.
Admitted.
All right. Let's look first at 535, and before we get to that, generally describe again to the jury your conclusion as to that second injury suffered by Paul, the fatal shot as you've described it.
Well, the first thing is, once Paul received that second shot, he never walked again. He never made any movement. Any movement he made was involuntary, and it was due to gravity, pulling his body down to the ground. When you sustain an injury to your brain like that, that ceases all movement. So he was found outside the feed door. He fell over forward after sustaining that movement. Some wounds are fatal later. You can actually see someone that receives a fatal wound, and I've seen them run 100 yards. They can move for a little while. This is not that type of wound. Once he received this wound, it ceased all movement.
And did you, I'm going to put attachment, states 535 up on the screen, and tell the jury what this particular image reflects, please.
Yes, sir. If you can look at the green funnel that I've added just visually, if you look at that green funnel, that is approximately the shot shell path, the shot path from the shot shell after it did the injuries to Paul, or the direction of the shot from the shot shell. And I determined that by shot shell pellet defects that are still in the door, even though the door had been cleaned. I went and looked at it myself, run my own measurements, took the width of the door. I took Paul's approximate height. It's listed as several different things. DMV shows him at 5'6". The pathologist listed him, I believe, at 5'9", so I had to split the difference. I went somewhere in the middle. Then I deducted the distance between the top of your head and the top of your shoulder, so I took another foot off. Then I took the width of the door, and there's one other thing I looked at, and that was a void pattern that's on the door frame of the door. A void pattern is caused by something being there when the blood and biological materials are let, we call it a bloodletting from the wound, and there's a void pattern which tells me something was in that way, and because of the narrow door, in my opinion, it was Paul. So that's what caused that void pattern on that door. So I used all of that, and I used a dowel rod, and I used a protractor on the doorknob side of that door frame, and I ran it up, and that's what helped me establish the angle of that shot pattern.
All right, and we're going to use the images to kind of talk about that a little bit more specifically, but quickly I want to show you 539 and 540 and see if you recognize these images.
Yes, sir, I do. 540 is my photograph when I visited the scene. And 539 is also my photograph, and it shows that top hinge of that door is approximately 72 inches at the top of the hinge.
All right, Your Honor, this time I'd move into evidence of belief without objection, states 539 and 540.
No objection.
Admit it. All right, let's. If you could, I'm going to ask you to step down again. I know I just sent you back there, but come on down. I'm going to put 539 up on the screen, and if you could, back out. Tell me what this image reflects, if you would, please.
Yes, sir. These are 36-inch standard yellow yardsticks. We use them to measure certain things, and it right here is the top of the top hinge. It's a 3-hinge door. And this is the top of the hinge, and then 4 inches above this are where those shot pellet defects were that I used to figure out my angle.
All right, and looking at 540, who took this particular image?
I took this image.
All right, so this would have been long after the actual event occurred. Is that correct?
This was last December. Yes, sir.
All right, and tell the jury what this image reflects.
You can still see the pellet defects in the door. And this is the approximate center of it here. So that's 4 inches above 72. That's approximately 76 inches on an 80-inch door.
I'm going to show you states 536 and explain to the jury what this is, and in particular how that's relevant to your conclusion about the angle in which Paul suffered the fatal head wound.
This is the original crime scene pictures. And this is where the pellets took their path. This is where they struck and did damage to the door. And you can actually still see the dents that are documented in my photograph. You can see them in the original crime scene. This is the concentration of blood that's caused by the brain exiting Paul's body in the path of the shot shells. And then you also have biological material, hair and blood, here at the top of the door frame. And that's where I drew my conclusion. At some time, those body parts made contact with these sections of the door. And my opinion is that it hit here, and then landed on the sidewalk.
Looking at states 537, can you explain what the jury's seeing in this image and how it relates to your opinion about the manner in which Paul suffered that fatal wound?
I can. With a major bloodletting, especially...
Dr. Kinson, let me ask you to... I'm going to move this podium and actually ask you to step back just a hair so that the jurors over here can see what you're saying.
Yes, sir. With a shotgun wound, you've got you've got over 100 pellets that are making damage. It's not like a single projectile from a pistol or a rifle. So there's mass damage, and it throws body fluids and blood in several different directions, but they follow the path. When I mentioned that it was a void pattern, this is the last blood drop. You can see it in the photograph that I could see, and it's approximately 5 foot right there. And this is not green tape. That is a digital effect I put on the photograph to show the void I was talking about. So at some time, it's my opinion that Paul was up against that door or real close to that door to keep that blood from striking the door at the point in time that he was shot.
All right, and the green tape reflects that blood path or that void area that is consistent with Paul blocking that area. Is that correct?
Yes, sir. Digital tape. It's not really tape.
All right. Well,
yes, sir.
And so that's been added to.
Yes, sir.
Okay. To illustrate your opinion. Correct?
Yes, sir.
All right, and then 538. I'm going to show you this image, and again, if you can point out what's been added and how this relates to the conclusion that you're offering to the jury.
Yes, sir. one thing that I looked at to determine that it happened in the doorway and a little bit outside the doorway, more outside than inside, you don't just look for the presence of biological material in blood, you look for the absence of biological material in blood. Here at the top, it didn't have a scale or a ruler, so I can't tell you exactly, but looking at some of these other objects, I was able to scale it approximately 4 inches. Up here, you have a void. So I know that it happened, the second wound happened far enough outside of that door frame that the actual frame kept the biological material from hitting at the very top, right here. I also looked at these items. You got some medication, canine medication, or some cleaning materials and that kind of thing up here. You can see all the spatter at the front of those containers. And then we got what I call a demarcation line right here, and I drew it through most of these cans. And that separates the blood contaminated area and the clean area. So that tells me that it was at least forward of the angle on those containers. And that's why I believe he was shot. The second wound happened just outside the door frame, but his feet were probably still in the door frame.
All right, and just quickly point to the jury, can we see part of the door frame in this particular image?
You can, yes sir, right here.
All right. And going back now to States 535, and just for the record, we were just looking at States 538 and 537. Going back to States 535, did you reach a conclusion as to the location of the shooter on that second fatal shot that Paul suffered to his head?
Yes sir, I did.
All right, and explain that to the jury if you would, please.
The shooter was right here. If you're facing that door, to the right of the doorway, outside.
And would you have expected there to be, in that particular range, any sort of biological evidence in that area in proximity to the shooter?
Yes, sir, I would.
Would the door frame have potentially blocked any of that as well?
It would block some, and just depending on the positioning, how much of the body of the shooter was exposed. Because once you have that kind of catastrophic injury, it's real fine blood particles and biological fluids that go in all directions. And the closer the shooter was to the muzzle, to the exit end of that firearm, the more stuff you would expect.
Let me ask you this. In your expert opinion, is there any way that Paul's fatal head injury came from the top in a contact fashion or a close fashion?
No, sir. I see no possible way for that.
And explain your conclusion in that regard to the jury, please. What factors weigh against that in your expert opinion?
Well, number one, I don't know of a way to mimic this blood evidence on this door, that pattern where that shot traveled through Paul's shoulder, into his jaw, into his brain, and then took a path up and placed the biological material here at the top of the door. If he was shot in the head, then you'd have biological material out here on the ground, or at least going down, on the sidewalk in front of him. And it would be different than just free pouring blood. You would see this pattern, and you would see those high velocity blood droplets there on the ground. And plus, the shooter would have to be on the roof to shoot down into him, but you wouldn't have this on the door.
In your expert opinion, did you see any support or evidence in this crime scene that could support that the injuries suffered by Paul were in any manner a suicide or self-inflicted?
I don't see the possibility, knowing that it's not a contact shotgun wound, and I'm fairly strong, and I'm bigger than Paul was, and I don't know of any way you could hold that shotgun out and shoot yourself in that direction at that angle and put that biological material on top of that door like that. I don't think it's possible.
Okay. All right. Thank you. All right. I hate to keep sending you back and forth, but I'm going to send you back one more time. Now, let me ask you this. Excuse me. The second wound, the fatal wound that Paul suffered to his head, was that buckshot or was that birdshot?
The second wound was birdshot.
All right. And can you describe to the jury the difference between the composition of a buckshot round as it relates to the pellets and a birdshot round?
Yes, sir, I can.
All right, please do that.
With buckshot, you've got a number of larger pellets, approximately 30, 36 caliber pellets, and you've got fewer of them. They're made for bringing down larger game. So in the typical double-aught buckshot, you're going to have 9 pellets. In your typical number 2, and it's called many things, you know, the typical person calls it birdshot, chill shot, steel shot, coated shot. I've heard it called many things, so I just typically call it birdshot. But in this particular shot, there's approximately 150 to 156 pellets in that dry lock shot shell. So that's the difference. With the buckshot, you've got fewer and they're larger, and with the birdshot, you've got many and they're greater. They're for bringing down winged animals, squirrels, rabbits, dove, quail, turkey, duck. I mean, just depending on the number shot, that's what that's for.
All right. And about how many approximately birdshot might be in an average shotgun shell?
The literature says that it's 156 in a dry lock. I cut one open and I only counted 150, but that may have been human error.
Around 150?
Yes, sir.
In your expert opinion, when you have birdshot, is there a forensic value to collecting every single pellet, or can you explain those concepts to the jury when you're dealing with birdshot?
I always try to collect enough that the firearms examiner can weigh it, and he can have a good representative sample of what was used to cause this injury. With a projectile or a bullet, you have what's called lands and grooves, markings, rifling. Some people call it rifling, and it's caused from that projectile spinning as it goes down the barrel. You don't have that in a shotgun. And a pellet is so small that you probably couldn't find it if you could have it in a shotgun. So in my opinion, there's no forensic value as long as you have enough to determine what type of shot or what type of shell and the weight of it.
In your opinion, and you've talked about this, but was the shooter, when that fatal shot was fired, inside or outside of that door frame?
The second shot?
The second shot.
Yes, sir. It was outside the door frame.
All right. And where was that second shot shell located?
It was also located under the door.
All right. And is that still consistent with your opinion?
Absolutely.
And can you explain that to the jury, please?
Yes, sir. Like I mentioned earlier, the ejection port on a shotgun typically, now there are left-handed shotguns, but typically the majority of shotguns, the ejection port is on the right side. So as long as that shooter had it at an angle and had that ejection port pointed toward the door, even just the least little bit, that would give plenty of opportunity for that shot shell to be ejected and go inside that door.
All right. I know I just sent you back. I'm going to bring you back down. I'm sorry. Before we move on from Paul, I would, and if you could just use me as a mannequin, but can you sort of describe to me your conclusions about the positioning of Paul when he suffered that fatal head wound, and just how the trajectory of that wound and that shot as you've described and as supported by the evidence as you see it?
Can I describe it and demonstrate?
Yes, please.
So the jurors can see. The second wound, as I mentioned, went in his arm and caused an injury here, a large entrance, and then of course exit here. So it had to be, typically with the kind of non-fatal wound Paul suffered to his chest and his arm, it's my belief that now his 5'8" frame is dipping or favoring that arm, because as you know, that's over 20-something entrances and exits. I believe it would have hurt him. I believe he would have been in pain, and I believe he would have been somewhat affected. And the reason I believe that is because I've got the 90-degree blood drops moving really, really slow. If he wasn't feeling it, or if it hadn't affected him in some way, I believe his youthfulness would have allowed him to get out of there faster. But he's moving real slow to the door. So that's going to drop that angle just a couple inches, and I can demonstrate.
All right. And if we can make sure that juror can see.
Yes, sir. Absolutely.
All right.
That wound went in approximately right here. It traveled in, out, in, and out in a straight line. In a straight line. Shot always goes in a straight line.
And then when you're pressing the dowel stick there, you're showing the trajectory of the wound, not implying that was a contact wound. Is that
No,
correct?
sir, I'm not. I'm not implying it's contact. I'm just showing the level of the wound.
All right. While I'm thinking about it, the wound to Paul's chest, did it show evidence of stippling?
It did. Yes, sir.
All right. And just very quickly, what is stippling?
Commonly referred to as tattooing. It's particles and material that's in that shell that don't burn up because it's superheated at the time that the powder charge ignites. It doesn't explode. It ignites and burns rapidly. And that's unburnt particles of powder and other contents of that shell. They're hot, and when they hit the body, they cause stippling, or in the old days they called it tattooing. And that's basically what it is. It works as an ink.
Looking at this particular image, Paul's about 5 feet in the feed room when he suffers the first wound, correct?
Yes, sir, that is correct.
And then he moves towards the door, is that correct?
That is correct.
And suffers the second wound somewhere near the door frame on the inside of it.
Yes,
correct?
sir, with his shoulder just outside that door frame.
And when he suffers that second wound, what happens to Paul?
He falls immediately.
And where does he fall?
He falls outside the feed room.
All right. Let's move on now, and let's talk a little bit, if we can, about the injuries to Maggie Murdaugh. And if you could, start out by reminding the jury of the injuries that she suffered, and then let's talk about your conclusions as to the manner and the order in which those were suffered.
Yes, sir.
All right. So if you could just remind us again of those injuries, and if you could go ahead and describe them in the order that your expert opinion they were suffered.
Yes, sir. Miss Maggie Murdaugh suffered 3 non-fatal injuries from a firearm. One was through her wrist. One was her left upper thigh above the knee. One was at her abdomen here, and it exited somewhere around her kidneys. Now, I'm not that kind of doctor. I can't tell you all the damage it did inside, all those organs and things, but it ran a straight line through her body. This one on her left leg and this one on her midsection were approximately the same angle, and they were really, really close in distance. One had stippling that said that it was a foot closer than the other, but that would probably fit. This was either a total separate non-fatal wound, or it could have been a continuation of one of the 2 fatal wounds. Her fatal wounds were, she had an abrasion or a burn on the left side of her abdomen from the outside in. That bullet followed a straight path. It entered the end of her breast and did extensive damage to the end of her breast, entered her left jaw, side of her face area, and went into her brain. That's the first fatal injury. And it was immediate, and she dropped right where she was at. I saw no evidence that her body had been manipulated, moved, or rolled over. The second fatal injury was down into her head, and it actually did what in the day they call a keyhole injury just from appearances. The entrance and exit in the top of her head were so close it made one big injury, and then it entered into her upper shoulders and went down into her body. That would have also been a fatal wound, but it was second. In my opinion, that one came second.
All right, let's talk about that in a little bit more detail. Those first 2 wounds that you described, you believe those are the first 2 wounds she suffered?
Yes, sir, and possibly 3. I can't tell you much about this because the arm could have been moving or it could have been here.
All right, well, let's talk about the thigh wound and the abdomen wound. Did you have any conclusions about the location of the shooter as those 2 wounds were suffered?
Yes, sir, I did.
All right, and explain that to the jury if you would, please.
A little bit more, right there. All right. Left leg out a little bit. About here and here. Here and here.
And in your opinion, were those 2 shots fired in fairly quick succession or around the same time?
I think it would have been really, really difficult to get a similar angle if they weren't. All the shooter had to do is raise the weapon or lower the weapon, and you're still on the same plane.
And did those wounds to the abdomen and to the thigh reflect the presence of stippling?
They did.
And what does that indicate to you about the distance between Maggie and the shooter when those wounds were suffered?
I guess 4 or 5 feet.
Okay. Fairly close?
Yes, sir.
All right. And after those 2 wounds were suffered, and again, we'll put aside the wrist wound for a bit, what would have happened after that in your expert opinion?
In my opinion, at bare minimum, she would have been over. She would have been in pain. I believe sometime in close proximity, she fell to the ground, and that's when the first fatal wound was delivered.
Would she have been prone on the ground or still somewhat raised above the ground or in a bent over position when that first fatal wound was suffered?
In my opinion, from the angle, she would have been on her knees and had at least one hand on the ground.
Those first 2 shots, well, let me ask you this. There were obviously 6 shell cases of 300 blackout that were used to murder Maggie Murdaugh found at the scene. Is that correct?
That is correct.
Explain to the jury, what conclusions, if any, can you draw about the location of those shell cases, if anything? Explain that to the jury a little bit.
Once again, just like with the shotgun, I'm not saying it doesn't exist, but I don't think there are many left-handed AR platforms. So generally speaking, the ejection port's going to be on the right side. I own 7. Some of them throw it, the shell casing a little bit forward. Some throw it a little bit back. Some throw it perfect 90 degrees to the ejection port. If they were always uniform where they come out, if you go target practice, you could place a bucket there and all your shell casings would drop in the bucket. You wouldn't have to bend over and pick up your shell cases. Unfortunately, that's not the real world. So I don't put a lot into that unless I have the actual weapon, and we can test the weapon with the same ammunition, and you can generally get an idea where that shell casing is going to go. So no, sir, I don't pay a lot of attention to it, and I definitely don't think the sequence of from one end to the other or from this end to this end means that's necessarily the movement of the shooter.
Gotcha. All right. You said that when she suffered that first fatal wound, in your opinion, I mean, she would have been over and perhaps been on her hands and knees. Is that correct?
Yes, sir.
All right. I'm going to get down on my hands and knees, and if you could come around here and kind of show me where the trajectory of that wound would have gone, the first wound that was fatal for Maggie Murdaugh. I guess you can come behind me.
Yes, sir.
All right.
Right here. The shooter was right here, approximately right here.
All right. And show us the trajectory as it went through Maggie into her brain.
Yes. It burnt or grazed her stomach outside to inside, went through the end of her breast, into her jaw, and then into her brain.
Okay. And what would have been the effect on her once that shot was suffered?
She would have immediately fell down with the front of her body.
All right.
And that is the position her arms were in the original crime scene photograph.
And while I'm down here so I don't have to get up again, tell me about the fatal shot and the position of the shooter as the evidence indicates to you.
The second shot was not as close, but it still wasn't a long distance. It was approximately here into the crown of the head.
And use the dowel stick to show that injury that Maggie suffered.
In, out, in that line.
Okay. Thank you. We need to go to the dry cleaner after this. All right. The first shot, the first fatal shot, that would have immediately been fatal. Is that correct?
Yes, sir.
The second shot also would have been fatal had she still been living, but in your opinion, she was not at that point. Is that correct?
Yes, sir.
All right.
She may have had a sign of life, but there was no movement. She was not capable of any movement at that time.
All right. Go ahead and have a seat for me. Of course, as soon as I say that to you, I'm sure probably going to have to get back to that. Let me talk about something else real quick before we come back to this. I'm going to show you what's been marked as States 541 and see if you recognize this document. I'll bring it back to you. Good call.
Yes, sir, I do.
All right. Tell the jury generally what this document is, please.
That is a comparison and presentation that I put together over an unidentified impression on Miss Maggie Murdaugh's left calf.
Okay. Your Honor, at this time I would move States 541 into evidence under seal.
Objection.
Submitted without objection.
If we could make sure the monitors are secured, please. All right, I'm gonna. Are all the monitors secured? We're good. Right. I'm gonna put States 541 up on the screen. I'm sorry. We're good. I got the thumbs up for Court TV, correct? All right. Moving 541 and putting it up on the screen. If you could tell me, first of all, what do we see here before we get to your analysis on this particular issue?
This is a general photograph of an impression on Miss Maggie Murdaugh's left calf.
Okay. And do we also see a wound on this picture?
You can see the exit wound from that thigh wound that I described earlier.
All right. And what, if anything, did you notice about or conclude from the sort of the blood pattern on the back of her thigh there?
She stood a little while. I can't tell you how much time, just like with Paul, but she was standing after she suffered that thigh wound because the blood is running down the leg and gravity always pulls it to the earth.
All right. And then, I sent you back there. I'm going to just bring you back on down. I'm sorry about that. Bring the stick. If you would, and again, make sure you're out of the way of the jurors. Was there any sort of mark or any sort of mud mark on the back of her leg?
Yes, sir, it was.
All right, and point that out to the jury, please.
Right here, an unknown impression on her leg.
Okay. And did you engage in an analysis of that particular impression?
I did, yes, sir.
All right, you just stay there. I think it's probably easier than sending you back. I'm going to move to the next slide. And just tell me what this is, if you would, please.
That is the same impression, unknown impression. I've just cropped everything out so you can concentrate on the actual impression.
All right. Moving on to the third page of this exhibit. What is this?
This is a side-by-side all-terrain vehicle that was in close proximity to Miss Maggie Murdaugh's body, where her final spot where they located her, and this is in close proximity to where she was located.
All right, stand by for me real quick. I'm going to show you what's previously been admitted into evidence as State 70 and State 71. And can you tell me what these images reflect?
That is that Polaris ATV side-by-side that I mentioned.
All right, and generally remind the jury where this was located.
Ms. Murdaugh was laying face down. That was to her left, underneath a overhang or a I don't know what you call it, a shed that was attached to that airplane hangar. A lean-to, that's the word I was trying to think of.
All right. And do you see any indication of any biological material in the crime scene images that were taken of that Polaris?
That was my first indicator. That's what made me concentrate on a specific tire. Yes, sir.
And let me see how washed out that is, if I can maybe fix it. And can you point out an example of what you're talking about on that image?
Yes, sir, I can.
And I can bring you the original image if that's better.
Right here, we've got some kind of biological material, and I'll tell you the reason I believe that to be so. Like I said, blood has a viscosity or a cohesive factor to it. That's why a blood drop stays together. You know, if you throw a drop of water on a tire, what's going to happen? It's going to run down. But here, and actually here on the front of that four-wheeler, in my opinion, that's some type of biological material.
All right. I'm going to do one other thing. Let me slide by you real quick. All right, looking now at defense 29. Again, if you could, just, this is the feed room right here, is that right?
Yes, sir.
And just, if you could, just point to the general location of this ATV and where it was located in the crime scene.
Yes, sir. Thank you. Yes, sir. I'll get that.
Now,
right here in this area.
All right, and that would be, again, on this is not to scale, but that would be at least on this diagram where Maggie was, is that correct?
Yes, sir, that's our approximate location.
All right. Looking at going back to this particular slide and your analysis of this tire, if you would explain a little bit about what you see here and what an examiner looks at in looking at sort of this particular tire as it relates to your analysis.
Yes, sir. What we look at it as footwear and tire tread or tire track examiners, we look at the actual tread pattern and design of that tire or that shoe. And there are a couple different conclusions you can come up with. We compare known and unknown. It's not like you see on TV where you take a picture of a shoe and feed it into a computer. Some people have footwear databases, but it still has to be examined by a human. There's no magic machine. If it is, I've never seen it. What we look at the dimensions of the tread pattern. We look at the shape, the sole, the outsole design, the tread design, the measurements, and we try to find class characteristics. That's shape, size, sometimes depth, or the physical properties included in that pattern. And then to make a complete identification, that's a class characteristic. That's saying there's an association, either this shoe or this tire could have made this unknown impression, or another one just like it could have made this unknown impression. So that's a class or an association. Then you've got an identification. That's where you say, to the exclusion of all others, this shoe or this tire made this print. Now, to make an actual complete identification to the exclusion of all others, you've either got to have what's called a random unique characteristic. A thumbtack in the bottom of someone's shoe, bubble gum, damage to the tread pattern on that tire. You know, you hit something and it cut a tread pattern. So that's pretty difficult unless you have the actual tire, the actual shoe, and then you take it and compare it to the unknown. And what you'll do is take that tire, and three-dimensional comparisons are always better than two-dimensional. Two-dimensional is a photograph. You can't tell depth. If you have the actual cast of that footprint or that tire, now you've got three-dimensional. You've got the width, the length, and the depth. So it's a little bit better to have a three-dimensional to compare with, but you can do a lot with the two-dimensional. If you can get it scaled to the size, you can associate it with another thing. You're looking for them unique random characteristics. They call them accidentals. It's something that happens by accident, just because of the way you walk, the way you drive, what you might hit. And that's what you look at when you do a tire or footwear impression analysis.
I'm going to move on now to the next page in your exhibit, and tell the jury what these two images are, please.
Yes, sir. This is the unknown impression on Miss Maggie Murdaugh's left calf, and this is the photograph of the known front driver's side tire of that side-by-side.
All right, and when you were starting to compare these two, did you have to make any account for the relationship of Maggie's thigh and this ATV tire?
I did.
And explain that to the jury, please.
Just like if you're driving in your car and an ambulance comes up behind you and you look in the rear view mirror, you can read ambulance. But if you look at the front of that ambulance, it's written backwards because you're looking through a mirror. Well, with a shoe, a tire, or Miss Maggie Murdaugh's leg, you can't see through her leg. You can't see through the tire. So you have to flip one of them or the other. So flipping the tire, in my opinion, because it has some characteristics on it that I wanted the reader to be able to look at, I chose to flip the impression on her leg to do the comparison. Because unless you do footwear and tire tread examinations, you're not going to be able to look at something in reverse and find those points.
So this is the original orientation, is that correct?
It is, yes, sir.
And then flipping over to your next slide, that's where you've reversed the image, is that correct?
Same photograph. I just pulled it over. In the old days with 35 millimeter film, and I'm from the old days, we just flipped the negative. That's all you had to do. It's a little bit more complicated in the digital world, but not that hard to do. But this is a direct representation. It's just in reverse.
All right. Continuing on as we go through your analysis, what does this reflect?
This is just a side-by-side so you could understand the orientation. Here, 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 and here. Those are the two treads that we're talking about now.
All right.
And by the way, those on the tire are the only treads at that level on her calf that I believe needed to be examined.
All right, and again, these are just additional images illustrating what you were focusing on in your analysis?
Yes, sir.
Okay. And then this one right here?
Yes, sir. That's a side-by-side view once again, with all the background cut out of it.
All right, and then the final one is this. Explain this to the jury and how this supports your opinion.
This is my actual comparison, and we use a process called ACE-B, where you analyze, compare, evaluate, and verify. It's a peer-reviewed process. I never go by just my results. I always have another competent examiner with like experience and like skills look at my work, because if you're going to make a mistake, that's where the mistake's found. You don't want to put a conclusion out for something important and you miss that. And that is a very important process in the examination world, that you use peer-reviewed process. You have someone else look at it. And so what I do, so that person and the jury in the court, Your Honor, so that person can look at these details, I've got a markup here showing some unique random characteristics that I've used, but I also put the actual impression there so you can make your own decision. I didn't want to look like I was being deceptive and put enhancements in there and point things. You can look at it and make your own conclusion. But I wanted to put it right next to mine so you know I'm being straight here, or you can make your own opinion.
All right, very quickly, is it your expert opinion that this mark on the back of Maggie's leg is a tire impression and not anything else?
That is a tire tread impression. That is my opinion.
All right, now I see you have a number of arrows here that have different colors, and so I'd like to move through those and you explain what you're pointing to with those arrows in this image, okay?
Absolutely.
Let's start with the baby blue one and tell the jury what that indicates to you.
Now you're going to have to tell me because I can't tell shade from up here.
Right.
Okay, the top one.
Yep.
Yes, sir. All right, here you've got your unknown impression. You see down there? Here you got your unknown impression, and what I pointed here is at the start of that impression, and it's in mud, by the way. It's in mud, and so it's really, really fragile, but it's still here. You got an unknown impression, and here's approximately where it starts in the unknown, and here is where it starts in the known. And you can look at both, the marked up one and the actual impression itself.
All right,
and it's here.
All right, and then moving on to this one right here, kind of we got a purple one, and then kind of that.
Yes, sir. I see
whatever that one is, but explain
to
the jury what you're seeing there and how that supports your conclusion.
Right here is the other side of that tread, and this tread is this tread is this tread. Those two are the same, and right here you can see it come up, and it actually makes a complete corner there. Comes up and it curves out just a little bit there.
All right, and is that consistent with the sort of unique shape of that top tire?
Yes, sir, it is. Right here, and then it comes up. Now it's exaggerated a little bit in the drawing, but that's the best I could do with a stylist trying to get it there.
And are those very distinct patterns that you see in the mud that match up with that particular tire?
Yes, sir. Not so much the corner there, but these in here are. You can see a unique random characteristic here, and all that is a void pattern in the mud. You can also see it here. I mean, almost perfect. You can see one here where the yellow area is. You can see it here. It's right there.
All right, you're kind of doing a little mountain or a little hump, and expand on that with the jury. Why is that particular? Why is that significant to you?
Because that's not in the process of making the tire. That's because whoever drove that side by side last hit some dirt or some mud, and that is a pattern that's left in mud on the tire. And in my opinion, it transferred to Miss Maggie Murdaugh's calf.
All right, and show the jury where you're talking about the little hump on
yes,
this
sir.
image right here, if you could show it.
It's marked with a yellow arrow, and here it is, right here. And I've marked it there, but you can look at the one that's not marked, and you can also see it here.
All right, talking about this bottom impression, we've got a white arrow to that line right there. Explain that to the jury and what's significant in your analysis about that.
I marked that because unless you examine, unless you got really, really good eyesight, you might not even pick up on that. But here you've only got a partial line. The whole line didn't show through in the transfer of the mud or dirt or debris. And I kept myself honest. I only highlighted the length of that, but you can also see it here and here. You can see that side of that tread, that tire tread.
All right. And moving on now to this green one right here, and kind of green to the baby blue to that blue, just kind of going around there. If you could explain that to the jury and its significance, if any, to your analysis.
It's just a continuation, and there's a little break in there, but they're still the same angles, same lines, and they match up, and that's just because the dirt didn't transfer completely. But you got plenty of skeletonized line here to show the outline of that tread here, here, and here, and that's here, here, and here.
In your opinion, that's a tire impression, is that correct?
That is a tire impression. That's my opinion.
And in your opinion, based on these very significant mirror images and accidentals and that sort of thing, is that most likely that specific tire tread that's on the back of
it is most likely that tire. If it's not that tire, it's a similar tire with the same tread design.
And that particular tire was in close proximity to where Maggie was found, correct?
In close proximity.
Looking at how you had Maggie in that first shot, I think you had me kind of angled a little bit like that. Is that correct?
Yes, sir.
And if she was angled that way near that front tire, would she be facing towards the feed room?
Yes, sir.
All right. And are those two shots that were suffered in the abdomen and the thigh, are those consistent with the shooter coming from the direction of the feed room?
Certainly could be. Yes, sir.
All right, go ahead and have a seat for me if you would. I'm sure I'll have you back up. All right. Additionally, with this particular tire tread impression on the back of Maggie's calf, is that consistent with her running into it or backing up into it with her calf hitting that tire as it was parked there?
Leading, I've not. This is my first leading objection on this, but I object. Leading.
I'll replace your. All right. Let me ask you this. With this particular tire impression and what you see on Maggie's calf, is there a reasonable explanation as to how that impression got on her calf?
At some point in time, Miss Maggie Murdaugh's left calf made contact with the inside of that front driver's side tire, or one just like it, and I saw no evidence that she was run over. So she had to make contact at some point in time.
Gotcha. All right. Hold on for me 1 second. I've just got a few more matters. All right, I'm going to show you and want you to be careful. This one will be under seal, so can we secure the monitors, please? I'm going to show you what's been marked as 542 and see if you recognize this image.
I do.
All right, and just generally tell the jury what that is.
It's a cell phone sitting up on the back right-hand side pocket of the victim, Paul Murdaugh.
All right. Your Honor, this time I'd move States 542 into evidence under seal.
Objection, Your Honor. That's admitted.
All right. Are the monitors secured? And I'm going to put this image up on the screen. All right, and again, is this your understanding of how Paul's phone was found at the crime scene?
It is.
All right. And did you make any assessment or analysis of whether or not Paul's phone could have popped out and be found in that position?
I did.
All right, and can you relate that to the jury, please?
It's my opinion that his phone was placed there by someone else.
All right, and tell the jury your basis for that conclusion, please.
Well, after I mentioned the fatality, the fatal shot, at that point in time you have no movement, even involuntary movement, and there's no way Paul could have retrieved that phone from his pocket and placed it on top the back of his pants.
And in your opinion, if he had been carrying that in his hand, could it have landed in that fashion following the fatal shot he suffered to his head?
Mathematically, you could have made it happen, but I don't believe it's possible. I believe the phone would have fell to the ground and it wouldn't have fell behind him up in the air and landed on him.
A couple other things. You've testified about your experience in crime scene and that sort of thing. Is that correct?
Yes, sir.
Is there any forensic value in a residence belonging to certain family members and doing any sort of DNA swabs of the bathroom sink or the shower drain or anything like that?
If it's an unknown person, maybe, but not if someone lives there. I see very little forensic value in that.
And why is that? Can you explain that to the jury?
Because Because we as humans, we swap, we lose biological material every day. We brush our teeth, or we should. We brush our teeth and we shampoo and we wash, and there's commonly blood and other bodily fluids in our drains, in our tub drains, and generally everywhere except in the toilet bowl.
Generally.
Generally, yes, sir, under black light.
You've talked about your experience and your certifications with firearms. Is that correct?
Yes, sir.
Do you own yourself any AR-style platform rifles?
I have 7 complete rifles, and I also own a couple strip lowers that I'm just holding for a rainy day.
Gotcha. And what are those chambered in?
223 556.
In the AR platform, is that the most common chambering for an AR platform?
I believe it is, yes, sir.
Do you personally own a 300 Blackout?
I do not, but I have trained and shot a 300 Blackout.
And why do you have 223 instead of 300 Blackout?
The cartridges were a little bit more difficult. Well, they were a lot more difficult to find during COVID, and they are a lot more expensive than 223 and 556.
300 Blackout pretty loud?
I think they're all loud, yes, sir. I have to wear hearing protection around my rifles.
300 Blackout louder than a shotgun?
Absolutely. I don't wear hearing protection when I hunt. I'm an avid hunter, but I have to wear hearing protection with my rifle.
Hold on for me 1 second.
Ladies and gentlemen, I have you go to the jury room for a break. Please do not discuss the case.
back to our coverage of week 4 of the Alex Murdaugh trial out of Walterboro, South Carolina. A really fascinating case about a disgraced attorney accused of killing his wife and son on their family property on June 7th, 2021. They're currently on a morning recess. As soon as we can jump back live, we will. Now, before the break, we were listening to the testimony of crime scene investigator Dr. Kinsey. Really fascinating testimony because he's able to tell a story of what happened to Maggie and Paul based on their injuries, the positioning of their bodies, the forensic material. To give you an example, here's what he had to say about Maggie Murdaugh's injuries.
Remind us again of those injuries, and if you could go ahead and describe them in the order that your expert opinion they were suffered.
Yes, sir. Miss Maggie Murdaugh suffered 3 non-fatal injuries from a firearm. One was through her wrist, one was her left upper thigh above the knee, one was at her abdomen here, and it exited somewhere around her kidneys. Now, I'm not that kind of doctor. I can't tell you all the damage it did inside, all those organs and things, but it ran a straight line through her body. This one on her left leg and this one on her midsection were approximately the same angle. And they were really, really close in distance. One had stippling that said that it was a foot closer than the other, but that would probably fit. This was either a total separate non-fatal wound or it could have been a continuation of one of the 2 fatal wounds. Her fatal wounds were, she had an abrasion or a burn on the left side of her abdomen from the outside in. That bullet followed a straight path. It entered the end of her breast and did extensive damage to the end of her breast, entered her left jaw, side of her face area, and went into her brain. That's the first fatal injury. And it was immediate, and she dropped right where she was at. I saw no evidence that her body had been manipulated, moved, or rolled over. The second fatal injury was down into her head, and it actually did what in the day they call a keyhole injury just from appearances. The entrance and exit in the top of her head were so close it made one big injury, and then it entered into her upper shoulders and went down into her body. That would have also been a fatal wound, but it was second. In my opinion, that one came second.
All right, so let's break this down right now with our boots on the ground. Gigi McKelvey out of South Carolina in that courthouse, our law and crime correspondent. Gigi, it's good to see you. A lot to take away from Dr. Kinsey's testimony. As I said, it told a story. What was the story that you found out or you learned from Dr. Kinsey?
Well, I think that the presentation, mainly with Creighton Waters on the ground, with him using that long stick to really just show the position of the shooter, brought it to life for the jury and added a layer of just this being a lot more haunting now that we have an actual visual of how they were positioned when they were shot. But I think it really gives some indication of talking about how slowly Paul was walking with the blood droplets. So it adds that layer of just the brutality of these murders, and I think that was not lost on the jury. They're very engaged in this testimony.
So in other words, even though there were points when Creighton Waters was on the floor, right, demonstrating, they were watching every single second of it, this demonstration. And I guess the question I have for you is, was there anything in there that suggested Murdaugh did it? The reason I say is because there were some parts where, it seemed to suggest that Paul might not have seen this coming, right? And that would give you to speculate about who might have done it. But was there anything that stood out to you about this might tie back to Murdaugh specifically?
I think one of the biggest things in that regard is just the fact that Paul didn't have his hands up in a defensive position. So either he just didn't see it coming or he knew the shooter and had no reason to think he was about to be murdered. I think that's, for me, the whole trial has been the one thing that lets me think this is somebody most likely he knew.
And the difference in the way Maggie and Paul were killed, I think, was significant as well, right?
Yeah, because with Paul, you have the two shots. You have the one to the chest, one to the head, to where it makes a little more sense that maybe he was first, because you have some random shots that didn't really follow a certain order on her body. They kind of went from lower to upper, with the final two, the fatal headshots. So it indicates to me maybe she saw or heard something, started running or trying to flee, and then you've got somebody, you know, that's closely behind, but still not hitting her with fatal shots until the very end, after that abdomen wound kind of caused her to slow down a whole lot due to the pain she would have been in.
Yeah, it was brutal execution. I think that's pretty clear based on what we heard. Gigi McKelvey, thank you so much. I know you have to jump back into the courtroom. Gives us an opportunity to bring back on my guests. Florina, I'll start with you. We can talk more about the gunshot wounds, but I actually want to ask you what your opinion is on the judge permitting the evidence of this staged roadside shooting where Alex Murdaugh allegedly hired someone to shoot him in the head so that when he dies, the insurance proceeds could go to his surviving son, Buster. At first, the judge wasn't going to let that in. Then he said the defense opened the door to that testimony and is now going to permit it. This will extend the prosecution's case. Good decision?
Well, it is a good decision because initially, like you said, Jesse, the judge kept it out. And the judge kept it out because it is horribly prejudicial and, in theory, not related to this case. However, once the defense opened the door to it by suggesting and using the theory that maybe there's this other suspect and that other suspect could be the guy that Alex had hired in that other shooting to shoot himself for insurance proceeds, he's opened that door wide open. And so, of course, they could go into all of it, but I don't know how helpful it's going to be for the prosecution. Obviously, it's prejudicial that he's going to look like a bad guy, but I think it could potentially really create other suspect evidence, because here we have another guy who has shot him previously at his own hiring. Potentially there's some misunderstanding, some conflict, some other money. Maybe that other guy is the guy who came back and did this shooting, and any questions raised can equal reasonable doubt.
And maybe if they couple that with the idea that investigators didn't thoroughly look at other people, which I think the defense has done a pretty good job of showing deficits in the investigation, mistakes and things that were missed, maybe that's something they can explore. But still, we got so much more of a trial to cover. Duncan, I appreciate you coming on. Florina, I appreciate you coming on. Wish I always had more time with both of you, but thank you so much for your insight. I will be signing off. You're in great hands. Michelle Yu is up next. Stay with us here on Law and Crime. We'll be back.
Hi, everyone. I'm Michelle Yu. Thanks for joining us here on Law and Crime Network. Our coverage continues in the trial of disgraced former South Carolina attorney Alex Murdaugh. He stands trial accused of killing his wife Maggie and youngest son Paul back in June of 2021. All eyes have been on Dr. Kenneth Kinsey, the crime scene investigator, as they have reconstructed the crime scene to determine the sequence of events the night of the murders. Court is still on a quick break right now, so let's listen into some of his testimony from earlier today, especially hear about Paul Murdaugh and the injuries he sustained.
What were the injuries that Paul suffered, please?
They were very, very severe firearms injuries. One was a shotgun wound to just a little anatomical left of the midline of the body. One was to the shoulder, and it proceeded into the jaw and ultimately into the head.
And was that the first injury or the second?
The first injury was the shotgun wound to the middle of the chest, and it was non-fatal. Right. At least not fatal immediately.
And then what about the second injury?
The second injury was immediate death.
And were you able, in reviewing the crime scene evidence, to come to any conclusions as to the order in which Paul suffered those gunshot wounds from the shooter?
Yes, sir, I was.
All right, and please relate that to the jury.
My conclusion was that the first non-fatal wound to the midline of the body occurred as Paul was standing with his body canted in the middle of that dog food room, pointed slightly southwest, and the shot entered the midline of his chest, exited his underarm.
You may bring the jury. Yes.
Dr. Kinsey, I just have a few more questions on direct examination. Did you see any evidence or anything that would reflect a struggle between Paul and the shooter?
I did not.
And can you explain that to the jury, please?
Typically, if when you observe defensive wounds, what's called defensive wounds, you would see signs of a struggle. I saw none on Miss Maggie Murdaugh or Paul Murdaugh in any of the autopsy or crime scene photos.
Thank you. Please answer any questions the defense may have.
Please, Your Honor. Yes, sir. So do I call you doctor or deputy or chief or what?
I haven't been a deputy in about 25 years, Mr. Harpootlian, but I'll answer to whatever you call me, sir.
You may regret that. So, you've been, when did you start in law enforcement?
Around 93.
Okay. And you were in Orangeburg?
Yes, sir.
You know, back then, I was a solicitor in the Fifth Circuit. I was the prosecutor there. Do you remember that?
I've testified for you a couple times, Mr. Harpootlian.
I thought you looked familiar. So you actually were my witness a couple times?
Yes, sir.
Okay. And I don't know that we're going to have much dispute today, but I'm going to try to understand a couple of things, if that's okay with you.
Absolutely.
So let's understand the wound to Paul, the two wounds to Paul. And as I understand it, you were saying that he was standing how far back when he got shot, the strike that? For his bloody footprints to be there, those footprints had to be made after he had the shot in the chest, correct?
That is correct, yes, sir.
And so how far back in the room were those footprints?
The footprints are approximately, because I have no way, once everything was pressure washed and cleaned out, but looking at the actual crime scene photographs and then taking my own measurements, the placard, the yellow placard that's in the photographs, is approximately at 5 foot. And he was on the other side of, so he was occupying that 6 foot area.
And there were no scales in any of those pictures, were there?
There were not, no, sir.
Let me just talk about this generally before we get to that. You teach a course on crime scene processing?
Yes, sir.
You teach a course on how one should photograph a crime scene?
Yes, I do.
And I'm going to try to oversimplify this. There are basically 2 or 3 things that you want on any crime scene photo. The first is a scale, correct?
Well, there's 3 types of photos. One of those includes a scale. Yes, sir.
Okay. I mean, obviously you don't have a scale if it's a long shot out, like from outside the feed room in. But for something like bloody footprints, you would want a scale.
I would, yes, sir.
And you'd want multiple lighting sources so that it's well lit.
Well, if you operate the camera correctly, you have your light source, and that's why you do it from 90 degrees over perpendicular to the footprint, because you can hit all the angles and then choose the best exposure that takes those shadows out.
So if you do 90, do you recommend taking more than one shot?
Yes, sir, typically.
I mean, at different perspectives of the same item?
Yes, sir.
Okay, so you recommend multiple shots, including one, got to have 190 degree.
If for comparison evidence, you do. Yes,
right.
Sir.
And in the sense of the shoes, the shoe prints you think you saw, they were definitely Paul's shoes. You did that comparison.
Just like with the tire tread, they share class characteristics with Paul's shoes.
And were
yes,
those
sir.
shoes facing towards the front or the back of the feet?
When they were made, it appears they were going toward the door.
Right.
But it would be hard for me to tell you without some kind of mark on that pavement to be able to orient them.
I'm sorry, I couldn't hear that.
Without a mark on the pavement or some type of landmark, it would be hard for me to orient them from the photograph.
Okay. And again, if you'd had a scale or multiple pictures of that one shot, I mean, straight down and multiple pictures, you could have done a little bit more in terms of that, could you not?
An examiner possibly could have, yes, sir.
And the trail of blood leads towards the front door, right?
It does.
And how long was that trail?
Well, if he was in the 6 foot and you got 4 past him, at least 5 foot from where he starts dripping blood, then he steps in it, and then he makes his way to the door.
So you think he was a foot and a half inside the door when he got shot with the second shot?
Well, his feet were inside the door, but his shoulder and his head was slightly outside the door.
Leaning forward?
Yes, sir.
Okay. So the first shot, as I understand it, hit his shoulder.
The second shot is the one that hit the shoulder.
No. I'm talking about, let's talk about
the fatal one.
The fatal one.
Yes, sir.
It hits his shoulder.
Yes, sir.
So based on, now you met with Dr. Reamer, the pathologist.
I did.
And she showed you her photos? Y'all talk about her photos?
I offered to go over the photos with Dr. Reamer, and she told me that she had limited crime scene experience, and that I'd have to determine that she looked at the wounds and she makes her determinations, and that wasn't really her forte.
Okay, so, but she said shot in the shoulder. I'm talking about the fatal shot.
The path, yes, sir.
Into the neck, out the top of the head.
That is correct.
Okay, so, and how, you said you had some difficulty in determining Paul's height.
Well, the DMV record, the printout showed 5'6", and the autopsy information showed 5'9", and I know a young man like that will hit a growth spurt. That's not my area.
But would you consider Dr. Reamer's measurement probably more accurate than what he told the DMV?
Or he could have grown since he registered with the DMV. Yes, sir.
So why wouldn't we just use 5'9"?
So,
I mean, is that fair?
well, but then he's got damage to the top of his head, so I asked myself, how could Dr. Reamer get it exactly right when the top portion of his head's gone? So I had to guesstimate, and I figured the best way to do it is split the two.
And the two were, so you had him at what height?
DMV showed 5'6" on the printout, and Dr. Reamer showed 5'9", so I figured somewhere around 5'7.5" to 5'8".
So 5'7.5".
And then you take the foot from there to the actual wound.
Right, I guess, so where the wound occurs, the initial, I guess it's his shoulder.
Yes, sir.
How high was that?
That was approximately 4'7".
4'7"?
Yes, sir.
Okay. So, just give me a second here. We're going to do a... I hadn't touched a protractor in 50 years. I've done it twice this week. So let's do, if you'd step down here for just a minute, please. Oh, you walk around with one?
Yes, sir.
Really sad. Okay, really, really sad. So why don't you take this for me, and I'm going to hold the bottom. I'll hold the bottom and put a dot on here at wherever the shoulder, the height of the shoulder. Okay, I'm going to take it straight. Want to hook it down there? Okay, and we can. Okay, let me just get it up here to 4. Let me do this. I think you can do this with one of these. 4 foot. 6. 4 foot. We're saying 4'7"?
Yes, sir.
Do you know how to lock it? There you go. Okay. So that's 4'7", right?
Yes, sir.
Okay, let's go straight up. Okay. And that would have been the height of the wound.
That's the height, approximate height of his shoulder, depending on how far he's dipping.
You think it's lower?
Could be, yes, sir. Like I said, when you've got a wound to that side, I would expect him to be favoring that shoulder.
Okay, so what's your opinion of how, I mean, you're the professional, I'm just holding it.
Well, looking at the defects on this side of the door,
yeah,
and it's several of them there, even though they've been pressure washed, if I run a string back in the area of 4'7", somewhere in the middle, gave me a 135-degree angle. That's give or take 5 or 6 degrees.
And that's what Dr. Reamer said in her report, 135 degrees.
I don't know if she said that in her report, sir.
Okay, let me find it.
Yes, sir.
Can you undo that? Thanks. Give me 2 seconds and let me find her.
But that's not absolute. Like I said, a lot of variables could change that a couple of degrees one way or the other.
Couple of degrees one way or the other. Okay, here we go. Make sure I have the right. So well, while I'm looking for this, was there any evidence of stippling, soot, powder, burn, anything? Is soot the same thing as a powder burn?
Soot is a byproduct, yes, sir.
Okay. Around this
But
shoulder.
soot can wipe off. The
Right.
powder burn, the stippling doesn't easily wipe off. It's actually tattooed.
And that would indicate a pretty close shot.
Yes,
right?
sir, it would.
And you would agree, Dr. Reamer said there was no evidence of any of that, any stippling, anything to indicate a close-in shot.
That is accurate.
And she testified, I don't know if you saw her, did you see her testify?
A little bit of it.
Okay. She testified that the muzzle of the gun, the weapon, the shotgun, would have had to have been at least 3 feet away, perhaps 4, but at least 3 feet away. Is that consistent with your experience?
I don't know if that's consistent with my experience. I'm not trying to disagree with the pathologist, but I don't see how the angle would work out unless it was a pretty short shotgun. I don't see that angle working out 3 feet away. It may have been within 3 foot.
Well, how far away was it? There was no. I mean, at what point?
Well, at the angle, the bullet defects would have been here at 76 inches.
Right.
So you've got quite a difference there. If I could get that dowel. You want to swap places with you?
Yeah, I'm trying to find that 135-degree comment by her, but
to make that axis,
yes.
At 3 foot, we're here.
Right.
At 2 foot, we're here. So I believe it would be more in line with 2 foot, but I'm not contradicting a pathologist.
Okay. I know it's in here. Give me 2 seconds. I thought I had it marked. Give me 1 more second here.
Well,
so assume that you said, and you relied on Dr. Reamer's 135-degree shot. Let's follow that down.
now, Mr. Harpootlian, I reviewed her stuff, but I went and measured my own angle on that door now. I didn't rely on her angle.
Well, but she actually, you're going based on where those pellets were.
Yes, sir.
And she would be going on measurements on the shoulder.
Yes, sir.
And she's actually looking at the wound.
Yes, sir.
And she would have maybe a more accurate angle because she sees what the wound is.
She knows the angle to him.
Right.
But she can't relate that to the defect at the scene.
But do you think it's, 135 degrees is basically a 45-degree angle, correct?
Not quite, but yes, sir, close. Yes, sir.
Okay.
Yes, sir.
So it's 45 degrees off of that dot.
I did my measurement from a little bit lower on the door frame. I took my protractor and placed it on the door frame, inside the door frame like so.
So you don't think it's that tall, you think it's down?
Well, that's where his shoulder's at, but the angle of the gun, depending on the length of the barrel,
right,
it would have to be here, because it's not a contact wound, so it would have to be down a little bit, but the angle doesn't change, just the distance changes.
Right, right. So, sorry, standing between. So, but if you come off of this 45 degrees, for the sake of argument.
Okay, for the sake of argument.
Okay. That would show you the angle of whatever hit his shoulder, correct?
As long as the angle stays the same, yes, sir.
Okay. Well, the angle's not
I've got it on 135, by the way.
But 135 would be wouldn't it be 45 degrees off of straight up and down? So don't you have to take it over this way?
Well, you've got 90 in the middle. It depends on where your axis is. You've got 90 in the middle. This is 180. All the way around is 360. So here we've got 135 off of the door.
Going that way. Can you make it go this way for me?
I don't quite understand.
I want the line not going this way. I want to be able to draw it out this way.
You just flip it.
There you go.
And you go above it.
Okay, would you do me a favor? And let me get a ruler for you. Can I have that long ruler, please? And let's take it, just, I'll hold it. Like that. If you'll just get that. Okay. And so, and again, it could be somewhat lower if you turn.
Yes, sir.
But
and that would change the angle. That's why I said approximately 135. It could change it a little bit.
How much?
A few degrees. As well, if you figure if this is 135 and if he's 2 inches lower, that would take probably 5 degrees off.
So that would be 130?
Maybe. If you sit it up there, we'll measure it. I can tell you for sure.
So, okay, what do you want me to do?
You hold the protractor up. There you go.
Except we got to go this way. No?
You had it. You had it. There you go.
But your line's going to go that way.
Which way do you want to go?
I want to
flip it. Flip it. There you go.
There we go. See what? That's why you're the.
No, I got a feeling you're familiar with me, Mr. Harpoon.
You got that feeling?
I got that feeling.
Okay. So that's 135.
Yes, sir.
What do you want to make it?
Well, I'm not measuring it this way. I mean, you tell me what you want me to make it because I measured it this angle.
Yeah, but this is just the flip side of that. Remember how you're talking about the negative?
All right, put it back.
Okay. Which way you want it? This? That?
There you go.
That's 135. What do you want to make it? Oh, wow. There you go.
All right, so if it was, let's say this end was down a little bit, that would make it what? Now you're on the bottom half now, so that changes it. Now we're at 40.
Yeah, it was 45.
Right.
Now it's 40.
Right.
See, I went to Clemson too.
Yeah.
And so, this is sad. So if you make it 40 instead of 45 degrees, what is it?
Here.
Okay, so okay, you want to draw that in? And there's a red pen right on the.
Sorry about pushing in the eye now. It's not intentional.
Okay, so those are basically what you're saying is those are the two possible paths, and there may be one in the middle.
It could be. Yes,
okay.
sir.
Now, and you believe that the shooter was how far away from him with that shotgun?
I think 3 foot is a stretch without having some damage to the door frame.
Right.
Because them shot pellets immediately when they leave the barrel of that gun, at 3 foot, that shot pellet's going to spread 1 inch. There's no damage to the outside of that door frame.
Why would there be?
Why would there be what?
If it's spread how far? 1 inch?
If Paul's shoulder is barely breaching that door frame, and that's what the blood evidence tells me.
Right.
If you are further back, them shot pellets are going to do what they're supposed to do. They're going to open up, and there's no shot damage to that door frame.
Okay.
So,
you recognize it?
Yes, sir, from photograph.
And it's a Benelli shotgun, is that right?
Yes, sir, it is.
Okay, so
I prefer to put on gloves. I have some. I have some.
Okay, would you take that shotgun and, unlike these boys back here, I don't mind if you point it in my direction. Okay? So if you take that, the muzzle of that gun and follow the line down, please. And let me turn this just a little bit so this mirror back here can see. Okay. Follow this down. Either one of those down. So that would be the position the shooter had?
That's the angle. I mean, I'm on the opposite side, you know, of where the shot came from, and I don't know the length of the barrel, but that would be the angle.
If I'm standing, I'm standing in the door, why is that the opposite side? Bent down a little bit. I don't understand what you mean by the opposite side.
The shot came from over here. It didn't come
Well,
from...
this is a two-dimensional representation of a three-dimensional, but I'm trying to figure out just the angle from the muzzle.
All right, if you're coming out of the door,
right,
and you got damage to your right shoulder,
right, there you go.
instead of your left shoulder,
same.
All right, turn this way.
Okay.
And that is the door frame.
Right.
Was here.
Right. But and that distance there is how far from the barrel to
2.5 to 3 foot.
That's not true, just to be. So actually, that is.
I'm going to your shoulder now.
Okay.
You got to turn. You got to turn. Yeah, you got to turn.
So that is about 24 inches.
Well, you step closer, but yes, sir, about 24 inches.
Again, we both want the crimson. Okay. So this is getting complicated. So what you're saying is, whoever shot him was holding the shotgun that low?
Really low, yes, sir. Not from the shoulder. From some position other than the shoulder.
Why? Wouldn't it be easier just to go boom right in the head?
Sir, I can't figure out why people do what they do.
Well, but I guess, okay, so the person with the shotgun has just shot him in the chest, and he would have been turned to the left, and that would have gone through under his armpit, out the window.
Right.
Okay. And then he shuffles over to the right of that position?
Toward the door.
Towards the door.
Yes, sir.
And then whoever has just shot him, you would agree with me, the first shot was inside the, the shooter would have been inside the feed room for shot number one.
At least to here. If this is the door frame,
right,
the ejection port of that shotgun was in at least this far.
And how far back was he in the room when he got shot?
Paul?
Yeah.
Just on the other side of the 5 foot mark.
Okay, so how far was it from that 5 foot mark to the door frame?
5 foot.
Yeah, no, but I mean, how far would the barrel have been if that was just inside?
Well, it depends on the length of the shotgun.
Assume that's Benelli, whatever the name.
If this represents 5 foot,
right,
and I've got the ejection port inside the door, what, 2 foot? I mean, you don't want the ruler, but 2 foot maybe.
Okay, so I'm going to move this way so it's even with me. That's that candy dish. Thank you. So this is 5 feet, right?
I don't know what you're saying, but this is the door. It'd be easy to measure it like that.
This is actually 6 feet.
So if it's,
no, that's 5 feet. No, 5 feet.
for demonstrative purposes, if it's this gun, right, and that breach is inside, so that's what? How far are you? I can see that.
I'm at 5 feet.
Okay. Just a little bit behind 5 foot, because he's occupying that next foot. There you go. So how far is that?
This is 5 feet.
Okay.
This is a little bit back,
Yes,
5
sir.
feet.
Now can't your body?
This way or
Yes, sir.
this way? Okay. What do you mean? Turn my feet?
Yes, sir.
Okay.
A little bit more.
Okay.
Right there.
Okay. Now, and you're shooting me in the chest.
Yes, sir.
And the distance between that barrel and my chest is, well, that's 29, 30 inches, 30 inches. 30 inches, that this says to me, 30 inches.
Yeah, with this shotgun.
Okay, right. And so I would get, I mean, just a minute ago we said at 36 inches, or you said maybe it was closer. I mean, is this consistent with Stifling?
Yes, sir. Within 5
Okay.
feet. Yes, sir.
Okay. And when we had it before and you were shooting up at me, it was about the same distance, maybe six more inches between the barrel and me, right?
Mm-hmm.
And there's no stippling.
Okay.
Okay. You're the expert. What does that mean?
Well, he also has, I don't know if I can answer that.
Could it be? Well, I mean, on that first shot, we know, you say that he was, you say he was the whatever you call it, thing ejects. What's it called?
The ejection port.
There you go. The ejection port had to be inside the room.
Yes, sir.
For
The second shot, now all it had to be is pointed towards the room.
Why?
Because it's going to eject to the right. So if this is the door frame and I've got the ejection port pointed toward the room, it's going to eject into the room. The first shot, because it was straight on, had to be at least past the door frame.
Right. But the second shot, if the ejection port was
pointed toward the room,
pointed towards the
I
room,
could be this far away from the door, the second shot, and the ejection port would still throw it that direction.
So doesn't that change the calculation here on how far away that gun was? Because the ejection port on this, is that it down there? Where is it? There it is right there. The ejection port is, who you disagree with me, about 28 inches from the barrel.
On that shotgun? Yes, sir.
Well, assume this was a possible shotgun, although it doesn't match up with the ejected marks on the shells found in the feed. But there's some theory that this would be about the same shotgun. So you would agree with me that the shooter would have been, how about show me again how low they would have been holding this?
Other side, but here.
Down.
Well, I mean, I don't know how long the arms are. There's a lot of variables there, but, you know, it could have been here. It could have been here. I mean, I can't tell you the mechanics of it. All I can look at is the angle.
And that angle, you would agree with me, is an unusual angle. Typically, people shoot a shotgun from their shoulder.
Typically, unless you and I are both occupying nearly the same space.
Wouldn't there be stippling or powder burns or some?
I can't explain that.
Well, okay, so you can explain it. I'll take that answer.
Yes, sir.
But it would be inconsistent for them to be that close, wouldn't it?
Well, you figure if Paul made it to the door, whoever fired the first shot could have retreated or could have backed up, better word for it, could have backed up or even was taking cover to see what was going to happen. And then I believe the angle would fit or could fit that two persons could be that close to that door frame.
Hand me the weapon again, please. You might want to step that way. Well, you're blocking the dirt.
Oh.
That's better. So we both agree that the first shot is square into his chest.
Well, I can't say square, but it's directly on. Yes, sir.
Okay, which is at shoulder height. Boom.
Well, it could have been shoulder height. It could have been like I was holding it just now. No. Before. I mean,
I'm sorry.
It could have been. It could have been here. Could have been here. I mean, I can't tell you the
But he's holding,
mechanics.
whoever's shooting him in the chest is holding it
Parallel to the ground or
Parallel to the
near
ground.
parallel.
To the ground.
Yes, sir.
And we know it wasn't down here.
I don't believe so. No, sir. Not the path of the bullets going out the back window.
Okay.
The pellets, not bullets.
So either at his shoulder or just under his shoulder. Now, a shotgun has a pretty good kick to it, doesn't it? Buckshot?
Yes, sir. Pretty decent.
So I guess what I don't understand, and you have no explanation for it, is why the second shot would be like this. I mean, we agreed the normal height person would have to crouch to make that shot. Correct?
I don't know where they wanted the end of that barrel placed, Mr. Harpoon. I can't tell you that part with my science. I can't. All I can look at is the angle.
Which is about like this.
Well, it's here, but in reverse.
Which is about like this. Correct? The barrel would have to be, okay, like that. But you would agree with me, I'm bent over to do that.
You are. Yes, sir.
So the shooter was a very short person?
But here, I'm not bent over that far, and I'm almost 6 foot.
But what, I don't understand. You go ahead and take a stand. I don't understand what circumstance would cause a person to, you might want to move that one over, to do this or this, and then immediately do this or do this to put that second shot in.
Objection, asked and answered. You simply should understand. The question is.
The question is that your position is that the first shot was like this, and the second shot would have been like, if I'm standing up straight, like this, not a very good aim, or crouched down. If it's a normal sized person, right?
The first angle was almost parallel with the ground.
Right.
The second angle was somewhere between somewhere around 135 degrees from the door frame. I can't tell you the psychology of any more or any less.
So what height was the entrance wound on that chest?
On the chest?
Yeah.
Approximately 4'3" or 4'4", I believe, according to the
4'3".
Yeah, 4'3", 4'4".
Because that would have been below the shoulder wound, right?
Yes, sir.
So it'd be, let me see how that works for me. Maybe this will help us. Two, 3, 4, 4 foot. You think 4'3"?
I'm fairly certain. Yes, sir.
Did you trust me? That's 4'3"?
I believe. Yes.
Okay, and I'm about 5'10" on a good day. So that would be about right for me, wouldn't it?
Yes, sir.
Okay. So that first shot, if it was on that person's shoulder, if they put it on their shoulder, they would have been approximately. Was there any way to figure out?
I don't know a scientific way, Mr. Harpootli, unless you had a tripod that you could hold the gun and shoot it many times, the actual gun, and measure it. I don't know the scientific. If it is one, it's way out of my purview. I look at the angles, and I look at the damage, and I develop my angles. That's what I do.
Okay. Okay. I think I'm done with the gun. You can have a seat.
Can I take the gloves off, or we could do this again?
Objection, asked and answered.
I think we're done with the gun, but I got to tell you, that's not being. So, and I don't think I need this anymore, Mr. Barber. I'm sorry. Were you able to find what I wanted? Where is it? Okay, so let me go a couple other places with you. You were hired on. Were you hired on December 22nd?
I think it was in November when I first got to review the evidence, and I think I was hired in October. I can't tell you the actual date on my retainer, but it was several weeks after that before I ever got access to evidence.
Okay, so you read a crime scene reconstruction done by a guy named Bevel from Oklahoma, did you not?
I did refer to, I did read that, yes, sir, but I did not depend on that to make my determinations.
No, I'm just saying,
okay, yes, sir.
For purposes
I did review that, yes, sir.
Okay, and do you remember when he generated his report?
I don't, Mr. Harpootlian.
Would it surprise you if he generated it in 2022, early? Several months before you even asked, right?
Yes, sir.
Okay. And you were their second choice?
I don't know if I was their second choice. I was a choice.
Okay. Let me make sure I understand the date of Mr. Bevel's report. So he issued a report in March of 2022, and you were not asked to get involved until October of 2022.
I had a phone call early, shortly after. I don't even remember who I talked with, but someone called me shortly after the homicides and asked me if I would mind taking a look at stuff, and I said I'm always available to help if I can.
Okay. Now, the other things that you looked at, let me just make sure we understand what you looked at. You had a David Green recording of June 7th, 2021. You remember looking at that?
Body camera, yes, sir.
Right. And in that body camera interview, when they talk to Mr. Murdaugh, he indicates the phone had fallen out of Paul's pocket when he tried to check his pulse, and he put it on. It didn't explode out of anywhere. He put it on that picture that you introduced just a moment ago. He put it on his rear end. Correct?
It may have said that in the body camera.
So there was no exploding out of any pocket, right?
I don't believe it did, and that's what I said. Someone other than Paul put it there.
Okay. Now, you had a SLED crime scene investigator summary. Was that by Agent Worley?
I read several SLED reports, but Agent Worley's report was one of them. Yes, sir.
Okay, and you digested everything in that report that was relevant to your inquiry?
I read those reports just so I have the knowledge of it, but what I can work out on my own, even if it contradicts their results, I like to make my own.
For instance,
conclusion.
She had very distinct measurements on shell casing location, right?
Yes, sir, I believe they did.
And you relied on that, certainly, in looking at shell casing placement.
When you say shell casing, are you talking about?
I'm talking about where the Blackout 300 shell casings were.
I looked at the path. I did not look at the measurement per se because, like I said, the shooter moving, the victim moving, not having the rifle and be able to say exactly where it throws that shell casing, I don't get too involved with that. I'll look at the general path where they're at, but as far as so many feet, so many inches, I don't pay a lot of attention to that.
And I'm not asking you that, but it would show you the path of the shooter, would it not?
Well, like I said earlier in my testimony, it could or it may not. You can't look and say a shooter started here and ended here because he might have went from here to here and back to here.
Well,
So
let me rephrase that. Not necessarily the path, but at least you would know generally where the shooter was during, if you look at the coagulation of all those shots. For instance, what we see, if you remember correctly, is a number of these shell casings. There's one sort of back on the gravel road, and then all of the rest of them are located in a fairly small area on the grass, and then there's one under her, right?
yes, sir.
Okay. And that would show you, at least generally, I mean, the one under her had to have been a shot that was fired while she was upright and fell on it, correct?
I would agree with that assessment.
Okay. But it'd give you some general idea where the shooter was. General idea.
General idea, somewhere within 5 foot, 5 or 6 foot, knowing what I know about those rifles, it's not going to throw it 20 foot or 30 foot. It's going to be confined to that area, and all I can do is probably put a general perimeter within, a couple yards at the most from Miss Maggie Murdaugh.
Did you look at the autopsy report?
I did, yes, sir.
And the autopsy report, Dr. Reamer indicated the angle of the shot, we talked this to death, was 135 degrees.
I really wasn't aware of that, but I look at the photos more than the report part.
Okay, hold on one second here. Let me see if I have it. Let me ask them to find something. Your Honor, pardon. Let me ask you what else you looked at. And you list a bunch of things here. You looked at lab photos of victims' clothing, trace reports, DNA, CS. What's CS photos, evidence processing? What's CS mean?
Crime scene. Yes,
okay.
sir.
So you looked at the crime scene photos. There were 449 of those, or at least the ones that were relevant to your look, what you were looking at, right?
Yes, sir.
And a number of interviews with people, right?
I had access to it. I may have looked at some of them. Yes, sir.
Okay. Now, let me ask you this. Does the wound on Paul's shoulder indicate to you how far the shooter was? I mean, what was the spread at that point?
Your typical full choke on a shotgun, and it depends. Once again, it depends on the choke.
Right.
At 3 foot, it's going to spread 1 inch.
Okay. Well,
with an improved choke, at 3 foot, it's going to spread 1.75 inches. So I don't know the.
Well, you looked at the autopsy photos, right?
I did. Yes, sir.
Was the wound on his shoulder bigger than 1 or 1.75?
It's a massive wound. I mean, it's massive, but a lot of that can be taken into the angle too, Mr. Harpootlian.
Did you look at the x-rays?
I did, yes, sir.
And there's a whole bunch of pellets in his shoulder.
Along the path, yes, sir.
Along the path. Mm-hmm. But wouldn't it indicate that the spread of those pellets is significantly more than 1 inch or 2 inches? Like, I think we determined it was about a 6-inch spread.
Well, I don't think with the angle it would be possible for someone to be 12 yards away and shooting up that direction. So obviously that's got something to do with the close proximity and the way those number twos work.
So, do you have an explanation for why the spread would have been that big based on what we just did? I don't want to pull the shotgun out.
I'm not a firearms examiner, Mr. Harpootlian. I'm just familiar with how they work.
And so your position is that spread is not inconsistent with what you've testified?
I do not believe so. I have had people shoot themselves in front of me, and I have worked a number of crime scenes where I've seen the same damage.
Okay. So, okay, here we go. I knew I'd seen it somewhere. This is your report.
Thank you.
Okay. Let me ask you, did you say Paul's height of 5'8" and the sharp angle upwards, approximately 135 degrees, I know I find it, support that Paul's left side was dipping slightly, head slightly forward as he was standing or exiting the feed room at the time of the second shot?
I think that's what I testified to, yes, sir, and that's still my findings.
Okay, I just want to make sure that this 135 degree thing I didn't imagine. That's what you said, right?
Well, that's what I was saying. I was hoping you didn't say I copied someone else, but yes, sir, that's my measurements.
Okay, so you also said the length of the shotgun would be needed to a reasonable degree of certainty, but it's unlikely the shooter was standing with a shouldered weapon at the time of the second discharge. We've already established that, correct?
Yes, sir.
They would have been crouched or holding it down in some awkward position,
yes, sir,
rather than having it up to their shoulder. Also, let me see if I can finish this. You don't have, you do, in your opinion, IQ 7, it is my opinion that the exact position of the shooter cannot be determined in relation to Margaret, correct?
Yes, sir.
Do you have the most accurate information available to narrow down the position of the shooter's position is the physical location, position of the deceased, bullet path of known wounds, stippling, or lack of physical damage caused by those wounds? So you came across no data that would allow you to determine trajectory with any degree of certainty as to Maggie?
No, because the victim and the shooter could possibly have been moving. So it's no way, to my knowledge, scientifically, to prove either one. Okay,
and I guess that wasn't my question. My question was, you saw no data in the material you looked at that would allow you to do that?
Other than the pathologist measuring the angle of her stomach wound and her thigh wound, and they were very similar angle, that's about all I can tell you, Mr. Harpootlian.
Okay. And let me deal with a couple of issues. Let's go to the what you testified to about the impression on her leg, right?
Yes, sir.
Now, this again, was there a photo taken of either her leg or the tire that you're talking about that would have been what you would expect if you were trying to make a comparison, that is a 90-degree shot of it, either one?
And no, sir, and that's why I explained that I can't call this to the exclusion of all others. If I was going to make an absolute identification, I would require a scale photograph.
Right, and there's no scale in either one of those.
No, sir, but I got it close, but still not close enough for me to call. I used the scale at autopsy that the pathologist used on the back of Miss Margaret Murdaugh's leg, and I went and did research on the tire, and I actually know the type of tire, and the only problem is it comes in a 9, a 10, and an 11-inch front tire, so I have no way to scale that without the actual tire.
So you're not telling this jury that it's your opinion that tire caused that impression on the back of her leg?
What I'm telling the jury is that is a class. They share the same class. It's called an association. And in my opinion, either that tire or a tire just like it caused that impression.
Well, let me ask you this. By the time it got to the autopsy, her leg, whatever mud was on there was washed off, right? There was no, in those autopsy photos, all you see is a bruise, correct?
That is correct.
Okay. And so the only evidence you have is that there was some mud stuck on the back of her leg with those specific details, right?
It's an impression in mud, yes, sir.
Okay. When you looked at the tire pictures, was there any mud on them?
There are, specifically those treads, and like I pointed out earlier, you can actually see unique random characteristics. In a perfect world, if I would have had a scale myself, I would have called that all day, and my technically reviewer would have called it all day also, but I'm not allowed to do that.
You're not allowed to do that because you may be close, but you can't say with affinity that tread caused that defect on the
What
tire.
I can say is that, in my opinion, that impression was created by that tire or a tire with similar characteristics.
Did you look at any black and white images of that what you call a tire impression or mark on the back of her leg?
I did. I made it black and white. Yes, sir.
Okay. So, okay. You can go round and round about how sure you are, but I'm not going to do that. Let me ask you sort of in not closing, I have a couple more shots, but a couple more questions. We'll strike that. Let me check one thing with my folks over here, and I'm probably done.
Can I stand for a moment, please? Your Honor, thank you.
Somebody stand over there.
Okay.
And you remember?
Yes, sir. Just real quick. Couple things real quick. You were contacted by SLED to do a review of this case, is that correct?
Yes, sir, it was.
And were you told any particular conclusions to come to, or did you do a fresh review and then arrive at your own conclusions of your own independent judgment?
Every conclusion I came to was in spite of any pre-existing conclusions. I made my own conclusions.
You're asked a little bit about the tire mark impression, and were you relying on the crime scene photographs of Maggie Murdaugh at the scene?
Yes, sir.
And did you see mud, which is the impression that you examined?
It is. Yes, sir.
And from your review of the crime scene, was there any other ATV in the vicinity of where Maggie Murdaugh was found, except that tire you looked at, the picture of it?
That's the only one I observed.
And you said it either had to be a tire, that tire, or a tire with similar characteristics?
Yes, sir. That's my opinion.
On the ATV that was at the scene?
Yes, sir.
You were asked a lot about shell casings, and you pointed out that they can be thrown different feet and can move around, and shooters can move as well. Is that correct?
That is correct.
The shell casings, though, that were they located in this area around the feed room as to where Maggie Murdaugh was found?
They were.
And you said them shell casings ain't going to get thrown 30 feet, right?
No, sir. Not in my experience.
In your experience, having done 850 homicide scenes, can shooting events be fluid situations?
That's death scenes, but the answer is yes, sir.
The victims can move?
Yes, sir.
The shooter can move?
Absolutely.
People can change their aspect of how they're positioned at any given time?
Because of the moment.
Well, if I can get to it on that easel, y'all went through the whole thing, and drawing and all the rest of it. But what y'all were drawing, that was actually reversed from how everything happened. Is that correct?
It was.
And if this were the door to the feed room going out to the outside and I was standing in it, which direction was the trajectory of the shot to Paul's head?
Where I'm at, up at a 135-degree angle.
And what did you observe up here?
I observed body fluid, a concentration of body fluid as a result of a gunshot wound.
Defects in the door as well?
Absolutely.
And what's a defect? What does that
A
tell me?
defect is damage caused by a projectile, whether it be a pellet or a bullet.
That easel drawing y'all did, that was reversed from the reality of the situation, correct?
Yes, sir.
All right. And that easel also was slanted as well, was it not?
It was.
And if it were actually standing straight up, that dot y'all were marking would actually be higher than it was when it was demonstrated to the jury. Is that correct?
Yes, sir, and that's why you use approximate, because I can't tell you how Paul was positioned. I can only go by the angle.
All that stuff that you and Mr. Harpootlian did with the easel and the shotgun and all the rest of that, does any of that change your opinion about what happened to Paul on the night of June 7th, 2021, when he was fatally shot in the head?
It does not.
Thank you, Your Honor. Nothing further.
Just one additional question.
Ms. Barber, please.
We agreed that what I did there a moment ago with the easel was a mirror image or a negative of what actually occurred, right?
It was the opposite side of the door, yes, sir.
Go get in the door, please. Mr. Barber, in the interest of justice, has allowed me to point the shotgun at him, Your Honor. It is. So we agree that if he's standing in the doorway, the shooter would have had the shotgun, and how about turn a little bit to your, turn that way?
A little
bit more?
Yes, sir.
Okay, the shotgun would have been about like this.
About here.
About like this?
Yes, sir.
Okay. Okay. So that's the trajectory. That's where the barrel of the shotgun would have had to bend.
In my opinion, yes, sir.
Okay, thank you. No further questions.
You may step down. Thank you. Yes, sir. Ladies and gentlemen, we're going to break for lunch at this time. Members of the jury, I'm appointing juror number 826 to be the foreperson of the jury. The foreperson has the responsibility of serving as the spokesperson for the jury from this point forward. Will have the responsibility of presiding over the jury deliberations, and will have the responsibility of completing the verdict form representing the unanimous verdict of the jury when we reach that point, and also sit in the first seat, which is the seat designated for the foreperson. Understand? All right. Very good. We'll see you all at 2:15.
Remain in order! Order!
Not come to play with Dick Harpootlian. Slick Dick thought that on cross he was going to confuse him, ruin his swag as an expert, but he did not allow it. He was not here for it. Everything he said, he stood by it. He gave an expert opinion, and he did not allow himself to be shaken or intimidated by Dick Harpootlian, as he always does. He does an exceptionally great cross, and he usually leaves the people really sad, like the person yesterday that he almost had in tears. But not this guy. He wasn't here for it. He came to slay, and that he did.
Yeah, Dr. Kinsey was very confident in that cross-examination. Holly, what did you think? And did you think that Dr. Harpootlian was, Harpootlian was able to wear him down, or no?
Not at all. This was an imprecise cross-examination, which means that this is the perfect expert testimony that you're looking for as a trial lawyer. So this expert, Dr. Kinsley had authority over the courtroom. Not only did he have authority in his testimony, he was able to recall specific measurements all throughout this cross-examination. But he was also the authority on the own tools that Mr. Harpootlian was trying to use. This witness became not only the authority for the prosecution, but on cross-examination, he was the person that was teaching Mr. Harpootlian how to use a slide rule or a tape measure, which is just silly. I don't know if this was an ill-timed, I don't know if the defense was ready for this particular witness in the morning, but to me this seemed rushed. It was a very imprecise cross-examination, and while most defense attorneys try to confuse the jury and the witness through their cross-examination of an expert, it did not work at all. So this was model expert testimony, but it really is all credit to this particular witness. He's a pro, and I thought it was a terrible fact that was elicited by Mr. Harpootlian at the very beginning, that this is a witness that even Mr. Harpootlian has used before. So he's good enough for the defense and good enough for the prosecution. This is a perfect witness.
Well, Holly, one more thing here. What do you think a jury makes of Dr. Kinsey's testimony, since he was not at the crime scene at the time of the murders? He reviewed this evidence in 2022.
He's such an expert. We spent so much time on his credibility and all of his experience testifying. We know that Mr. Harpootlian himself has trusted his judgment before. And what I hope the jurors know is that in these situations, you don't have everybody with personal knowledge testifying in this case. Oftentimes you have to have an expert that looks at the information generated by people who were there at the crime scene. So because he had so much authority, because he was so educational in his testimony, I think the jury is going to forgive the fact that he was not there at the crime scene on the day and the night of the murders.
Marie, did you think he was so knowledgeable that it didn't matter to the jury?
I think he was so knowledgeable that it didn't matter to the jury. And I think he was unshaken by Dick Harpootlian. And like I said, he did not come to play, he came to slay. And he really nailed it as far as keeping his opinion and not letting Dick Harpootlian push him around and make him lose his expert witness swag. He kept it all the way.
Now, Marie, I know that you're not one to ever be afraid to express how you feel here. One thing I also found very interesting is, the props that were used, the shotgun and also the measurement tape. They were really, Harpootlian was really trying to reconstruct the scene in front of the jury. But, Dr. Kinsey wasn't having it. Do you think that the jury was shaken by the fact, with all the trajectory talk, number one, and number two, trying to get Kinsey to kind of rattle himself with the angles?
I think, like Holly said, Dr. Kinsley was unshakable. He was such an expert, even though he didn't physically go to the crime scene, he handled Harpootlian like he should. And nothing Harpootlian did took away from his credibility because he was so well educated on what he was saying. Like Holly said, there was nothing Harpootlian could do to dissuade him from the credibility that the jurors know by now that he has.
Now, Holly, earlier today, the judge reversed the decision to allow evidence from 2021 of the roadside shooting by Curtis Edward. That's cousin Eddie Smith for you viewers. What do you make of that? Do you agree with that?
I thought that it was great for appellate purposes for the judge to rule against the prosecution at first, but I really like how when the door was opened by the defense attorney, the judge revisited this, because what we found in the cross-examination by the defense that opened the door is that the defense is trying to use certain facts, like the fact that Alec was addicted to drugs and had his cousin as a go-between between purchasing drugs and all of this mischief and attempted fraud and murder. And when the defense is trying to use those facts as both a sword and a shield by saying, I want to promote these facts to blame these murders on someone else, but yet I also want to shield these facts when the prosecution wants to introduce it about my client's bad behavior, you cannot do that. I think that the effect of this court's ruling, basically reversing the original ruling that this evidence could stay out, is going to be very, very fatal for the defense. I predict that the jurors are going to see this as highly prejudicial, and they're going to draw a line between Alec's bizarre behavior, his ability to hire people to kill him or others for financial gain and for money purposes, and they're going to take that instance on that roadside and they're going to use it to convict him. So I think it was a fatal error to attempt to try to use the same facts that they were trying to keep out as a way to explain some sort of random murder or gang murder to deflect attention away from their client. I think it's fatal.
Marie, what did you think of that decision?
I agree 100%, and I think it was fatal that they opened that door, and you know what? Holly put it in a fancy way, but they done messed up now.
All right. Well, thank you, ladies. This has been a great discussion so far. I do want to thank Holly Davis for joining us. We hope to see you again. But when we come back, it's time for our lunch Q&A with Anjanette Levy, Gigi McKelvey, who is down in South Carolina, who has been covering the trial for us. She will be there as well to answer all your questions, so get them ready. We're going to take a quick break. More from South Carolina in a moment.
I'm Anjanette Levy, and thanks for joining us here on Law and Crime. We are in the lunch hour in the trial of Alex Murdaugh, the double murder trial, and we are taking your questions live as we always do. So submit those to us on social media, on Twitter, in our YouTube chat. Some have been coming in on Facebook as well, and we will get to as many of them as we can. But first, we want to check in with Gigi McKelvey, who's been in that courtroom every day in Colleton County, South Carolina. Gigi, I am really wondering what's been going on in the courtroom this morning, especially with Dr. Kinsey's testimony, and what you think the jury thought of his testimony.
Well, they're very focused on this testimony. I think a lot of it is because it's very visual. They haven't had a whole lot of visuals as far as the evidence goes. They're paying very close attention, and I think it also gives a little bit of life to the moments of the murders where he's demonstrating the angle the shooter would be and is using the dowel to act as if it's a gun. So I think it kind of brings that moment to life, which, you know, adds a whole other layer of just how terrible these murders were.
And it's horrifying when you hear, you know, we had to hear about it again, how Paul was shot, obviously knew what was going on because he was still alive, still standing, takes steps, he believes, toward the door. And just that whole thing with the angle, Gigi, just thinking about how that happened and then hearing about how Maggie Blakely was shot and passed away is really upsetting. And just the thought of somebody being able to carry that out is horrifying. Did you see anything on the jurors' faces, any reaction as they're taking the shotgun and this whole thing is being acted out? And, you know, the whole thing about Paul's head, possibly he's dipping down. I mean, I was just watching that, was just really brought a lot of images to mind for me.
Yeah, I mean, there wasn't any huge reactions, but more, you know, just as sort of sympathetic looks on some of the faces of the jurors, as if, you know, it gives you a visual. It's almost like you can see in your head how this happened for the first time. And I think that brought it to life. You could just see several jurors were kind of feeling sorry, I think, in their heads for Paul and Maggie.
It's hard not to feel sorry for them. It's horrifying to think about what went on that night. Marie Pereira is here with us, former prosecutor, currently a criminal defense attorney, and Chris Adams, an attorney in South Carolina, is with us as well this hour as we take your questions. So let's get right to them. The first question is from Jay Howard. Do you think that Maggie and Paul saw the person who was shooting them, or was it too dark at the kennels? Chris, what is your feeling on that? We've seen some photographs that showed some lighting was on at the kennels that night.
It appears that they may very well have seen that Paul definitely and perhaps Maggie saw the shooter. There was a lot of back and forth with the witness this morning about where the shooter would have been, and according to that witness, the shooter would have been somewhere in front of Paul before the fatal shot was fired. So it does appear that he would have known who was shooting him.
And what did you think about this whole angle that was discussed as at the end, toward the end of the testimony, where, you know, he's basically saying that this shooter, Dr. Kinsey is saying the shooter almost had to be crouched down with the shotgun to take that second shot. Did you have any thoughts on that, Chris?
I'm not sure how this fits into the state or the defense's theories of either prosecution or defense. It's an interesting development, but I'm not sure of the significance. I'd love to get your opinion and Gigi's opinion.
Yeah, I'm not sure either. And I guess in my mind, this is where my mind goes, because I've tried to run this through my head many times as to how this could have gone down based on what we are hearing in court. Alex Murdaugh is obviously a tall guy. Gigi and I have been in the courtroom with the guy, you know, from a distance, and he's not a small guy. So you're telling me he had to crouch down? I don't know, but I've never done this. You know, I've fired guns. I've never fired a gun at a human being. So, Gigi, I don't know what your thoughts are. Obviously, we'll get Marie's thoughts too.
I mean, I just don't know. It kind of.
Oh, Gigi first, and then Marie.
Did I misspeak?
You're good, Gigi.
Yeah.
Go.
So I don't know. I mean, it's been a little confusing. It's hard for us to see where we are, the angles that he's crouching down at, but I mean, yeah, I mean, he's 6'5". That's pretty tall, but then I heard somebody on the way out say, it kind of makes me think, was there a second shooter? Because you had two types of ammo. So did you have somebody in one spot and then somebody somewhere else? So I think Harpootlian got everybody a little confused with what he was trying to get at.
He's probably trying to get at something with his expert, but your thoughts on that, Marie, about the trajectory or the angle that this had to take place from, or being, a shooter crouched down?
I agree with everyone else. I thought he didn't really make his point on cross-examination, and I thought Dick Harpootlian, his job is to zealously defend his client and poke holes, but I think him trying to insinuate somehow that there was a murder-suicide situation was insulting to the jurors, and it sort of looked really desperate, and I don't see where he's going with it, and it left me confused, so I could imagine it left the jurors confused as well. I think he might have focused more on a double shooter scenario, but he touched base on a murder-suicide scenario, and I thought that made the defense look very unlikable in the eyes of the jurors, because it made me say, okay, really, you must be really desperate if you're going along this angle.
Yeah, and I just don't see how that's possible. I guess anything's possible, but that seems highly unlikely to me. And even the other day when he was talking about that, I thought he was just talking about the whole contact wound versus not a contact wound. So let's get to some more questions. Kat Walker from Facebook. If you believe after listening to Paul's video that Alex was at the kennels, then there are only two real possibilities. Alex, too, would have been murdered along with his wife and son, or is he the killer? How many on the panel believe it is Alex Murdaugh's voice on the video? I think I know what all of you guys are going to say to that, but what do you think about that question, Chris?
I don't think the defense has contended since opening statement that that's Alex's voice on Paul's video, but there is still a window of time. The state is focused on and says the time of death is somewhere right around 8:49. I believe Paul had a call at 8:44 that lasted 4 minutes, and after that, no phone calls or texts were answered or responded to by Paul or Maggie. And that's how they come up with 8:49. And Alex seems to have gotten in his car at 9:06. I think there are questions in my mind. I have plenty of calls that I don't answer and texts that I don't return, and it doesn't mean that I'm deceased. So I'm not sure how solid the state is on anchoring their timeline around 8:49. If the shootings did occur at 8:49, then it's going to be hard for Paul not to be at the kennels, or at least within earshot of hearing the guns. But if they occurred later and the phone calls just weren't returned, to me, that's still a fair conclusion of the evidence.
Well, and there's been all this talk, too, about, the cell service not being great down there. Rogan Gibson, he tried to FaceTime him. It wouldn't go through, so that's why he did the video. And I don't know about you guys, but there are a lot of times I keep my phone on silent and forget to turn the ringer on. I do it all the time. And I just keep it on silent because I'm working, and I don't want the disruption or having it ring on the air. Not that people are doing that, the same thing I do, but it is something. This next question I think is a pretty good one. Linda Golden asks, has anyone shown the kneeling position of a hunter/shooter outside the door where the second shot was fired from a low angle? Again, I've fired guns. I've never hunted or fired a shotgun to hunt something, but is that a common stance? Marie Pereira, do you know of maybe kneeling down to shoot something with a shotgun?
I don't think it's an uncommon stance, but I think the angles at this point don't matter, at least to me. I believe that Alex Murdaugh may have not physically committed the murders, but I believe he was involved in it and knows more than he's saying. That's what I believe. Angles don't matter. Two people are dead, and I think he knows exactly what happened and is just not saying what happened.
That's interesting that you think he knows or was involved, and that's something that could be one of the many possibilities here. Did he know, or was he there? Gigi, have you heard any scuttlebutt about that at the courthouse, or is anybody thinking maybe that he knows what happened, was possibly present? but maybe didn't pull the trigger. I know Dick Harpootlian is saying this is two shooters, or at least that's what they're trying to say.
Viewers that have approached me and we've had a little chit chat about the case, it's kind of mixed. I mean, a lot of people do feel that way, that there's just isn't anything tying him to the actual murders, but the circumstantial evidence certainly puts him there in that time frame. So yeah, that is something I've heard by professionals and just members of the public who have sat here through these proceedings, that it's very possible he wasn't the trigger guy, but definitely set it up or knew what was going on.
And something we haven't talked about, guys, just yet, Gigi, let's get that back to you, and then we'll go around the squares real quickly. You know, the decision today by the judge explaining his decision, I thought for sure that Jim Griffin on purpose brought up Curtis Eddie Smith, cousin Eddie, yesterday during the cross-examination in order to, you know, open the door. And he's saying today they didn't open the door. You know, it sounds like, I thought maybe this was like some 3D chess move. But your thoughts on that, because the roadside shooting is now coming in.
Yeah, I mean, I thought it was strategic yesterday. Maybe he slept on it and woke up and said, oops, that was kind of a bad idea. Who knows? But I have not seen his lawyer, Eddie Smith's lawyer, here today. So it doesn't look like at this point that he's going to testify today, at least from what we know, unless it's kind of a surprise.
Yeah, and I'll just tell everybody, just so we know, everybody knows, I spoke to his lawyer this morning. She is actually at the jail with him right now, and she said that she's concerned for his safety. And that's what she said. She wasn't planning that he would be transported to court or anything like that. I don't think the prosecution wants to call him. But Chris, she is concerned for his safety, and she is at the Lexington County Jail with him right now, where he's been in protective custody ever since he was booked in there. So she's worried. She said she's worried about somebody trying to harm him, to him being influenced by somebody related to the Murdaughs. Your thoughts on all of this?
So it's interesting. One of the things that's really changed over the time that I've been practicing law is what it means to be a cooperating witness for the government. In the old days, at least in friendly, sleepy South Carolina, there weren't really acts of retaliation against state witnesses. That's changed. And now there are threats, and there are people in jails and in custody who would like to make a name for themselves in jail by intimidating or perhaps taking aggressive action against a cooperating witness. And that could be 100% beyond any control Alex Murdaugh has. So it wouldn't be something that Alex Murdaugh is engineering or doing, but there could be a legitimate threat to somebody in custody who's very high profile, who may be testifying for the state.
Well, she's concerned about it, that's for sure. And it doesn't sound like the state wants to call him. It doesn't sound like they will call him. They've already said they can call this other guy, this agent Kelly, who was the lead on the roadside shooting. So we probably won't hear from him or see him, but she's obviously concerned about him. We are going to take a quick commercial break, so keep your questions coming to us both on Facebook, Twitter, and on YouTube, and we'll get to as many of them as we can. I'm Anjanette Levy, and you're watching Law and Crime. We'll be right back. Welcome back. I'm Anjanette Levy, and thanks for joining us for the lunch hour here on Law and Crime. We are on that lunch break in Alex Murdaugh's double murder trial, and we are taking your questions. So keep them coming to us on YouTube, Twitter, and Facebook, and we'll answer as many of them as we can. We've got Gigi McKelvey here, Chris Adams, and Marie Pereira. So a great panel. We love having the panel here every lunch hour. Let's take a look now at some of the testimony from Dr. Kinsey from this morning. He reconstructed the crime scene on behalf of the state of South Carolina. So he's a prosecution witness, one of the last ones that the jury will likely hear from on the prosecution side. He's basically outlining what he says happened on June 7th, 2021 at Moselle when Paul and Maggie Murdaugh were shot and killed. So let's take a listen to a little bit of his testimony about their fatal injuries.
Generally describe again to the jury your conclusion as to that second injury suffered by Paul, the fatal shot as you've described it.
Well, the first thing is, once Paul received that second shot, he never walked again. He never made any movement. Any movement he made was involuntary, and it was due to gravity, pulling his body down to the ground. When you sustain an injury to your brain like that, that ceases all movement. So he was found outside the feed door. He fell over forward after sustaining that movement. Some wounds are fatal later. You can actually see someone that receives a fatal wound, and I've seen them run 100 yards. They can move for a little while. This is not that type of wound. Once he received this wound, it ceased all movement.
Remind us again of those injuries, and if you could go ahead and describe them in the order that your expert opinion they were suffered.
Yes, sir. Miss Maggie Murdaugh suffered 3 non-fatal injuries from a firearm. One was through her wrist. One was her left upper thigh above the knee. One was at her abdomen here, and it exited somewhere around her kidneys. Now, I'm not that kind of doctor. I can't tell you all the damage it did inside, all those organs and things, but it ran a straight line through her body. This one on her left leg and this one on her midsection were approximately the same angle, and they were really, really close in distance. One had stippling that said that it was a foot closer than the other, but that would probably fit. This was either a total separate non-fatal wound, or it could have been a continuation of one of the 2 fatal wounds. Her fatal wounds were, she had an abrasion or a burn on the left side of her abdomen from the outside in. That bullet followed a straight path. It entered the end of her breast and did extensive damage to the end of her breast, entered her left jaw, side of her face area, and went into her brain. That's the first fatal injury. And it was immediate, and she dropped right where she was at. I saw no evidence that her body had been manipulated, moved, or rolled over. The second fatal injury was down into her head, and it actually did what in the day they call a keyhole injury just from appearances. The entrance and exit in the top of her head were so close it made one big injury, and then it entered into her upper shoulders and went down into her body. That would have also been a fatal wound, but it was second. In my opinion, that one came second.
And just really some graphic detail describing kind of in slow motion how this would have unfolded at Moselle that night when Paul and Maggie were killed. Let's take some of your questions now. This one comes from Melanie Johnson from YouTube. And Melanie asks, since they are saying the angle is low, and this is for you, Marie Pereira, since they're saying the angle is low for the second shot on Paul, could Paul have tried to lunge at the shooter and then cause that low angle? What's your thought on that? Because obviously he's saying Paul did kind of turn and took some steps toward the door.
I think Paul actually saw whoever it was that was, about to kill him. And I think he tried to get away. And I think the blood droplet testimony that the expert Kensley testified to sort of support that. And it could have been someone crouching. And the testimony from the expert supported those angles and why the shooter might have done it that way.
Interesting. Our next question, Susan D. from YouTube asks, isn't it the job of the ME to confirm time of death? Did they? I don't remember Dr. Reimer saying that at all. It's all sounds like it's been based on their phones. Stephanie O. from YouTube asks, why would a strange shooter go for Paul's phone? They wouldn't have known about the video moments before the murders. Chris, what are your thoughts on that? You know, Alex Murdaugh says the phone popped out of his pocket or whatever. That seems very odd. But why would a shooter just go for his phone? What could the possible explanation be?
I guess if you were sitting there and trying to brainstorm the defense, there are always things that you're just never going to know in a homicide case. And if the phone did come out and there were questions about it, I think it would raise the issue of, could there be other assailants, other perpetrators of this crime who would know Paul, who would know Maggie? Certainly in this case, there has been 404B evidence, other bad act evidence that's been brought up about the boat crash. There's been a lot of financial crimes referenced. People who would perhaps be angry at the Murdaughs or not like the Murdaughs would be people that they would know. So it's possible that there have been some back and forth on a telephone. There have been threats by text or other stuff, and that could perhaps create the opportunity for a person who shot Paul or shot Maggie to want to get their phones to try to eliminate that evidence.
But then take the phone.
And again, I'm not saying, I wasn't there. I'm not saying that is what happened. That is a possible scenario.
No, I know. Yeah, I've gone through it in my head many, many times. Our next question comes from Jenna Reynolds, Wyndham, from Facebook. Gigi, I'll send this one to you. Was this interview his first knowledge of the tree video? I think she's talking about, the third police interview, and that there was evidence of him wearing those particular clothes, being the blue shirt and the chinos. He seemed to have a bit of a shock on his face when it was mentioned. So was that interview his first knowledge of the tree video? Gigi, what was your take?
Yeah, I think it was. And, what was even odder to me is he said he didn't know when it was taken, which if you're experiencing a situation where your son is murdered just an hour later, I think you would remember if you bent the tree over, and he wasn't really sure when he changed, but he did. That was one of those things that threw him off. And so when things like that come out of the blue, it's very telling when they have to scramble or they pause, because otherwise you say, yeah, I took that with him, just an hour before I laid down or whatever.
Yeah, it's weird that he maybe didn't notice the phone being out, but, who knows? Let's see. SMBR63 from Twitter asks, do you know if Alex Murdaugh gets off on the murders, will the judge allow him bail for the financial crimes? I don't see that happening, Marie. What do you think?
I don't see it happening either. And to circle back to the previous question, I think that Alex, he lured Maggie and Paul back to the house. He did it and he lied about it. He didn't expect that the housekeeper would have received a text from Maggie saying, oh, Alex is asking me to come back and I don't want to come back. He actually said in that interview, that first interview, that, oh, she came home on her own because she was worried about him and his sick dad. Why would he lie about them being at the house because he told them to come? Only if he had something to do with it. That's what I think. He had something to do with it.
Mitzi Brownstone from YouTube, Chris, asks, do you think it's possible that Alex fell after the first shot and that is why the second shot was so low? Good question. Do you think that's a reasonable possibility?
That is, I guess, a potential theory. My theory as a defense lawyer would be that there's a question about who the actual shooter was. And so I don't accept the premise of the question that it was Alex. I'm not sure that it's been proven beyond a reasonable doubt that he was the shooter of Maggie and Paul. But certainly a shooter could have either dropped down to a knee for the second shot or slipped and shot from the ground on the second shot.
And I want to correct that. That was actually Dizzy and Dreamin's question, not Mitzi Brownstone. Mitzi Brownstone's question, and Gigi, I'll send this one over to you. If I'm rapidly killing people to escape, I'm not about to bend down. What is your opinion?
Yeah, I don't know. It doesn't make any sense to bend down because then you have to get up, and you don't know at that point where Maggie is. Is she coming up behind you? So yeah, I don't know. I don't think that it would have been intentional to lean down. I don't know. It just doesn't make any sense to me at all. I think a lot of people really feel this furthers the second shooter theory, is what I've heard today.
Interesting. And, you know, and we've tried to play this all out in our minds many times, but none of us on this panel have ever done this either. So it's hard to kind of put yourself in those shoes. You think you know what you would do, but who knows? Leah B. from YouTube asks, what is the defense trying to prove with this morning's witness? Marie, what did you think? Where did you think they were going with their cross of Dr. Kinsey?
They were trying to create some type of reasonable doubt. They were talking about angles. They were playing around with that ridiculous suicide angle, saying that, you know, Paul shot himself possibly, which I think really hurt them, because that is a defense of desperation. If they're trying to insinuate that that little boy killed himself, and then before that killed his mom, that made no sense. And that cross-examination did not help them whatsoever.
Okay. And our next question comes from Tom Kaiser from YouTube. The tire testimony from the ATV makes me think that Maggie ran into a parked ATV across from the feed room rather than her being, quote, run over by the ATV. How do you interpret it? I don't think they were saying she had been run over. That's not how I heard the testimony, Chris. So what is your thought on that? Did it make you think that Maggie was running and maybe brushed up somehow against that tire?
That's a possibility. I mean, there has been bruising on the leg that's been talked about from the beginning of the case, and now we have the ATV or four-wheeler testimony. It's just really hard for me to figure out that one scenario of how this had to have happened at the scene. What we have, without question, without dispute, are two deceased people and two guns. And there's still the big question, I think, to focus on is, was there one shooter or two shooters? And if there are two shooters, if that's not been eliminated, then the state's theory does not take into account a potential second shooter. And I think that is going to be an issue, a major issue going into closing statements next week.
And their theory, not their theory, but also the charges. The charges say Alex Murdaugh killed Paul with a shotgun. Alex Murdaugh killed Maggie with a rifle. That's what the indictment says. So interesting stuff. We are still taking your questions, but we have to take a quick commercial break. So stay with us. We will be right back. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. I'm Anjanette Levy, and thanks for joining us here on Law and Crime. We're taking your questions about the Alex Murdaugh double murder trial, so keep them coming in on Twitter, Facebook, and in our YouTube chat. Let's get right to the questions, guys. Marie Pereira is here, as is Chris Adams, the South Carolina attorney, and Gigi McKelvey is at the courthouse there in Colleton County. Let's get to you, Marie, with this. Greg and Chris +6 from YouTube. That's actually a funny name. What are they trying to insinuate with the ATV and tire impression mark on Maggie? So I think they're wondering what the defense is trying to imply with this line of questioning.
I'm not sure what they're trying to imply, and there's a problem with that, because if on cross-examination you're bringing something up, you need to be very succinct about it and get to the point of what you're trying to elicit from the witness. And at this point, I don't know if they're saying she was running away and fell on the tire. It made no sense to me. So therefore, I don't think it was good defense strategy if I don't understand the purpose of the line of questioning.
Well, I think the defense is trying to say it was a footprint and not a tire impression. And they've kind of brought up earlier that it wasn't documented properly. At least this is the defense contention, because they questioned Special Agent Worley about it. Like, that's where I think they're going with it. They're trying to suggest somebody like held her down to shoot her. Let's get to our next question. That's just my thoughts. Elmina from YouTube. Hunters change angles with the gun as long as they can handle recoil from there. Alex was a skilled hunter and beefy. Plus, wasn't a dog running free, and could that have made him change his angle? We know that Bubba, it sounded like he was running around with a chicken in his mouth, Chris. So how about Mina's question?
Angles could be changed. Certainly there's recoil, and I guess you would have to be really well trained and not have the same angle the second time. But this is, Mr. Harpootlian elicited on cross-examination that this was a significant change of angle from the second time, not as simple as a shot and a recoil and shooting from a different angle. So it's interesting. The other question that I have is around the forensics. Is the defense has made clear that they have about a week's worth of testimony for their case, which may very well come next week. We don't know what experts they may use, and a lot of this may be just setting the stage for different defense experts who have similar material to come up with different conclusions.
Mm-hmm. That's kind of where I thought they were going with a lot of this when they were questioning Dr. Reimer and Dr. Kinsey, because they have their own people, and so they're trying to see if these people will agree with the suppositions or propositions of their experts. Todd Godwin from YouTube asks, is anybody in the courtroom to see if Buster is changing his mind about his dad? Gigi, have you seen, yeah, we do, Gigi's in the courtroom every day, so do you see any change in Buster since the beginning of the trial?
Not really. I mean, he hasn't really interacted with his dad much at all, unless it's a hello or a goodbye. Now, we know they were moved back, so it's not as easy to communicate. Alec doesn't turn around anymore, really, to even make eye contact unless he's coming in or leaving. So it just seems like maybe there's some distance there. It's really hard to judge, but he did give that comment to a publication that don't assume that I support my dad. So I thought that was a pretty bold statement, and just not a lot of interaction between the two, but his dad's a defendant. So how much can you have?
Right. Yeah, he can't. And he's on the defense witness list, too. So we don't really know how he feels about his father. We don't know, other than he's sitting there behind him and he's on the defense witness list. Chris, I want to throw this question to you because you're down there in South Carolina. Why was he giving Eddie, this is from Ruth Lee from YouTube, why was he giving cousin Eddie $50,000 a week if it wasn't for drugs? Chris, what is another possibility?
Well, I believe that the defense went on national TV. I don't know how much this has been presented as evidence yet, but they went on national TV, I think on Good Morning America or one of the other shows, and said that Alex Murdaugh had an opioid addiction, and that Eddie, I don't think they named Eddie Smith in that, but Eddie Smith surfaced as his dealer a short time later. And they said that explains the missing money, that he was a major consumer of opioids over a number of years, and that Eddie Smith was his source of opioids. So that would be why he was delivering large amounts of cash to Eddie Smith, I think, is what the defense explanation would be. But
other explanations, because there are some money laundering charges with Alex Murdaugh and Alex Murdaugh and Cousin Eddie. So I don't know why he would be laundering money through him. That's just that's weird. So I was wondering if you had any kind of inside gossip. And they have said that they've called him a drug dealer. The defense has. Dick Harpootlian called him a drug dealer the other day in court. So we are going to continue to take your questions here. Do we have any sense if Agent Kelly is coming up, Gigi, just briefly, right after lunch?
It seems that way, and there was a possibility that we may be hearing the phone conversation with the SLED agent where he admits it. So we'll see, but I do think Agent Kelly may finish this out. I don't know.
Well, Gigi's going to sign off from us now. You stay with us. We'll be right back. I'm Anjanette Levy, and thanks for joining us here on Law and Crime. We are in the lunch hour in Alex Murdaugh's double murder trial, and we are answering your questions, so keep them coming to us on social media. That's YouTube, Facebook, Twitter, and we'll get to as many of them as we can. But first, we want to bring you up to speed on what's been going on in court today. The prosecution called a crime scene expert, a crime scene reconstructionist, to talk about how the murders of Paul and Maggie Murdaugh were committed. And one of the things he told the jury about was his opinion, based on all of the evidence, about the trajectory of the shots that killed both Paul and Maggie. So let's listen to Dr. Kenneth Kinsey.
The shooter was right here, approximately right here.
All right, and show us the trajectory as it went through Maggie into her brain.
Yes, it burned or grazed her stomach outside to inside, went through the end of her breast, into her jaw, and then into her brain.
Okay. And what would have been the effect on her once that shot was suffered?
She would have immediately fell down with the front of her body.
All right.
And that is the position her arms were in the original crime scene photograph.
And while I'm down here, so I don't have to get up again, tell me about the fatal shot and the positioning of the shooter as the evidence indicates to you.
The second shot was not as close, but it still wasn't a long distance. It was approximately here, into the crown of the head.
And use the dowel stick to show that injury that Maggie suffered.
In, out, in that line.
First of all, what do we see here before we get to your analysis on this particular issue?
This is a general photograph of an impression on Miss Maggie Murdaugh's left calf.
Okay. And do we also see a wound on this picture?
You can see the exit wound from that thigh wound that I described earlier.
All right. And what, if anything, did you notice about or conclude from the sort of the blood pattern on the back of her thigh there?
She stood a little while. I can't tell you how much time, just like with Paul, but she was standing after she suffered that thigh wound because the blood is running down the leg and gravity always pulls it to the earth.
Is it your expert opinion that this mark on the back of Maggie's leg is a tire impression and not anything else?
That is a tire tread impression. That is my opinion.
Additionally, with this particular tire tread impression on the back of Maggie's calf, is that consistent with her running into it or backing up into it with her calf hitting that tire as it was parked there?
Leading, I've not. This is my first leading objection on this, but I object. Leading.
I would say sure. All right. Let me ask you this. With this particular tire impression and what you see on Maggie's calf, is there a reasonable explanation as to how that impression got on her calf?
At some point in time, Miss Maggie Murdaugh's left calf made contact with the inside of that front driver's side tire, or one just like it, and I saw no evidence that she was run over. So she had to make contact at some point in time.
So there you have it. Dr. Kinsey saying he did not believe that Maggie Murdaugh was run over by an ATV. We had heard about this impression mark earlier in the trial where the defense suggested it was a shoe impression. So that somebody was maybe standing or putting their foot on Maggie Murdaugh as they were shooting her. So Marie, I'm wondering what you think of that, because there's a difference between a shoe impression and a tire impression.
There's a big difference there. And again, there's no clarity in that line of cross-examination, and I'm not sure where Dick Harpootlian was going with it. And that makes me believe that they're grasping at straws and their defense is weakening as we go along, with him opening the door yesterday, to him insinuating that Paul might have committed suicide after shooting Maggie. And now, is it a footprint or a tire print? I think it needs to make sense. Every question matters. And when there's no clarity as to what the question is about, there's a problem here.
Let's get to more of the questions from the viewers. I always love taking these. Mary Fitzpatrick from YouTube asks, Chris, was Maggie running away from Paul's shooter or toward Paul? What do you believe the answer to that question is?
I'm not sure that I'm ever going to know the answer to that. And even with the whether it's a tire print or a footprint. The defense's theory was that one of the shooters put a foot on Maggie at some point, and I'm assuming they may have an expert that says that would not be consistent with the shoes Alec was wearing. But when you do crime scene reconstruction, which is what this witness is doing, you deal with the known facts, and then you try to see what theory may work, may be the most plausible, that doesn't contradict any of the known forensic evidence. And things like running to and running away are almost always going to be subject to interpretation. And I'm not sure that the forensics are going to tell us the truth on how everything really occurred on the terrible night.
I have a question kind of from MS Gal from YouTube for both of you, but Marie, I'll go to you first because the three of us were discussing this kind of during the last commercial break. MLS Gal, I'm sorry, from YouTube asks, a proof of level of addiction outside of the possibility of Alec using rehab is another way to get a break and try to deflect. We heard the testimony, Marie, about from Marion Proctor saying that Maggie called Paul Little Detective because Alec had this pain pill addiction, and Paul was always trying to make sure his dad was behaving himself and not using the pills. So we do have that, but you have some thoughts on the level of his addiction.
I have thoughts about it because we're talking about $50,000 a week allegedly being given to his creepy cousin, whose name I forgot. Now, that's a lot of drugs. Even though he's a big guy and he could take a lot of pills, he would be nodding off. Over 10 years, $50,000 a week worth of pills, and nobody would notice that you're nodding off like a real bummy drug addict. I'm not believing that. Unless there are some blood tests that were done by the rehab center before he checked himself in that would show some opioids in his blood, I think he's exaggerating, and I think he's trying to use his drug addiction as mitigation for his actions. And I'm not buying it, not to that extent. $50,000 a week worth of drugs? No, I don't believe that.
And that's kind of opens a whole nother can of worms because it's a lot of money, and maybe he is dependent on painkillers or was at one point in time. But even Marion Proctor said this had been going on for many years, the pain pill abuse and use. Chris, we know that Curtis Eddie Smith is facing charges related to this for money laundering, unlawful possession of a Schedule II substance, trafficking in meth, possession of marijuana. And then Alex Murdaugh faces charges as well related to this. It's conspiracy counts for narcotics related to oxycodone. So there's a lot going on there. $50,000 a week, though. So if Curtis Eddie Smith is charged with money laundering, $50,000. I mean, how many pills does that buy you? And then what goes on for the rest of the money? What's the laundering aspect of this case?
I think the aspect as it relates to Curtis Smith, based on what's publicly known, would be taking the money and treating it as lawful income and trying to get it back into the bank or back into legitimate investments. So I think it would be coming, the drug proceeds being used. But the money has always been a big question mark, and I thought this trial might shed light on the money issue. From the law firm, there's been $7 or $8 million that was stolen allegedly over the course of a period of time, and I know the feds have looked into it. There was a prior trial of the banker Lafitte, who was a close associate of Mr. Murdaugh, and I don't think anybody has come up with an explanation for where all the money has gone. And I think Marie is raising the question of, she doesn't buy that it could have all gone into opioids, and it's hard to see how a person could spend $8 million over the course of 6 or 7 years on opioids. So it's a real question in my mind, and I don't know where the funds would be. I don't believe they've been recovered.
Yeah, it would be a significant amount of opioids. It's an insane amount, actually. Trey Linda Kerr from YouTube asks, why wouldn't Alex Murdaugh offer up the blue shirt if he still had it? That's the blue shirt in the Snapchat video that we've heard about and seen, that nobody knows where it is to this day. So, Marie, why isn't he coughing up the blue shirt?
Well, we don't know yet. We don't know if he's going to testify. We don't know what the defense is going to be. Although the burden is not on him to prove his innocence, it's on the state to prove that he's guilty beyond a reasonable doubt. I think he's going to have to testify somehow to answer some of those questions. Because at the end of the day, if I'm accusing you of something like an outfit change or changing your shoes or being at the kennel when you said you weren't, or luring your wife back when you said, you know, she came back because she wanted to come back, you need to provide an explanation as to why you're lying. And if you're not lying, you need to convince the jurors that you're telling the truth. You don't have to testify, but not testifying is really going to make you look suspect in the eyes of the jury. Whatever the judge says, they're going to use it against you.
Mitzi Brownstone from YouTube, Chris, asks, Alex received no money from their death, therefore how can money be the motive? And I think that a lot of people struggle with that. If there was no life insurance that he was getting, a windfall, how can money be the issue here in covering up these financial crimes?
If Alex Murdaugh is convicted, one of the huge issues for appeal is going to be whether the financial crimes evidence was properly admitted or not by Judge Newman. The state asked to admit it under 404B, the other bad acts evidence rule. And one of the grounds under 404B is motive. And usually there's a motive of, I'll kill Adam so I can get Adam's life insurance, or I'll kill Adam so I can, carjack him and take his car. In this situation, the motive just doesn't really make a lot of sense. The state argued that there was a lot of pressure from many directions, financial pressure coming in on Alex Murdaugh around June 7th, and that led him to make the irrational decision to kill his son and wife. Not that he would financially benefit from it, but that it was outside external financial pressure, and the jig was about to be up. And so he did this to buy himself other time. And that doesn't make a lot of sense. And I'm not aware of many appellate court cases that have dealt with this abstraction of outside financial pressure. So it will be interesting to see what happens. To go a step further on this is, that very day, he received news that his father went from being in serious medical condition to going into the last stages of hospice care. So if he just needed to buy some time to avoid a deposition in the civil suit related to the boat wreck, he had that already built in. A shooting of his son, a shooting of his wife wasn't necessary. So I think that undermines the need for the 404B evidence that's been admitted.
Interesting. Well, we'll have to wait and see how it all pans out to see if we even get that far to an appeal, because there's many possibilities for a verdict in this case, or maybe no verdict at all if there's a hung jury. Richard Rabondo from YouTube asks, Marie, why doesn't the prosecutor ever object? It seems like a waste of time.
I'm not sure what the prosecutor does object. I think both sides are objecting, and they're preserving, especially the defense, their right to appeal. And I feel like there have been a lot of objections.
Yeah, I feel like they're not jumping up all the time and constantly doing it, but they do object. I've seen them do that a fair amount. And Danielle McKinney from YouTube asked, do you think the defense is doing this just so Alex can say his lawyers didn't rep her well enough or rep him well enough, it should say, to cause an appeal? That's from Danielle on YouTube. I don't know what she means doing this. I mean, I think these are pretty aggressive lawyers, Chris. I mean, Dick Harpootlian and Jim Griffin know what they are doing.
Unless she's talking about the opening the door to the September shooting incident. And that, trials are not perfect. We do our best, and sometimes we make mistakes. They're smart, hardworking lawyers on the other side of cases, and sometimes they just outflank you on particular issues. And sometimes you do things for strategy reasons, and sometimes you just do things because you made an error under the pressure of a trial. But to get back to the bigger point which you raised, Dick Harpootlian and Jim Griffin are top shelf lawyers. I have every reason to think they believe in their case, they believe in their client, and that they are doing everything in their power to put him in the position to win a defense verdict in this trial.
And the most interesting, or one of the most interesting things to me about their relationship with Alex Murdaugh is the fact that they were representing Paul in the boat crash mess. So they had this relationship with the Murdaughs a couple of years before this even happened. And Dick Harpootlian had said, I had been with Alex and Maggie for, days on end for the last 2 years. So, there's that part of this as well. So I feel like they are personally probably a little invested in this too. So we are going to be done now, unfortunately. We had to get you back into court, right? So we are going to be done with the questions for now, but thanks everybody for joining us. I'll be signing off, and Michelle, you will be taking back over after the break. So Marie and Chris, it's been a lot of fun. We hope you'll come back, and everybody stay with us. I'm Anjanette Levy. You're watching Law and Crime.
everyone. I'm Michelle Yu. It's been another day of twists and turns in the murder trial of Alex Murdaugh happening down in South Carolina. The crime scene investigator, Dr. Kenneth Kinsey, has been front and center with his testimony so far as the jury learned today more details about the angles and patterns of the shots fired the night of the murders. Now, court is expected to come back from their lunch break any moment now, but let's show you some of the arguments outside the jury today regarding the judge reversing his decision to allow the jurors to hear evidence of the 2021 Roadside shooting involving cousin Eddie.
And from that, Your Honor, there were no questions related to the Roadside shooting, no questions related to whether Alex lied to the police in connection with the Roadside shooting. It was all about him stealing money from clients to support his drug addiction, which is evidence that was already in the case. Your Honor, I sent the court via email earlier today the case of State v. Hayward, 426 SC 630, which is a 2019 case where the Supreme Court reversed Judge Young on an opening the door theory.
The same Supreme Court reversed the Court of Appeals.
Excuse me, the Supreme Court reversed the Court of... Sure.
Yes.
The defendant was convicted. It went... The Supreme Court, the Court of Appeals affirmed, and the Supreme Court reversed the Court of Appeals. That's right. Yes. And vacated the conviction based upon the introduction of propensity evidence, 404 evidence on the theory of opening the door. And in that opinion, Justice Hearn is very specific to state that the courts have to be very careful and very wary of thinly veiled attempts to show propensity by way of the open door doctrine, and that the testimony in response must be proportional and confined to the topics to which counsel had opened the door. And again, I go back, we did not open the door to any roadside shooting, any insurance fraud, anything with regard to Alex lying to the police. And so that was the basis. I just objected, so I want to put that in the record. Today, they intend to present a full panoply of evidence on the roadside shooting. And, Your Honor, we would oppose that.
What do you mean a full panoply?
Well, they've asked to, that they're going to, my understanding is they're putting up Agent Kelly to talk about his investigation of the roadside shooting. We got a request this morning for them to play the hospital videotape of Alec in the Savannah Hospital, which is over an hour, where he's being interviewed by SLED agents, and he's meeting with a sketch artist to draw up a sketch of the roadside shooter, and that they plan to introduce that evidence. They plan to introduce, as we understand it, follow-up evidence of when Alec gets to detox in Atlanta, when he calls back with Mr. Harpootlian and I, and gives a full statement about the roadside shooting and about how he had lied to them previously, how he was sorry.
Is that the same video or
two separate? I mean, second is just an audio tape. But Your Honor, I just go back to State v. Hayward, where the court says testimony in response must be proportional and confined to the topics which counsel has opened the door. And so they intend to spend 3 hours of testimony here today, and it's not proportional, and it's not related to the topic for which the court, I believe, should find that. I don't think I opened any door because I think the evidence was already in the case.
Concerning the court's ruling yesterday, and also State v. Hayward, Mr. Owens, in questioning Mr. Griffin in cross-examination. Ready for the jury?
State's ready, Your Honor.
Defense ready, Your Honor.
Bring the jury. Okay, very good. Welcome back. Ladies and gentlemen, I've appointed juror number 826 to serve as the foreperson of the jury. In various places in various states, it's done differently. In some places, the jury selects a foreperson. It's my practice to appoint a foreperson. The fact that a person is appointed as foreperson does not give that juror any more authority than any other juror. All jurors are equal participant, and each juror has an equal voice in the process. Well, certainly welcome you to this role as foreperson, and look for all of you to continue with your role in the process from now through the end. And with that, we will have the state call its next witness.
Thank you, Your Honor. May it please the court, the state calls Senior Special Agent Ryan Kelly.
Sorry if I'm walking away from you.
Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
All right. Please be seated and state your full name for the record. Spell your last name, and make sure you can get to the mic real good.
Ryan Kelly, Kelly.
Special Agent Kelly, how are you doing today?
I'm doing well, sir. How are you?
Doing well. If you would just quickly introduce yourself to the jury and just give them a short synopsis of your career in law enforcement leading to where you are today.
My name is Ryan Kelly. I'm a senior special agent with the State Law Enforcement Division. I'm from Berkeley County. I went to college at the Citadel where I studied biology. I attended the South Carolina Criminal Justice Academy. I've got approximately 22 years law enforcement experience, the last 10 of which have been at SLED Investigative Services, Low Country region, where our caseload includes violent crime, public corruption, officer-involved critical incidents, and financial crimes. Currently there as a senior special agent.
All right, and if you would get that mic just a little bit closer to yourself.
Is that better? Okay. Yeah.
Yep, that's much better. Have you, as far as the murders at Moselle, you had a very tangential role in that particular case, is that correct?
That's correct.
All right. Moving forward, did you become the lead case agent on a different matter that started on about September 4th, 2021?
Yes, on September 4th, 2021, there was an incident involving Alex Murdaugh where he was shot along Old Salcahatchee Road in Hampton County.
All right. And did you respond to that particular scene?
I did.
Okay. And about what time did that occur?
The shooting occurred at approximately 1:36 p.m.
All right. And that's September 4th?
September 4th, yes.
As you arrived at the scene, what, if anything, did you notice about what vehicle was there?
Prior to arriving at the scene, while en route, Mr. Murdaugh was being treated at a hospital in Savannah. So I responded to Savannah first.
Right.
After meeting with Mr. Murdaugh, I then responded back to the Salcahatchee Road.
Okay, and we'll talk about that in a bit. But let me ask you about the scene a little bit. What vehicle was at the scene?
There's a black Mercedes SUV.
All right. And do you know who that Mercedes belonged to?
Yes.
And who did it belong to?
Maggie Murdaugh.
All right. And what information had been, you said you responded to Savannah Hospital, is that correct?
That's correct.
All right. And you had a chance to talk with the defendant, Alex Murdaugh?
I did.
And do you see him here in the courtroom today?
Yes, he's there in the brown blazer in between Mr. Harpootlian and...
Let me ask you, I want to ask just a little bit about the scene before we get into that. What, if anything, did you notice about the condition of the vehicle?
The vehicle had a driver's side rear flat tire.
Okay. And did you notice anything about that particular tire, the class of tire it was, or what kind of tire it was?
That particular tire is a run flat.
All right.
So the tire was flat, and when we got there, we expected to see some type of damage to the tire, to the inner wall or whatnot, and that just wasn't present. After reviewing the tire and looking at it up close, we saw what we thought appeared to be a small puncture wound or a puncture mark on the sidewall.
And what did that appear to have caused that as you looked at it?
It looked like a small blade, like a pocket knife that most police officers would carry in their pocket. It appeared to be something similar to that.
Tell the jury a little bit about a run-flat tire. What does that mean if the tire goes, quote, flat?
Well, I don't work for Mercedes, and I'm not a tire expert, but it is it's a feature on certain brands of tire that once there is some type of puncture, that the tire remains operable. So if you're driving on a road and you suffer a blowout, it allows you to drive to a safe space, where you can pull off and seek assistance there. But they typically don't go flat immediately after being punctured, unless there's some catastrophic damage to the tire. And in this case, there was not. That catastrophic damage was not there.
All right. In the stand by for me just real quick. In the course of your investigation, as you started to look into this, did you obtain a copy or review the 911 call from this particular incident?
Yes, I did.
All right, and who made that particular 911 call?
Alex Murdaugh.
All right, and I'm going to show you what's been marked as States 543, and is that a disc containing that particular 911 call?
Yes.
All right, Your Honor, at this point I would move in States 543, I believe without additional objection.
Without additional objection, Your Honor.
It's admitted.
All right, thank you. I'm going to go ahead and play that. Technical difficulty here. Let me ask you this. While we're getting that 911 call up, can you generally describe what was reported by the defendant on 911?
Yes. Mr. Murdaugh called 911. The Hampton County 911 operator answered the phone, obviously asked, "What's your emergency?" Mr. Murdaugh said that he was on South Comanche Road by a church with a red roof. When she asked what had happened, he said that he had been driving on Old South Comanche Road, suffered a flat, and when he pulled over, another motorist arrived on scene to render assistance, and he said that when he turned around, the motorist shot him. So at that point, the dispatcher asked, "Have you been shot?" And then that's at that point where Mr. Murdaugh said yes, he'd been shot, but then he said he was okay.
All right. And did he say that he got a flat tire, he stopped, and then someone stopped to help and then shot him?
Yes.
All right.
for a lady and members of the jury will have in your jury room for a few minutes. Please do not discuss the case.
And criminal defense attorney Bob Murdaugh are both here with me to discuss and break down this trial. Marie, I'm going to start with you. What do you make of now having Agent Ryan Kelly on the stand to open a new can of worms to discuss this whole courtside shooting after the judge reversed the decision?
It makes him look like a liar in chief, a fabricator. They're actually going to lead down the road where they're going to hear the 911 call. And they're going to say, if he was such a liar on that call, he probably was lying when he called about his family too. And they're going to bring out evidence that he even helped to draw a sketch about the person who allegedly shot him. This is like a nail in his conviction coffin that I don't think even Dick Harpootlian is going to be able to get him out of here.
Bob, what do you think?
I think this is the chickens coming home to roost on Jim Griffin's horrific mistake yesterday. Opening the door or reopening the door, and I guess there's a debate whether or not he really did. I'm in the camp that he didn't open the door, but the judge, who matters in terms of deciding whether he opened the door, decided that he did. And this is going to be the result. The bottom line is the jury, after Mrs. Proctor's testimony, was left thinking that there was a shooter that had targeted Alex Murdaugh. And now they're about to find out the whole truth. So it's bad.
So, Marie, at the end of the day, you agreed with the judge reversing this decision.
Absolutely. He danced with fire. He came close to it and he got burned. They never wanted that 911 tape where he's saying somebody shot me while I was changing my tire, and they're bringing testimony that maybe they even punctured the tire. It's going to make him look like a liar colossally, and it's not going to help his case, all in the name of motive. It's going to be bad act, lying evidence that the jurors are going to never unhear or unsee.
Well, earlier today, Bob, I want to get your thoughts. We talked to Marie about this earlier. We had another witness on the stand, and that was the crime scene investigator, Kenneth Kinsey, Dr. Kenneth Kinsey. And he went toe-to-toe with Harpootlian about everything, with the trajectory, the patterns, the angles of the shots at the murder scene. What did you think of his testimony, and how do you think the jury responded to that?
I thought he was an excellent witness for the state. I thought he held up like a champion on cross-examination. There wasn't much in terms of what Harpootlian could do to kind of mitigate what his testimony was, because number one, it's always an opinion when you have experts like that. But in terms of him being able to deflect any kind of headway that Harpootlian was trying to make on cross, I felt like he volleyed very well, and he was very likable beyond that. Like the whole thing where he's like, "Can I stand up?" And the judge had the entire courtroom stand up. He was a very good witness for the state. I think he was very effective. And then you pile that on top of what's going to be happening next. It's not looking good.
Yeah, all right. Well, we're going to see what happens next. We're going to check back into that South Carolina courtroom in a moment. We're going to take a quick break here. You're watching Law and Crime. joining us. It's never a dull moment in the murder trial of Alex Murdaugh down in South Carolina. Today, Judge Newman reversed his earlier decision, which will now allow evidence in the front of the jury of the 2021 Roadside shooting, allegedly involving Curtis Edward Smith, that's cousin Eddie. Now, we were hearing testimony from Agent Ryan Kelly, the lead case agent on the scene of that Roadside shooting, but they're taking a very quick break in court right now. So let's show you some key testimony from yesterday. This is Agent David Owen. He's the lead agent on the double murders.
Did you present to them I think some of what we heard, the money he acquired, he being Alex, after this incident, the money he came into?
Yes.
Did you mention to them about whether Maggie intended to go to Moselle that night or not? What did you say to them about Maggie going to, and her plans, or whether she was going to go to Moselle that night or wanted to, if anything?
That Maggie had intended to go to Edisto, but had received a call from Alec requesting her to come home, that Paul was there, which contradicted the statements from the sister, Marion, where Maggie, I'm sorry, I misspoke. Maggie had called Marion and said that she had received a call from Alec, that Alec wanted her to come to Moselle, and that Paul was there and his dad was in the hospital. But during an interview with Alec in August, he stated that it was basically a surprise. He didn't know she was coming.
And did you mention to them that a reward had been offered on the offer?
That a reward was offered, $100,000 with an expiration date.
And did you tell them whether or not there was any other information or any other credible evidence pointing to anybody else?
I did.
Mr. Griffin asked you about the scene. It was bloody?
Very bloody.
Defendant said he had touched and rolled, tried to move Paul.
Yes, sir.
Did you see any evidence of that on him?
No.
Your eyes?
I did not see any on Alec. No, sir.
I guess the point, Mr. Griffin said they were bending over, wanting to help, wanting to do all this. You never mentioned Curtis Smith or anybody else until September, right?
Judge leading.
Can't believe the witness.
I'm sorry. I apologize. Did you ever mention anybody else who could have done this, who could have been involved with, who could have killed my wife and my son from June 7th, 2021 until September of 21? Did he ever mention anybody else?
No, he did not.
Did you mention to them about defendant denying going to the kennels 3 times?
Yes.
Leading the witness.
Don't lead the witness.
What did you tell them about him going to the kennels?
That after dinner, he stayed at the house and took a nap. When Maggie went to the kennels and Paul left, he
Agent Kelly, we fixed our technical difficulties, and for the record, about to publish the 911 call.
Hampton County 911, what's your emergency? On Salkahatchee Road. Okay, what's the address on Salkahatchee Road? I'm by the church. What church here? What church are you talking about? I don't know the name of it with the red roof. Okay, what end of South Road? Because I don't know what you're talking about.
At the Hampton County side.
Okay, what's going on?
I got a flat tire,
Mm-hmm.
and I stopped, and somebody stopped to help me, and when I turned my back, they tried to shoot me.
Oh, okay. Were you shot?
Yeah, but I mean, I'm okay.
You shot where? Where were you shot at?
Huh?
Did they actually shoot you or they tried to shoot you?
They shot me, but
Okay, where, you need EMS?
well, I mean, yes, I can't drive.
Okay.
And I'm bleeding a lot.
What part of your body?
I'm not sure. It's somewhere on my head.
Your head?
Somebody just stopped for me now. For 911.
Okay. Still?
Hey.
Okay, let me speak to him, see if he can tell me exactly where you are.
All right, for the record, I'm stopping that at 141. Was that the defendant on the 911 call?
Yes.
At that point in time, he said, someone shot me?
Yes.
Did he identify who that was?
No, he did not.
I'm going to show you what's been marked as States 545. And is this a copy of a body-worn camera video you received from the defendant in the ambulance at the scene?
Yes.
And by the scene, we mean the side of the road on September 4th.
Absolutely. South Road, September 4th, 2021.
Your Honor, at this point, I'd offer States 545 into evidence, I believe, without additional objection.
No additional objection, Your Honor.
It's submitted.
All right, for the record, I am going to publish a portion of that video.
I'm going down the road. I had a tire go flat. I pulled over, and this car went by me. I didn't pay a lot of attention truck, but then it turned around, came back. A real nice guy acted like, and I turned my head, and I mean, boom.
Okay. You know what kind of gun it was?
I don't know what kind of gun it was, but it sounded like a shotgun, even though it was so loud. It didn't sound like a 22. I know that's what they think it is, but it didn't sound like a 22.
It looks like a small caliber hole. Yeah.
Small caliber?
Yeah, small caliber.
But it was extremely loud.
What's your name?
Alex Murdaugh.
Okay. What's your date of birth?
5/27/68.
Over here, buddy.
I'm good. You're good. What's a good telephone number, Ms. Murdaugh?
942-1227.
27. What's your address?
PO Box 457.
Box 457, Hampton.
321 South and Faith Temple, 321 South and Faith Temple. Uniform Nancy Parker, resident 6, repeat, Uniform Nancy Parker.
So, you said it's a blue color pickup. It's a Ford, a GMC, or what?
It wasn't a Ford, I know that.
It wasn't a Ford? Like a Ram type, or?
You know, I think it was a GMC or a Chevrolet, but
GMC?
I'm not totally positive.
I got problems with you now. So you had a flat tire in Mercedes Benz, went inside the road, tried to change the tire. The blue color pickup came inside you, thought everything was okay, and then it clouded. You think of a shotgun and just shot. How many times did it fire?
I think just one time.
What time?
I lost my vision right when it first happened, and I think I was.
Wait for we going to the hospital. What's that? You flying out?
Oh, we're flying. Yeah, we're flying. Yeah, we can't handle that. Okay. Not no traumas are hit like that.
When the flight crew
we'll find out.
We'll find out where we're going.
Give me a picture for something. 1 second.
All right, for the record, I played that clip from about 14:07 to 14:10 by the timestamp. Was that the defendant in the ambulance at the scene on Salkatchee Road?
Yes, it was.
And did he again tell the story that he had been shot by an unknown assailant?
Yes, the story was consistent.
All right. And did he say at any time during that anyone shot him?
No.
And what did he say the weapon sounded like that shot him?
He said it sounded like a shotgun.
On September 4th, you said you responded to a hospital?
Yes, in Savannah, Georgia.
All right. And who did you see when you were there?
I met with Alex Murdaugh and I met with Randy Murdaugh.
All right. And did you have a conversation with the defendant?
Yes, I did.
All right. And can you just very generally relate what the defendant said? Did he tell you a very similar story that we've heard from the 911 call in the ambulance video?
Yes, when we arrived in the hospital, Mr. Murdaugh was receiving treatment. He was awake and willing to talk to us at that point. He was the only witness to this incident. We asked him what happened, and he told us a story that was consistent with the 911 call and with what was told to the deputy.
All right. And did he state that a driver had stopped, passed by, turned around, and came back to the location?
Yes, he said the similar story that he was driving along Old Salkatchee, that he hit something significant with his tire, causing it to go flat. So when he pulled over to the side of the road to inspect the tire, it was flat. As he was doing that, he said a dark in color Chevy pickup truck drove by, passed him, turned around, and came back to his location. He said he made contact with the driver, and as Mr. Murdaugh turned around to walk back to his vehicle, he said the driver then shot him.
Did he say that the driver of the truck seemed very nice?
He described the driver as a very nice-looking male between 30 and 45 years of age.
Did he tell you what he thought the weapon was that shot him with?
Yes. While he initially said it was a shotgun in the ambulance, when we met with him at the hospital, he identified the weapon as possibly a .22 caliber.
Did he say whether or not he ever lost consciousness?
He said that he lost his vision, dropped down to his knees, but he did not believe he'd lost consciousness.
Did he describe the vehicle of the person that supposedly did this?
Yes, he again described a newer model, dark in color blue Chevy pickup with, I believe, some type of sport tires.
All right. And did he describe the driver at all of this that supposedly was the person who shot him?
Yes, his description of the driver was consistent, a white male between 30 and 40 years of age. He described him as nice looking, a nice person. He described him as having close cropped hair with a close cropped facial hair.
And did he say whether or not he would recognize this unknown person if he saw him again?
Yes, Mr. Murdaugh told us that if he were to see the person again, he would be able to identify him.
At any point, did he identify specifically any individual, or did he claim that this was an unknown person?
He never gave a specific individual's name. He just said it was someone he did not know.
I'm going to return back to the scene, and I'm going to show you what's been marked as States 544. All right, I'm going to show you what's. Thank you. I'm going to show you what's been marked as States 544, and see if you recognize this particular image.
I do. This was recovered from inside the black Mercedes SUV driven by Mr. Murdaugh. It is his assistant solicitor's badge.
Can I have the helmet real quick, please?
All right, is that what's on the screen right now for the jury to see?
Yes, it is.
All right, turning back to let's move into September 5th. Did agents with law enforcement continue to sort of search that scene where the Mercedes had been located?
Yes. So on September 5th, agents returned to the scene. We were looking for any evidence of involved in the accident. We were looking for the significant piece of debris, and as we were searching the roadway around where the Mercedes had pulled off, we searched across the street in the grass area, and we recovered a gray in color utility knife.
Did law enforcement, did you notice any sort of debris or anything like had been described by the defendant as supposedly causing the damage to the tire?
No, we searched the area extensively, and we never were able to locate this significant piece of debris that Mr. Murdaugh described as causing his tire to go flat.
I'll show you what's been marked as States 546, and do you recognize that image?
Yes, I do.
And tell the jury what that is, please.
That is the folding knife that was recovered across the road from where Mr. Murdaugh's vehicle was parked.
Your Honor, this time, I believe without additional objection, the state would move into States 546.
No additional objections, Your Honor.
It's admitted.
All right, and is that the knife as it was found laying in the grass?
Yes.
And again, where was that location in relationship to where the Mercedes was?
The Mercedes was pulled off to the side of the road. This was directly across the road in the grass on the other side. Was DNA testing ultimately conducted on this particular knife? Yes.
And were two individuals in that DNA testing that came back in the propositions as a result?
Yes, DNA profiles of both Alex Murdaugh and Eddie Smith were identified on the knife.
In the course of the investigation, did you uncover any evidence that not long before this event occurred at 1:34 or so on September 4th that the defendant had a confrontation with an individual?
Yes.
And who was that? Remind the jury of that, please.
Prior to going to Salcahatchee Road, Mr. Murdaugh met with Chris Wilson.
And can you remind the jury what generally that discussion was about?
Mr. Wilson and Mr. Murdaugh met. Mr. Wilson, at that point, Alex Murdaugh had been terminated from his law firm, and Mr. Wilson became aware of that, so he wanted to meet with him to discuss what was going on, because obviously Mr. Wilson and Mr. Murdaugh had the missing $192,000 from the previous months that was still ongoing.
On September 6th, did you return back to the Savannah Hospital?
Yes, I did.
All right. And did you have another conversation with the defendant?
Yes. When Mr. Murdaugh advised us that he would be able to would recognize the individual if you should see them again, SLED has at its resources a composite sketch artist. So we brought her down, and her and I went to Savannah back to the hospital to re-interview Mr. Murdaugh in an attempt to create a composite sketch of the unknown suspect.
All right. And just very quickly, what is a composite sketch?
Again, I'm not a composite sketch artist, so I'm a layperson as I describe this. It is where an artist uses a digital software in concert with resources of magazines, of certain body types and skin tones and whatnot, and allows the victim to like a catalog to go through and find the identifying features closest that fit the unknown person, and those various parts are then drawn together to create a composite sketch.
All right. And during that particular interaction, was the defendant able to answer your questions?
He was.
Did he respond appropriately to subject matter?
He responded appropriately. He was able to answer the questions asked of him. And again, we started from the beginning, and he again went over the entire scenario of what happened on the 4th, and it was consistent with the versions he had given us previously.
Did he have agree to have this discussion with you?
He did agree.
And did you go into some discussion again with what happened on the side of the road, at least according to him at this point in time?
Yes.
And was it consistent with what he'd related before?
It was consistent.
Did he describe this unknown individual?
Again, he described him in a similar fashion. White male between 30 and 40 years of age, was nice looking, close cropped hair, manicured close facial hair. I believe he described him as wearing some type of outdoors type shirt. The description was consistent with what he had previously told us.
All right. And did he also provide a similar description of the vehicle that this individual was driving?
Yes, again, a dark and colored Chevy pickup truck.
And yet again, at any point during this period of time, did he identify who this person was, or did he say it was an unknown assailant?
Never identified who it was, and continued to tell us it was an unknown person.
Did he work with the sketch artist and looking through books and working to make a sketch of this supposed unknown assailant?
Yes, the sketch was completed.
And did that take a relatively extensive period of time?
Looking back, I don't know the exact approximate, but it probably took a couple hours for the interview and the sketch to be completed.
All right, I'm going to show you what's been marked as States 547 to your testimony and see if you recognize that image.
I do. This is the composite sketch.
All right, Your Honor, this time I would offer States 547, I believe, without additional objection.
Without additional objections, Your Honor.
It's admitted.
And what is this image on the screen?
That is the composite sketch created with the assistance of Mr. Murdaugh.
Based on his descriptions to the sketch artist?
Based on his descriptions.
This is on September 6, 2021?
September 6, 2021.
That evening, did law enforcement receive any communication from the defendant's family?
Yes. On the evening of September 6th, Special Agent Owen received a call from Mr. Murdaugh's brother, Randy.
All right. And can you relate what the investigation learned from that particular conversation?
Alex Murdaugh was still in the hospital in Savannah. Randy and the family had been down there with him. Randy called Special Agent Owen to let him know that Alex had been making calls from the hospital to some unknown numbers. So Randy provided those numbers to us.
And was information related that he had contact with hospital staff?
Yes, Randy told us that Alex was trying to convince the the medical staff members to allow him to use the phone so he could make phone calls.
And was information related that he was actually offering the staff money to try to use their phone?
Yes, one of the nurses in their notes made note of Mr. Murdaugh trying to offer money to use their phone.
Did the family of Mr. Murdaugh relate a specific name and a number to law enforcement as they discovered that Alex was attempting to contact this person?
A specific name and number were provided to us. Curtis Edward Smith. We were able to take the telephone number and trace that back to Mr. Smith.
During the course of this particular investigation, did law enforcement obtain any surveillance footage from any nearby establishments?
Yes, we did.
And can you describe that to the jury, please?
After the shooting, the agents who are present on the crime scene, obviously part of our investigation is to canvass the area. There was St. John's Baptist Church was nearby. Agents made contact with staff there. They in fact did have surveillance video that captured the roadway of Salcahatchee Road. Reviewing the footage, we first looked to isolate Mr. Murdaugh's black and color Mercedes. That was something that was a known to us. That he went that way, it would have been seen. And as we continued to review the footage, we started looking for a blue and color Chevy pickup truck. At 1:25 p.m. approximately, we observed a blue in color Chevy pickup truck with a gold or yellow in color passenger front quarter panel. Passed by at 1:25. Approximately 20 seconds later, Mr. Murdaugh's black in color SUV passed by. At 1:30 p.m., the blue in color pickup truck was seen driving back the opposite direction away from where Mr. Murdaugh would have been.
All right, I'm going to show you 3 images that have been marked states 548, 549, and 550, and see if you recognize these images.
Yes, this is the 1:25 p.m. image. The first image is the pickup truck with the gold front quarter panel. The second image is 20 seconds later approximately with the black in color SUV. And the third image is at 1:30, 5 minutes later, with what appears to be the blue in color pickup truck driving back the other way.
Your Honor, this time the state would offer states 548, 549, and 550, I believe, without additional objection.
No additional objection.
They are admitted.
All right. Putting this up on the screen, we have the timestamp up here. Is that correct?
Yes.
And what is that right there?
That is it is a dark blue in colored Chevy pickup truck with a gold front quarter panel.
All right. 549. What does that image reflect?
It is the Mercedes SUV.
Going in the same direction?
Going in the same direction, approximately 20 seconds after.
And then 550, what does that reflect?
That is at 1:30 p.m., approximately 5 minutes after the initial vehicles were seen. The blue Chevy truck appears to be driving in the opposite direction.
Did law enforcement travel to any particular residence in light of the information that had been provided by the defendant's family about the calls that the defendant was making?
Yes, once we were able to identify Curtis Edward Smith, we quickly learned that he was a resident of Walterboro, South Carolina. So we were able to go to his residence the morning of September 7th, and we were able, he lives at 1075 Burlington Road in Walterboro. Agent Owen went by and was able to locate or observe the blue in color Chevy pickup truck with the right front gold quarter panel.
Was a search warrant conducted of that residence?
Yeah, a search warrant was obtained and executed on the residence.
What date was that?
September 7th, 2021.
All right, and during the course of that search warrant, was there some narcotics found?
Yes.
Was there a ledger found?
Yes. So a small amount of narcotics. Mr. Smith has a garage, a modest home. Over the course of the execution of the search warrant, narcotics were located inside the garage. But the search of the residence, we found the best way I could describe it would be a physician's desk reference of multiple narcotic pills, like a drug reference guide that he had made personal notes in.
And was there any sort of notebook with a ledger in it or anything like that recovered?
Yes, there was also a small spiral notebook, a 3.5-inch spiral notebook that had various, it looked like, obviously it wasn't completed by an accountant, but there was numbers and there was pills and descriptions of it looks like some type of sales ledger.
All right, I'm going to show you what's been marked as States 551 and see if you recognize this image.
Yes, I do. These are transaction receipts and deposit and withdrawal receipts for Curtis Edward Smith's Enterprise Bank account.
And
Ultimately, did the law enforcement look at some of this financial information and trace that back to the defendant? This was recovered in Eddie Smith's house, correct?
Yes, those documents were recovered in Mr. Smith's house. At this point, Alex Murdaugh had been fired from his law firm for stealing from clients and from the firm. We were aware of that information. It was told to us that Mr. Murdaugh had a prescription drug addiction that we were aware of. At this point, we were aware of that Mr. Murdaugh had reached out to Mr. Smith from the hospital. So when we found, like I said, Mr. Smith lives in a modest house, has a modest vehicle. When we're seeing several $100,000 of deposits and financial records for Mr. Smith's Enterprise Bank, we obtained a search warrant. Through the execution of that search warrant, the funds were tied back to checks written by Mr. Murdaugh.
And did those funds continue up until the time of the murders at Moselle?
Yes, they did.
And did they continue afterwards?
They did.
Well, Your Honor, this time I would offer States 551 into evidence, I believe, without additional objection.
Without additional objections, Your Honor.
It's admitted.
Did the investigation obtain any information from Blanca Simpson about any communication she had with the defendant that day, September 4th, 2021?
Yes, Ms. Simpson made contact with Mr. Murdaugh, where Mr. Murdaugh had requested her send him copies of their insurance cards.
Was that prior to the incident occurring on the side of the road?
Yes, prior to the incident, Mr. Murdaugh attempted to meet with a few individuals, Mr. Wilson being one of them, and he made contact with Ms. Simpson via telephone.
In light of the information that had been uncovered about Eddie Smith and the financial connection between Eddie Smith and Alex Murdaugh, did the investigation seek to re-interview Alex Murdaugh?
We did. I reached out to Mr. Arpulian on the day of September 7th, 2021.
All right. And over the course of the next few days, was the defendant going to rehab?
Yes, we communicated regularly with Mr. Arpulian and Mr. Griffith. They made it known to us that Mr. Murdaugh had entered into a rehab facility that was out of state. So at that point, we were making an attempt to interview him. We made plans to travel to Atlanta, where we believe Mr. Murdaugh was, and those plans did not come to fruition.
Were you able to make contact with the defense and have a subsequent interview with the defendant, Alex Murdaugh?
Yes, Mr. Arpulian called me on September 13th, 2021, and we were able to set up a telephone interview of Mr. Murdaugh.
All right, I'm going to show you what's been marked as Exhibit 552, State's Exhibit 552, and see if you recognize this disc.
I do. This is a recording of the September 13th, 2021 interview with Mr. Murdaugh.
All right, this time I would offer States 552 into evidence, I believe, without additional objection.
No additional objections, Your Honor.
It's admitted.
I'm going to publish that to the jury.
No, should not worry though. All right, telephone conference interview of Alex Murdaugh, 9/13/21.
Whose voice is that?
Specialist Agent Jomar El Bayalden.
Was he present with you when you conducted this interview?
Yes, he was.
Jim.
Hey, Jim, this is Ryan Kelly and Joe Mar Albayalde with SLED. How are you?
Hey, Ryan and Joe.
Yes.
We're in an office over here in Atlanta with Alex and Dick, and I'm just going to put the phone here on the table next to Alex, and then turn it over to you guys.
Well, let me start, Ryan. First of all, we only have about 30 to 40 minutes before we have to get out of here. Okay.
Okay, no problem, sir. Sorry about that. You caught me. I was halfway to Somerville, so I had to turn around and get into a place where.
And I'm sorry, but we were late getting in here to see Alex, and once we got in here, we had to have a long discussion.
Okay.
It's beneficial. I'd like to walk him through some questions, which will then allow you to question him, but give you some sort of, rather than him just sort of wandering around.
Okay.
Okay.
Well, before we get started, can we just have, for the purpose of our notes, obviously we prefer not to do telephone interviews. This is how y'all requested, so obviously, we don't really have a choice. But we just I'm going to need Alex to identify himself, on the call, and basically what we do is I'm going to ask him his date of birth and the last four of his social.
Okay, go ahead.
Alex, just go.
Hello.
Alex, you give me your full name.
Okay, Richard Alexander Murdaugh.
Okay, and what's your date of birth?
My date of birth is May 27th, 1968.
Last four of your social.
7483.
Okay. And I understand that, obviously this is a unique situation conducting this interview over the phone. We need to, obviously you've been receiving some treatment. So just for the overall, sake of your competency to be giving us information, are you right now, sound body and sound mind?
Yes, sir.
Okay. Are you talking to us willingly?
Yes, sir.
Okay. All right, Dick. Go ahead, sir.
Okay, so let me say for the record, his attorneys Jim Griffin and Dick Arbuthian are here. We've spent the last hour talking to him. We believe that he is a sound mind and body, and that he understands, and that he is in no way diminished capacity.
Okay.
He is perfectly competent to answer these questions. Now, we're willing to, and we've advised him, we're going to talk about the shooting incident a week ago Saturday, where he was shot in the head, how that happened, who and why it was done.
Okay.
We don't want to talk about what happened in Moselle, and we don't want to talk about anything involving finances at the law firm. Is that okay?
Yes.
Okay. So, Alex, let's talk about last Saturday morning, and let me go through this briefly. Who did you meet with and talk to last Saturday morning?
I met with Jim Griffin and Chief Chessie.
Mm-hmm. And then what?
I drove to Canton and I met with Chris Wilson at my mom's house.
Okay. And you and Chris were talking about what?
About everything I had done.
Okay, everything you had done concerning finances.
Finances, pills, lies.
Okay. Now, were you taking, well, first of all, let me back up for just a second. Have you had a long-standing Oxycontin or opioid addiction issue?
Yes, sir.
How many years?
The best I can remember, around 20 years, 18 to 20 years.
Okay. Now, on this particular day, on this Saturday, were you taking the Oxycontin or taking any opioids?
I had taken some, but, I was taking, I'd given it all that I had someone else, and I'd taken some at like 4 a.m., so I was having some withdrawals.
Okay. And the previous day, the news had come out about your embezzling or taking client money or law firm money. Is that correct?
That's correct.
And how would you describe your state of mind at that time?
I was in a very bad place.
What does that mean?
I thought it would be better for me not to be here anymore.
What do you mean by not be here anymore?
I thought that it would make it easier on my family for me to be dead.
And easier, Was some financial gain to your family if you were dead?
I have a fair amount of life insurance debt.
Do you remember how much?
Not off the top of my head, but like $10 million, $12 million.
Okay. And so you decided to end your life?
That's correct.
And tell these sweat agents how you went about arranging that.
I called Curtis Eddie Smith on the telephone.
Okay, now let's stop for a second. Who is Curtis Eddie Smith?
Curtis Eddie Smith is the primary person who I purchased pills from for years.
And some weeks you would give him how much money for pills?
I mean, it would be in my records, but we had weeks where there would be $40,000, $50,000, $60,000
that you would give him for pills?
Yes, sir.
Okay, so you've known him for how long?
Years.
Years. So, did you call him that morning?
Yes, sir, I did.
That day? About what time?
I'm not sure.
Okay.
But I asked him to...
Was it after you met with Jim Griffin?
It was after I met with Jim Griffin.
After you met with Chris Wilson?
I believe so.
Okay, and when you called him, what did you ask him?
I asked him to meet me.
Did he meet you?
He did.
Where did he meet you?
He met me out not too far from my mom's house.
Where?
He was on the side of the road. I think at the funeral home.
At the funeral home. Okay, and did y'all talk?
Not there. He followed me into town.
To where?
To over where I stopped by the Sunoco gas station.
Okay, did y'all have a discussion there?
Yes, sir.
Did y'all get out of your cars, or was this in your vehicle?
I don't think we got out of our cars.
And what vehicle were you in?
I was in my wife's Mercedes.
And what vehicle was he in?
He was in a gray pickup truck.
Okay, and what did y'all discuss?
I told him that things were getting ready to get really bad, and that I would be better off not here. And I asked him to shoot me.
And you asked him to shoot you?
That's correct.
And what was his response?
I mean, I think at first he was a little surprised, but then he said, okay.
Did you tell him where you wanted him to shoot you?
Yes, sir.
Where did you tell him you wanted him to shoot you?
In the head.
And did you tell him how you were going to arrange that? What was going to be the logistics of that?
Yes, sir.
Go ahead.
I told him to follow me out, and that I would make a flat tire, and he would go past me and turn around and come back and do it.
And did he follow you out?
He did.
Now, where did you get the gun?
I gave it to him.
Where did you give it to him?
We had stopped somewhere on Salcahatchee Road, I believe.
Did y'all have a discussion there, or did you just give him the gun?
We didn't have much discussion.
When you say much, was there any discussion?
I'm not sure. I was worried about cars coming, and so it was a very fast thing.
You gave him, what kind of weapon did you give him?
A revolver pistol.
What caliber?
38.
Okay, and that was your gun?
Yes, sir.
Okay, and so he followed you out to where?
Salcahatchee Road.
Okay, and did you pull off the road?
Yes, sir.
And he pulled off the road, what did you do?
I stopped, made my tire flat.
How'd you make your tire flat?
With a knife.
Whose knife?
Mine.
What did you do with the knife after you made your tire flat?
Threw it.
Which tire?
Back driver's side.
Back driver's side. You threw it where?
Across the road.
Across the road?
Yes, sir.
Okay. Was there woods over there, a ditch, or do you know?
Just some grass, like thick grass.
Okay. And after you did that, he passed you, or did he pass you as you were doing that?
I think that he had already passed me and was in front of me and went down the road, turned around and come back.
Now, when he was coming back, you had given him a pistol, and what was your intent?
For him to kill me.
Okay. And when he came back, did he stop? Did he pull up? Do you know?
He did.
And when he pulled up, did you look in his face?
I don't think so.
So what happened next?
I stood close to his car.
And?
He shot me.
Where did he shoot you?
He missed and hit me in the very back of the head.
Okay. And as a result of being hit in the back of the head, did that have any physical effect on you?
It did.
What happened?
I lost my vision for a little bit, and I'm not sure if it knocked me to the ground or not, but I was disoriented, and it took me like a minute and a half, 2 minutes for my sight to come back.
And did you remember him driving off? Did you hear him drive off?
Not sure.
Okay, now after you came to your senses, did your vision come back?
It came back.
Okay, and what's the first time you remember somebody else being there?
I remember there were 2 cars that came, and one of them did a stop, and one of them did stop.
And the one that stopped, what did they do?
They tried to help me.
In what way?
In getting me to in every way that first we got in, they were crowded in their car. There was some reason why their car was crowded, and I'm not sure what that was. But so the young lady got in my car and was going to drive me to the hospital, and I just wasn't thinking about the flat tire. And so we had to get out of that, and then they worked it out somehow for me to be able to get in their car in the front passenger seat.
Okay, so, and you got in the front passenger seat. Where did they take you?
To meet the ambulance.
Now, were you on, did you call 911?
Yes, sir.
And you tell them somebody shot you?
Yes, sir.
Some shot you, right?
At my request.
So, your intent was to have him kill you so you could collect your life insurance, right?
So my son could. I mean, I knew I was about to lose everything, and I figured he's better off that way than dealing with me.
Now this gentleman that shot you, give me his name again.
Curtis Eddie Smith.
What kind of vehicle was he driving?
Gray truck.
Okay, and it's probably not relevant, but I'm intrigued by the fact, how long was it, have you ever discussed with him before killing you? Oh, you committed suicide?
No, sir.
How long did it transpire between the time you asked him to shoot you in the head on the side of the road and he actually shot you in the head on the side of the road?
When I first asked him, we were at the Sunoco station in Barnville.
And how long after that did he actually shoot you in the head?
However long it takes to drive from there to Talkahachie Road.
More than a half an hour?
I don't think so.
Did he ever ask you to reconsider? Or say, things aren't that bad? Did he ever, try to convince you to do otherwise?
No, sir.
You find that strange?
I didn't, I was focused on...
Focused on what?
Being gone.
Okay. So that's all the questions I have, but I tried to lay it out as expeditiously as possible. That he'll be happy to answer any other questions, any additional questions. Again, I'm not a interviewer, so y'all have at it. We've got about another 20 minutes.
Okay, thank you, sir.
Hey, let me ask you this: y'all recording this, aren't you?
Yes, sir, we are.
Okay, good. Just want to make sure.
Yeah. So, Alex, how long have you known Curtis Smith?
And Ryan, Officer Kelly, before we start, I just want to tell you, I apologize to you for lying at you in the hospital. I was in a very bad place.
No, so we understand. And I do appreciate you, helping us figure this out now. So that's in the past, so let's just focus on what we're doing now. How long have you known Curtis?
I've known him for years. I represented him. He knew my dad somehow from playing softball, and he came to my dad with a lawsuit, and I handled that case. So I would guess 10, 12
Okay.
years ago.
How often would y'all talk on the phone?
Very frequently.
Okay. And what would y'all talk about?
Getting pills.
Okay. And you would pay him money to get you pills, correct?
Yes, sir.
Okay. How often would you pay him?
frequently.
Okay, well, I mean, once a week, twice a week?
It would vary sometimes, but it was several times a week.
How would you pay him?
In cash, and mostly in checks, but in some cash too.
Okay, and what accounts would those checks come from?
The vast majority of them would come from the Bank of America account, but there would also be some funds that would come from the Palmetto State account.
And whose accounts are those?
Mine. The Bank of America accounts are in my name, and then there's another account there that I created that's a DBA, that's my name, DBA Forge, and then my checking account at Palmetto State Bank.
Okay, so there's two accounts at Bank of America?
Yes, sir.
The DBA and then your checking?
Yes, sir.
Okay. And what is the DBA?
Forge. F-O-R-G-E.
Thank you. Okay, and then the Palmetto is your, was the other checking account?
Yes, sir.
Okay, and who was he, so you were paying him the money. Do you know who he was getting the drugs from?
No, sir.
Al, what did he tell you? What did he tell you where he's getting it?
Oh, well, I was told that he got them from a black guy in Walterboro, and I was told that he had some connection in Beaufort, but I never...
Did he give you a name?
No, sir. I never saw those guys. I never dealt with those guys, so I don't know. That's what he told me.
Would you ever give anybody else money for drugs?
Yes, sir.
Who else did you give money?
I have given Kenny Hughes money.
Who's Kenny Hughes?
He's a guy that I called up and asked him if he knew anybody that he could pills from.
Mm-hmm.
And I told him I had a client that had issues and couldn't get them medically, and that, you know, and I would pay him as well, but I called him up and asked him to do it.
All right, how much money do you think you gave him?
I have no idea.
Okay, did you write him a check or pay him cash?
Both.
Okay. Did you pay anybody else?
No, sir.
So it was just Curtis Smith and Kenny Hughes?
Yes, sir.
Sure about that? Think about it.
In the past, I have paid other people.
Okay, who are those other people?
I had a lady that worked at our house that, at our mom's house that...
And who's that?
Barbara Mixon. But that was on a very, very few occasions.
And did you pay her a cash and check, or how'd you pay her?
I'm not sure.
Okay.
I mean, that was on very limited occasions.
Okay. Is there anybody else?
Not that I can think of right now.
Okay. So the .38 revolver, it was your revolver?
Yes, sir.
Okay. Where did you get that from?
It was at my mom's house.
When did you pick it up?
When I went up there that day.
Do you know where it is now?
No, sir.
So you gave the gun to Curtis, and you don't know what he did with it?
That's correct.
Has anybody in your family had any communications with Curtis recently?
I don't know why.
Well, because when we interviewed him, he said he had to talk to his attorney first, and he listed you. And then when we said that wasn't possible, he listed Randy. So we're just trying to figure out.
Randy's not going to represent him.
And let me say this, maybe.
Well, I got one more question. Does Randy have any knowledge of this?
Does Randy have any knowledge of what?
Of this attempted suicide / agreement with Curtis?
I have told I told both my brothers and my son
When?
very recently.
Yesterday, right?
When was it? Yesterday.
Yesterday. After we told him we're coming here so that he could tell you, he wanted them to hear from him first.
Okay, so Randy didn't have any knowledge last week, previously?
No.
Absolutely not. I lied to him too.
No, Alec told me yesterday about 4:15, and then I sort of tipped John Marvin off, and then later on I learned that, and I talked to Alec, and he had called Buster, John Marvin, and Randy after I spoke with him at 4 o'clock yesterday afternoon.
Okay.
Not we didn't do that. We're trying to.
And before that, I told them the same lies that I told you.
Now, here's an important thing. Since the shooting, have you talked to the shooter?
Yeah.
Okay, tell them about those calls.
I'm not sure. I was in the very beginning of my detox, and I can just see where I tried to call on the phone. And I know I talked to him, but I don't have it.
Did you call him or he called you?
I called him.
Okay, but you don't remember what he said.
I don't.
Do you remember what you told him?
No, sir.
And this is when you were in the hospital in Savannah?
No, this is when I was in detox here.
Okay, so you've called him since you went, because you went to detox.
Let me ask you this. Agent Kelly, has the investigation revealed, as you testified before, that the defendant, Alex Murdaugh, did call Eddie Smith, trying to use staff phones as well while he was at the hospital additionally in Savannah?
Yes, Mr. Murdaugh was able to contact Mr. Smith while staying at the hospital in Savannah. It's when? Monday night?
That's right.
Did you call him on a nurse's phone from the hospital? I heard that from.
But you know what? Randy did say I did that.
But you don't have a memory of that.
Randy said that I called him, and then he was asking me. He did say I did that.
Oh. But you don't remember calling Curtis.
I don't, but I will tell you from past experience that when withdrawals begin, you do just about anything to make them quit. And I probably was calling him for that purpose.
To get pills?
Probably.
All right, so you don't know where the gun is at?
No, sir.
But you last saw it in Curtis Smith's possession?
I gave it to him, yes, sir.
All right. So the accounts that you were writing the checks to Curtis were Bank of America and Palmetto State Bank?
Yes, sir.
All right, and the funds, where were those funds coming from?
Well, that's maybe an area we don't want to talk about, but just let's say the bulk of them were not legitimately obtained.
Okay, and I'm not trying to be coy. It's just that, Mr. Murdaugh is independently wealthy, so
not anymore.
Well, I understand that, but I think it's a pertinent question. So
look, he was independently wealthy, but there's a significant amount of money missing from clients in the law firm.
Okay. So the money came from ill-gotten gains? Is that what?
Some of it. Most, I would say the majority of it. But some of it, I'm sure I use my own personal funds too.
Okay.
I mean, I was buying so many.
All right, so just let me get this straight. So you entered into did you pay Curtis any money for this?
No, sir.
You didn't pay him anything, so you just asked of a favor and he did it?
Yes, sir.
Kill me. That's a great favor.
And so, and these checks that you were paying to Curtis, I mean, they were pretty significant, right?
Yes, sir.
But and when was the last time? I know. I mean, I'm not trying to get you to when was the last time you made a payment to Curtis? Was it before the shooting?
It would have been I mean, not like right before the shooting, but it would have been several days.
Okay. Did you remember how much you paid him?
No, sir. I think the last few times I paid him were all in check, and I was trying to, see him as little as possible.
All right. Now let me ask you this: do you owe money to any drug dealers?
No, sir.
So there's not a threat out there that we need to worry about for Buster?
No, sir. No, sir.
Okay, so the money that you were paying to Curtis to get money from his dealer or his supplier, you were paid in full in those payments. So there's no outstanding debt that we need to worry about.
No, sir.
Hey, Ryan, that's assuming that Curtis passed all the money along.
Well, no, I understand. I understand, and so to the best of your knowledge, you don't owe anybody.
No, sir.
Okay. So the money that you paid him, you don't remember how much you paid him, but it was for pills, and you're saying that you didn't pay him at all for him to shoot you.
That's correct.
Now, I'm going to be honest, that doesn't make any sense to me.
I understand.
And I know that, whether you did or you didn't, it really doesn't have that much of a difference. So I'm not going to, but I appreciate you're being forthcoming and you're making every attempt to be honest at this point. But so, I just want to make sure that we're all on the same page. So you did not make any financial payment to Curtis to have him shoot you?
No, I did not.
Okay, but you entered into a verbal agreement with him to set up a scheme where he would shoot you. It would be a suicide set up as a robbery homicide, and you doing so was in order for your son to get your life insurance policy.
I don't know about a robbery, but everything else is true.
Hold on. So let me say this to you. He's had this policy for 10 years. Suicide.
No, I've had a policy.
No, I understand that policies. I mean, what is the policy with? Where's it at?
I don't know where the actual policy is.
Okay. Did you intend to have that paperwork in the Mercedes, like the will and all that information? Was that left in there intentionally?
Well, I'd been down to meet with some lawyers about some things, and it was in there from that day before. I can't call her name now. My Buster's girlfriend's employers, Kathy Olivetti.
Yeah. And you're meeting with them about why did you have wills?
Just getting things cleaned up. I'd been down and met with him one time before,
and Ryan, there's a 2-year statutory ban on any suicide exclusion. In other words, if you have the policy more than 2 years, you can commit suicide and still collect.
Yep. Okay.
So that's not now what he thought. Really really doesn't matter, but he may have thought
Yeah.
that there had been a problem.
Okay. But you still entered into an agreement, basically, to have him kill you, so your son would then reap the insurance benefits. And
Yeah.
Okay.
Okay. You in? Alex, is that true?
Yes, sir.
Okay.
All right. So, how did you get the knife? Was it your knife?
Yeah, I think that Eddie gave it to me. Curtis Eddie Smith gave it to me.
Okay. And then how did you make the tire flat?
I just stuck it.
So you punctured the tire with the knife?
Yes, sir.
Okay, so Eddie gave you the knife. You took the knife and punctured the tire.
Correct.
And then what did you do with the knife?
Threw it.
Threw it where?
I believe across the road, but I'm not absolutely positive.
Okay, but you threw it. You disposed of it in the area of where the Mercedes was parked?
I think I threw it across the road from where it was parked.
Okay. Do you know if they disposed of the gun out there?
I do not know.
Okay. Was that gun registered to anybody?
Probably.
Probably to who?
Should have been. I believe that I purchased it, so I believe it would be registered to me.
Do you remember when you purchased it?
No, sir.
Where would you purchase it? Yeah.
I got no idea.
Okay. Ron, you don't have Curtis Eddie's phone number?
Sir?
You'd have Curtis Eddie's phone number.
If y'all have them, we'd love to get them.
Yeah. It will be my key.
Yeah, I got a cell number 843-908-1534 and a home number at 843-538-4691.
All right. Alex, did you ever have any dealings with anybody else besides Eddie? Any of his friends, family, girlfriend?
I mean, I knew who his girlfriend was, but I never had any dealings with her about Phil.
Who's his girlfriend?
A lady named Donna Eason. I don't know her very well, but I've just helped her with a couple of little legal issues over the years.
Okay.
But she never was involved in the exchange of pills or money.
Okay. Is there a property up in Hugie?
A property where?
In Hugie, up 41. Do you guys own any property up there?
Oh, yes, sir. And out of Charleston?
Yes.
Yes, sir.
Tell me about that.
There's a piece of property that I own with a bunch of other people that nobody else would pay, and so I've been paying for it, and he did some work up there digging some ditches.
When did he do that?
He started within the last couple of months.
And that property, where's it at in Hugie?
It's off of United Road, United Drive.
Okay.
I think it's called Redbeard and 0 United Drive.
Hey, Ron, we're going to have to jump here in just a minute.
Okay.
Shut it down here in just a minute.
All right. Alex, is there anything else that we're missing, that we're not asking you?
Like, in regards to what? Not that I can think of, but, like, what are you thinking?
I'll just kind of leave that open-ended. Like I said, I'm not trying to I'm not involved in the other aspects of whatever other investigations. We're keeping those separate. So you communicated with Curtis. You would communicate with him over cell phone?
Yeah.
Okay. How many phones do you have, Alex?
At the time. I had one phone. 1227 was my primary phone. And then,
I have to download that phone, Ryan. You know, when SLED started focusing on Alex, said he's a target, we started doing our own work. So I took possession of that and sent it to a guy to download, and he had to get a separate phone, and that was that other number. And then y'all seized both of those, that's my understanding.
All right, and then he's got a third phone that he got prior to going to the treatment center.
Yeah, from Walmart, burner phone.
Okay. What is his extended? What's your expected length of treatment there in Alpharetta?
well, it's unclear right now, but he'll go from here into rehab at some point. We'll keep you posted.
Okay. So anytime you're, obviously this is, so you've identified Curtis Smith as the individual who shot you. And y'all entered into an agreement, so y'all kind of were hand in hand in this.
Very much so.
And he never tried to talk you out of it?
I don't know. No, sir. I don't think he did.
Okay. Did anybody know about this plan besides you and Curtis?
No.
Okay. All right.
And if you're all about done, let me put this on the record. Alex, did you tell us the truth? I just want to make sure Ryan understands him and leading him on a very. No, I did not tell anybody the truth until. Was it yesterday? Yep. Until yesterday afternoon.
Okay.
I've been really, really sick, and it's really the first day where I had any coherent thought process. And I sincerely apologize again for lying to y'all about everything that I did.
Yes, sir. And you have no idea where the gun is?
I do not.
Alex, you're right-handed, right?
I'm right-handed.
Okay, and you did not shoot yourself, correct?
I did not shoot myself.
Did you? Were there? And what was the plan for Curtis to follow you out there, and you would immobilize your vehicle? So did he stop to make it fly for you to give you the knife first? I mean, how did that play? Because you got the knife from Curtis. When did you get the knife from? When did you get the knife from him?
I think I got it from him when I gave him the gun.
Okay, over when you were at the Sunoco?
No, we didn't do it then. That's when.
Okay, when you pulled off the side of the road in Salcahatchee?
Shortly after we made the turn onto Salcahatchee, we stopped and did a quick exchange.
Okay, so you stopped, pulled over the side of the road, stuck the tire. Where was Curtis at when you were disabling the tire?
I believe he was going past me.
Okay, so he turned around, and where were you at when he turned around?
I'm not sure. I mean, I would have been on the side of the road, I think.
Okay, so did you pull up, kind of like what you said, just past your car?
That's basically the way I told you it happened is kind of how it happened, except it was arranged by me.
Okay, so as you turned around and turned your back to him, about how far do you think you were from the car?
I don't know, 4 or 5 feet.
Okay, 4 or 5 feet. And did you just stand there and wait for him to shoot you?
Yes, sir.
Okay. And how he just? I'm assuming he just fired once,
Yes, sir.
and then you fell to the ground, or stumbled off.
I'm still not positive about that part, but I did lose my vision for about a minute and a half to 2 minutes.
Okay. And why didn't you? Why weren't you truthful with us when this initially happened?
I don't have a good reason. I was in a bad place.
Okay. All right, gentlemen. Well, I know our time's cut short, but
And Ryan, I'll call you from the car once we get out of here in just a couple minutes, and then I'll call you while we're driving back to the airport.
Okay. Yes, sir.
Okay.
All right, gentlemen. So let's see. We'll finish this. We are finishing the recording with Richard Alex Murdaugh, his attorneys Dick Harpootlian and Jim Griffith, and Special Agent Ryan Kelly, Special Agent Joe Alday. It is now 4:58 on Monday, September 13th. Thank you all, gentlemen.
Thank you.
Thank you, sir.
Special Agent Kelly, is that the complete conversation that you had with Alex Murdaugh on September 13th, 2021?
Yes, it is.
Prior to that conversation, over the course of the 911 call, the ambulance, and multiple interviews at the hospital, did Alex Murdaugh ever mention or identify Curtis Edward Smith at all until his lies about the side of the road were exposed?
No.
Did Alex Murdaugh ever say that there was any risk or threat to Buster?
He said no. No, he did not. He actually denied it when we asked.
Did Alex Murdaugh say that Curtis Eddie Smith had anything to do with the murders of Moselle?
He denied it when we asked.
And is there any evidence that Curtis Edward Smith had anything to do with Moselle?
None whatsoever.
Thank you. Nothing further.
Mr. Harpootlian.
Your Honor, I understand we have a 4:30 cutoff. You just want me to go as far as I can go?
Or we can adjourn now for the day.
I think I don't. This is going to take a while, and I would suggest perhaps maybe one adjourn.
Okay, ladies and gentlemen, we are going to adjourn till 9:30 tomorrow morning. Let's have order for speaking to the jury. We're going to adjourn until 9:30 tomorrow morning. Have a good evening. Please do not discuss the case. Please do not discuss your testimony with anyone overnight. You'll be cross-examined tomorrow morning.
Yes, sir.
And we will be in recess.
Thank you, Your Honor. All right.
An argument that the state was using when it asked for its introduction. If there is a conviction here, do you think that this is going to be a problem on appeal in terms of a reversal?
I do, because look, I mean, at the end of the day, it's not so much the state's theory that's going to be the problem, which, in order for their theory to work, they had to get that 404B stuff in, because otherwise there's no way for them to create the nexus with the murders, and a motive, like why did he do it? So in terms of the state, but, I think the issue is going to be with the judge, who, quite frankly, I think has done an admirable job throughout the course of the trial. He really has control of the courtroom. I think that he reads the law. I'm sure you and I have both been in front of judges where that's not always the case. And I believe that the judge has really had kind of a pretty firm grasp of all the issues. And this is kind of a lawyer's case. You know what I mean? Like, you and I sit here and watch it much differently than lay people that may not necessarily understand all the intricacies of the law, but there is so much going on here. And I think that 404B is going to come back and potentially haunt them, because it became essentially two trials within one. We have the financial crimes trial, and then we have the issue of, the underlying homicides. And, the question of whether or not they're going to lose the jury is an entirely different question. But whether or not they went too far afoot with the financials, it's definitely going to be an issue for appeal, as is the fact that we now have this opening of the door where, in my estimation, I think that when the judge ruled yesterday morning in favor of the defense, that, as he thought about it during the course of the day and kind of saw how it was playing out and realized that he had left the jury with this half notion, which all of us know as observers that isn't true. Like, we all know that Alex Murdaugh, that this was a plot, that the roadside shooting was a plot in order to have himself killed in order to collect on the money. We don't know whether or not the jury, who I'm assuming because they live in that county, probably know, but as an observer, I don't know if they do know. Yeah. So I'm going to assume, we all hope for a blank slate jury, when we pick one. So let's assume that that's true, that they don't know. So the judge had to be thinking, man, I've left the situation in terms of ruling on that motion in limine this morning in favor of the defense, where I'm not going to let the roadside shooting evidence in, no more of it in, at least, with the jury left with the impression that, oh my God, a third party actually did try to kill Alex Murdaugh, which really was a huge boon for the defense, So that's going to be an appellate issue without question with respect to ineffective assistance counsel, in my opinion.
Yeah, that's a really hard, that ineffective assistance to counsel argument. We oftentimes, the audience doesn't understand. Those are really hard issues to win on appeal, in my opinion. But that 404 is one judges are extremely careful to make sure it's not a trial within a trial and there's not character assassination occurring. That is more frequently the reason that cases get reversed. That's why I always say, as a prosecutor, for those prosecutors that are out there, just because you can doesn't mean you should. We'll be right back. All right, welcome back. Court has ended for the day, so let's check in with our own South Carolina local and law and crime correspondent, Gigi McKelvey. Gigi, you watching all of this, you're doing a great job. I love listening to your commentary, even when I'm not hosting the show. So talk to me, what's the skinny and word behind the scenes with people about this opening of the door to this testimony about the attempt to have himself murdered for the purposes of insurance proceeds? What's everybody saying? Is it a plan, or was this just a colossal mistake?
Well, thank you for the kind words. First off, I don't know. I mean, look, the jurors were not into this recording. They looked bored. And look, it doesn't take a rocket scientist to know that Alex Murdaugh is a liar, and he sets things up when things get stressful. So it's like beating a dead horse at this point. But, you know, yesterday I really thought it was very directed, that they did this on purpose, and then maybe had a little buyer's remorse this morning when they woke up, because then they argued about not letting too much in. But, you know, the entire afternoon session after lunch has been about this roadside shooting, which really to me has nothing to do with these murders. I think it's getting away from the focus. The state was supposed to finish up today, so I guess not.
Well, Gigi, let me throw out there, now this is my homicide prosecutor experience, what I would be concerned about that the jury could be influenced by, because I'm always thinking about what will the defense be saying in summation. And I can imagine a defense attorney saying, whether they wanted this evidence in or not, that you would have to believe, first of all, this motive by the state where he was to receive no financial benefit, just to kind of slow things down. And then he decides to have himself killed so his other son could get the insurance proceeds. He loves his family that way. There was no acrimony with Paul. There was no acrimony of any real nature with his wife. So as a person who's been willing to have himself killed so his son could get money, the kind of guy that would kill his other son and wife?
Yeah, I mean, it doesn't really follow that narrative. You know, maybe it's an attempt to look better in light of everything going on. I think at this point that a lot of people were chatting about maybe it was him that had something to do with it. But, you know, I mean, he's been known to try to elicit sympathy with different things. So I think the biggest moment where everybody was surprised was when on that interview, he talked about one of his mom's caregivers. Actually, he said maybe a couple of times, but providing him with some of the narcotic, but overall, I don't think anybody was really even interested in this, to be honest.
Yeah. You noted that before. So, you know, we all do that, right? We read the tea leaves, we watch the jury to see how they're reacting, and it's interesting, they weren't reacting to this, but what was something, the last thing, the biggest thing that you could think of that they did react to that you think may have either favored the defense or the prosecution?
I think the biggest reaction today was the demonstration of the position of the shooter with Maggie, because you've got Mr. Waters down on his knees, and he's using this, the witness is using this dowel and holding it as if he's holding a rifle. And that was a visual where you see a couple of the jurors, it kind of, you can almost imagine they're picturing it in their own mind how it happened. And so for me today, watching the jury, as I do pretty much all day, that was kind of the moment where you could see the gears turn and they're kind of thinking about, wow, I mean, we've heard all this technical testimony, but to show a visual like that, I think that was really kind of a big win for the prosecution.
Excellent. Okay, well, thank you, Gigi. Again, doing a great job. We will be back with you later, I'm sure. And since court is on break, let's take earlier today a look at some of the testimony of Ryan Kelly, who presented Alex Murdaugh's 9/11 call from the day of his roadside shooting. My guest and I will discuss this on the other side. Again, keeping in mind, if you're just coming on here, this was testimony that the court had previously said could not come in by prosecutors, but yesterday an argument was made that defense attorneys opened the door. That is, said questions that left now a big question for the jury, and the prosecutors argued, Judge, now it should come in because of what the defense did, and the judge agreed. Let's take a listen.
Can you generally describe what was reported by the defendant on 911?
Yes. Mr. Murdaugh called 911. The Hampton County 911 operator answered the phone, obviously asked, what's your emergency? Mr. Murdaugh said that he was on Salcahatchee Road by a church with a red roof. When she asked what had happened, He said that he had been driving on Old Salkatchie Road, suffered a flat, and when he pulled over, another motorist arrived on scene to render assistance, and he said that when he turned around, the motorist shot him. So at that point, the dispatcher asked, "Have you been shot?" And then that's at that point where Mr. Murdaugh said yes, he'd been shot, but then he said he was okay.
All right. And did he say that he got a flat tire, he stopped, and then someone stopped to help and then shot him?
Yes.
Traffic at 911, what's your emergency? On Salkatchie Road. Okay, what's the address on Salkatchie Road? I'm by the church. What church? What church are you talking about? I don't know the name of it with the red roof. Okay, what end of Salkatchie Road? Because I don't know what you're talking about. At the Hampton County side. Okay, what's going on? I got a flat tire, and I stopped, and somebody stopped to help me. And when I turned my back, they tried to shoot me. Oh, okay. Were you shot? Yes, but I'm okay. You shot where? Where were you shot at? Huh? Did they actually shoot you or they tried to shoot you? They shot me, but... okay, wait, you need EMS? Well, I mean, yes, I can't drive. Okay. And I'm bleeding a lot. What part of your body? I'm not sure. It's somewhere on my head. Your head? Somebody just stopped for me, ma'am. For 911. Okay. Still? Hey. Okay, let me speak to him, see if he can tell me exactly where you are.
Adante Pointer, who is a civil rights attorney, joins us again on the show. Great to have you, Adante. Let me ask you thoughts about the opening of the door for this testimony, and something that just struck me when I'm listening to these 911 calls is that if this was a plan to kill him for insurance proceeds, how come he's not dead?
Right. You know, that's what was going on in my mind, frankly, as I'm listening to this. I'm saying, so we want us to believe this guy put together this plot to kill himself in order to essentially give millions of dollars, $10 million to his surviving son. But then this is the same person, when it didn't happen, he calls in, reports it. Doesn't sound like he's in a lot of distress there. Sounds disoriented, maybe off the opioids that they claim that he's buying. But at the end of the day, it didn't work for him. And then you're going to go to the ultimate level, which is to kill your wife and your son. While I get the impression is that this is a person who's desperate, if you're willing to sacrifice yourself, I don't see you going to then sacrifice your wife and son. So I think this is going to perhaps cut against the prosecution, but at the same time, it does not leave a good taste in our mouth for Mr. Murdaugh.
Adante, because you're just joining us, I want to ask you one more question as a follow-through. Like, my experience as a prosecutor always was that even though I always played things very close to the vest and never was reversed on a conviction, sometimes prosecutors feel that they have a weak case, so they kind of try to expand the level of evidence that they're going to get in there. And I'm specifically referring to the 404 evidence. Sorry to the audience out there that I keep harping on this, but this is such an important rule. 404 is a rule of exclusion. 404 is a rule of exclusion. It says you cannot do this unless, and then in a very narrow and tailored reasons. Do you see the government's introduction of this and then asking after each of those witnesses, as I recall, the ultimate character assassination evidence, like how did this make you feel on the law firm and did you feel betrayed? That's completely outside the scope of 404 and completely character assassination. I'm surprised that there wasn't a huge argument about that. Do you think the defense is kind of looking at it like, one, I don't think the jury's going to buy the motive, but two, the prosecutor opened for us by the way they presented the evidence, a great appellate issues. Thoughts?
I think it's certainly they've opened the door, they've opened the gate, they've dropped the drawbridge, and the defense is going to walk right on in there to appeal land. You know, you should not be doing that. And I think it is a sign of weakness. At least if I'm a defense attorney sitting on the other side, I'm definitely making us think about it. And at the same time, once that moment is done and they continue to do it, I'm going to sit there, I'm going to object, but I'm going to let them continue to do it. Because I think to myself, at the end of the day, I'll be able to come back to this and perhaps, get whatever takes place during this jury and the verdict reversed.
Right.
So I think that is a bridge too far for the prosecution.
Right. The more you pound it in, the more you character assassinate, the less probative and the more prejudicial it becomes. That's how the appellate courts look at it. Bob, overall, do you think that just talk to me about the pragmatics, the physics of a case. He's got all these indictments, all these charges, all this financial crime. And in the end, prosecutors and defense attorneys have to try to find a way to either work the case out or not. What are the physics of this case? In other words, if they get a guilty verdict, are they going to work the other cases out? Are they going to go full boat on all of it in case there's a reversal of the murder verdict? Is it just everybody saying no plea offers here, we're just going pedal to the metal on both sides? What do you, because we all think about this before we wind up walking into a courtroom and trying a case. What do you think?
100%. I mean, you're always trying to make a global settlement when you've got multiple crimes, with the same defendant. I mean, you don't want to go to trial on multiple things, even if they're not related per se. You certainly want to be able to work with the state if you have a situation where they seem to have an ironclad case on the financials. And I think that the position for Alex Murdaugh was, I didn't do this with respect to the murders of his wife and his son. So I don't think that the global settlement per se or global plea deal was ever going to be on the table. I think that, how it's going to work out in the end. And to go back to that concept, I've been a criminal defense attorney for a long time. That bridge to appeal land is a one-way street, man. It is very difficult to win on appeal. It is very difficult to get a case reversed and thrown back into trial. So that's a weak strategy if that's what the defense's strategy is. I'm hoping that it isn't, and I say that just based on experience.
Well, yeah, but Bob, let me push back a little bit on that. The defense did object to it. The judge did let it in. It's the manner in which they put it in, not to mention the fact that you are right, getting a reversal on appeal is difficult, but there are certain areas that courts are more heightened. For example, improper comments and summation, commenting on a defendant's right to remain silent, the inappropriate introduction of 404 evidence, are areas the courts greatly look at here. And it's not so much the judge ruling, in my opinion, about letting it in, which I think is on the line. It's the way the prosecutor put it in, because he directly associated with him being a bad guy. And that's exactly what you're not supposed to do. I'll let you finish.
Yeah, no, I agree with you there. I think that Harpootlian may have tipped his hand a little bit. That I'm with you. I was surprised that there weren't objections when that kind of testimony was coming out as it was happening. And I think when the judge had mentioned this morning something to the effect of, that you've been objecting the entire trial, and Harpootlian said, well, there's a few that we missed, and I'd be willing to have you rule on them now, though. I have to feel that he was talking exactly about that. That's true, but is it going to be enough for an appellate court to look at it and say, look, would that have swayed the jury? Was it enough to sway them, from the verdict that they landed on? And I don't know. I mean, it's such a risk in terms of it can't be the approach that let's just try to pile up appellate issues in order to try to, create a good way to retry this case. Because you and I both know an appellate reversal means that he goes back to trial. It doesn't mean that he walks on the counts, So, what are they? Their premise is going to be let's retry it and maybe we can do right what we did wrong on the first case. So, and in terms of the financial crimes, I don't know what they're going to do with it. If he's found guilty on this and the appeals fail, which as well as I do, will take a decade or more, as they work their way up, unless he wins at the first level, which I doubt. Then they have the issue of what do we do with the financial crimes? At that point, you're a former prosecutor. Do you care?
No, it's all about the practical and analysis here. And I think both of you gentlemen can agree to nod with me as we go into break that when a lawyer, just so the audience knows, when a lawyer goes down for stealing client funds, those judges aggravate those sentences. In other words, they give them the maximum numbers. I know people that are doing exorbitant jail sentences for a heck of a lot less than what Alex Murdaugh is accused of doing. So, guys, great commentary. Appreciate it. We do have to take a break. We'll be back on the other end. Please stay with us.
Could maybe point out what was added to this image to kind of reflect your conclusion in that regard.
Thank you.
And there's a dowel stick right behind you if you want to use that.
Okay, as you see here, those are the digital legs that I placed there showing Paul's approximate position as he was standing when he had the first gunshot wound. Here along the floor, what you see are passive or 90-degree blood droplets. And when blood, you can tell a lot from the direction of blood by the way it strikes an object. Blood has a cohesive factor. It's viscous, and you probably heard that term before with the motor oil for your car. It's thicker than water. And the thing that causes that blood droplet to change shape is the friction and the direction and how much force was used. Well, a 90-degree drop just is exactly that. It's perpendicular to the ground. So these 90-degree drops right here tell me that Paul was standing there for a moment. Can't tell you how long, but those drops were running down from that wound on his arm, more than likely his arm, because his chest area had a shirt on it. It takes a little while for that blood to make it through the shirt, but it'll run down the outside of your arm and drip off your fingers. And you can see these 90-degree droplets here, here, and then they actually lead to the door. You can follow the path to the door. He's not moving very fast because most of them are almost perfectly circular or 90 degrees. Had he been moving real fast, you could see some directionality in him. A tail, because the tail always tells you the direction with a blood drop. So I know he was moving slowly, and I know he was standing in the middle of this room for some time after the first shotgun wound.
All right, and approximately how far was Paul inside the feed room? Can you describe a little bit about the dimensions of the feed room and your conclusion as to how far within the room Paul was when he was struck by that first blast?
Yes, sir. Well, the feed room is 10 foot deep by my own calculations and by looking at the other sketches. And where you see his feet here is just on the other side of the halfway point. So I went, I'm guessing because I have no way of running a tape measure because when I went there, everything was moved. But this door is 36 inches and it's approximately 1.5 feet, 2 foot past the door. So that's how I come up with that determination. And he's just on the other side of the midpoint of that 10-foot room.
Which is about how far from the doorway?
5 foot.
All right. Did you come to any conclusion about the location of the shooter when that first buckshot blast struck Paul in his chest?
It would be hard to say exact, but I can say to a bare minimum the breech of the shotgun, because I don't have the shotgun. I don't know the length of the barrel, that kind of thing, or I could run it from the door. But the breech of the shotgun, where it ejects the shot shell casing after it fires, was somewhere inside the door. Because had it been on the other side of the door, the shot shell would have been located outside. So depending on the length of the shotgun, at least I can say the ejection port was inside the door of the shed.
All right. And then the shooter, I have this image up here, which I apologize, states 534. And can you kind of illustrate what you're talking about to the jury using that image?
Yes, sir. The breech, the ejection port, where you load and unload that shotgun, which is a little less than midpoint from the shooter, was inside this door frame, at least to some degree inside.
Right. And where were the expended shot shells found on this crime scene?
According to the photographs and the original crime scene, behind this door.
And is that consistent with your review of the evidence? Does that support your review of the evidence that you just, that conclusion you just related to the jury?
Very easily. If you look, this room is kind of cluttered, and I measured that door myself. It had been pressure washed, but the same door, found the same shot shell pellet defects in that door. 1.5 inches at the bottom of the door, that's plenty of room for a shot shell to bounce and roll under the door. So I have no reason to believe it didn't end up there because of the location of the shooting.
generally describe again to the jury your conclusion as to that second injury suffered by Paul, the fatal shot as you've described it.
Well, the first thing is, once Paul received that second shot, he never walked again. He never made any movement. Any movement he made was involuntary, and it was due to gravity, pulling his body down to the ground. When you sustain an injury to your brain like that, that ceases all movement. So he was found outside the feed door. He fell over forward after sustaining that movement. Some wounds are fatal later. You can actually see someone that receives a fatal wound, and I've seen them run 100 yards. They can move for a little while. This is not that type of wound. Once he received this wound, it ceased all movement.
All right, Bob Murdaugh is with us, criminal defense lawyer, host of a Defense Diaries podcast. Bob, every state does it differently, but I wish as a homicide prosecutor I was allowed to have a witness get on there, talk about not really having an exact list. I don't know how long the gun is. I don't know the ejection. He's talking about how people die, which is like an ME thing. He says the word guessing. I really thought that this guy was able to get a lot of information out that I'm not sure is qualifies as an expert testimony. It seems to be a shotgun approach, if you will, on every aspect of the case. I'm not sure how scientific it is. Your thoughts?
I agree. I thought that the testimony was haphazard in terms of kind of veering out of his lane. You know, he had a very specific lane that he was there to testify about, and they kept on direct kept asking him things that were not in his domain in terms of what he was an expert about. So I agree. And of course, again, there weren't the objections. You know, and if people out there don't understand that if you don't object at trial, that issue is waived for appeal. There is no going back and curing that issue. So, you know, frankly, I was surprised, and I agree with you completely. I thought that there was a lot of guessing for a guy that's supposed to be an expert, and guessing on things that he's not an expert about. So, yeah, I'm in complete agreement with you there.
Yeah, and I mean, maybe they had objected to it prior to pretrial ruling, but your point on if it hasn't been objected to, a different standard of review is true in the appellate courts. Adante Pointer is a civil rights attorney. Adante, what are your thoughts about that? And I mean, I've had judges limit me on how the cause and manner of death occurred with a pathologist who's using exact science and methodology. The word guess should never come into an expert's lexicon. Thoughts?
You're exactly right. And, you know, the expert is supposed to have expertise. It's supposed to be very accurate, precise, and the judge serves as a gatekeeper. The judge is supposed to make sure that people who get on the stand, that they're testifying, especially someone who's a so-called expert, is testifying within their wheelhouse, their subject matter expertise. This guy appeared to be all over the place. He's a human biometrics expert. He's dealing with the gunshots, the trajectories, the way in which the body responds. He appears to be an jack of all trades. I'm not sure how that's going to play with a jury, but certainly as a defense, when I get up to cross-examine someone like that, I'm going to bring that out. What is your training in this subject? What do you have? What do you relate this to? What treaties and what authorities are you relying upon for your opinion? Or are you just here paid to give an opinion on behalf of the prosecution?
Yeah, I was particularly, I mean, like an expert testimony has a special knowledge or that's beyond the ken of the average juror. That's why they're allowed in there. But when I listen to the ejection of the shell casings, I've had cases where shell casings have hit things, bounced across a room. I don't know. I thought it was kind of odd. Anyway, guys, great commentary. Appreciate it. We got a lot more with these two and more of a review of this case when we come back from the break. Please stay with us. right, welcome back to Law and Crime. So that is it for today. Very interesting testimony. Let's take a look at earlier today when Dr. Kenneth Kensley talks about his observation on how Maggie Murdaugh was shot. Let's take a look.
Remind us again of those injuries, and if you could go ahead and describe them in the order that your expert opinion they were suffered.
Yes, sir. Miss Maggie Murdaugh suffered 3 non-fatal injuries from a firearm. One was through her wrist. One was her left upper thigh above the knee. One was at her abdomen here, and it exited somewhere around her kidneys. Now, I'm not that kind of doctor. I can't tell you all the damage it did inside, all those organs and things, but it ran a straight line through her body. This one on her left leg and this one on her midsection were approximately the same angle, and they were really, really close in distance. One had stippling that said that it was a foot closer than the other, but that would probably fit. This was either a total separate non-fatal wound, or it could have been a continuation of one of the 2 fatal wounds. Her fatal wounds were, she had an abrasion or a burn on the left side of her abdomen from the outside in. That bullet followed a straight path. It entered the end of her breast and did extensive damage to the end of her breast, entered her left jaw, side of her face area, and went into her brain. That's the first fatal injury. And it was immediate, and she dropped right where she was at. I saw no evidence that her body had been manipulated, moved, or rolled over. The second fatal injury was down into her head, and it actually did what in the day they call a keyhole injury just from appearances. The entrance and exit in the top of her head were so close it made one big injury, and then it entered into her upper shoulders and went down into her body. That would have also been a fatal wound, but it was second. In my opinion, that one came second. The shooter was right here, approximately right here.
All right. And show us the trajectory as it went through Maggie into her brain.
Yes. It burned or grazed her stomach outside to inside, went through the end of her breast, into her jaw, and then into her brain.
Okay. And what would have been the effect on her once that shot was suffered?
She would have immediately fell down with the front of her body.
All right.
And that is the position her arms were in the original crime scene photograph.
And while I'm down here so I don't have to get up again, tell me about the fatal shot and the positioning of the shooter as the evidence indicates to you.
The second shot was not as close, but it still wasn't a long distance. It was approximately here into the crown of the head.
And use the dowel stick to show that injury that Maggie suffered.
In, out, in that line.
Okay, Dante, we were just talking about before we were in a break that, I had investigators once telling me about how a murder-suicide occurred and they had the pointer and the stick, and I'm like, yeah, get a shotgun out and let me see you demonstrate that, which they couldn't do with the shotgun. I can't even believe this. Could have been, may have been, the stippling, this, that, first fatal wound, the second fatal wound. I've only heard of one fatal wound. I just don't understand how this testimony is being admitted. I think it's so prejudicial, but you tell me. I don't know. What am I missing?
I don't think you're missing anything other than we're missing what makes this particular witness credible. That's what we're missing. And I think if the jury is paying attention, I understand he has a folksy charm, but at the end of the day, you're supposed to be a doctor. You're supposed to be talking about things to a medical certainty. And I don't see it here. What I see here is someone who is trying to explain things away. But for me as a person, just like us as attorneys, I'm thinking, where's your chart? Where's your diagram? Where are your illustrations? Where is your computer program to make this easier for a jury to digest and believe? He just doesn't have it. I don't think he has much credibility.
Bob, that is a great point that Adante is making. There are so many things that you can do to demonstrably show to a jury with so much greater accuracy, science, measurements, things of that nature. Do you think the defense is going to make something of that, or the jury may sit there and say, this is what we get, people laying on the ground with a pointer?
Yeah, I mean, he's got the stick. Are you saying the stick's not enough? Yeah, no, I mean, in terms of demonstrative evidence, and granted, we can't see the charts that they're using because of whatever the judge's ruling was earlier on, but it looks like that he's just pointing at a diagram. So I'm assuming the defense will probably put some more demonstrative evidence on, but the fact of the matter is, you guys are both trial attorneys. Expert don't win cases ever.
Yeah, for sure. I mean, that's true. You just reminded me of something, so I'm going to kind of lift your thought. It could be a defense closing. If you have to use a stick, you must acquit. I don't know. Just a thought. Guys, thank you very much. Great job. That's it for us. Please stay tuned for our regularly scheduled program. I'll be back next week. You be well.